My name is Martin Small, and I am the inspector appointed by the Secretary of State to conduct this hearing to determine the appeal by TG Designer Homes. This appeal results from the failure of Ashford Borough Council to give notice within the prescribed period of a decision on an application for full planning permission. The proposal is described as the erection of 33 dwellings consisting of a variety of terraced housing, detached and semi-detached properties. The proposals include the creation of green space, a communal green and landscape areas with views over the existing woodland. The residential development will also include refuse and recycling facilities, cycle storage and private visitor parking allocation. The site address is to the land to the east of Calleywell Lane, Aldington. And I'll just check again, can everybody hear what I'm saying? Good?
Yes, thank you.
Thank you. Yeah. Lovely, thank you. When you are not involved in discussion, could you please mute your microphone to avoid background noise? I would prefer the parties to keep the cameras on during the discussion, but please, of course, turn your microphone back on when you wish to speak. This would be a good time to switch phones, mobile phones off or to silent, please. The hearing today will be a structured discussion which I shall lead based on an agreed agenda which has been issued ahead of this event. Does everybody have a copy of the agenda that I sent around in the pre-hearing note? Thank you. I do want to add two matters, which I will explain in a minute. And the purpose of the hearing is to enable all of you to put forward your points of view and to help me get the information I need to make my decision. During the discussion, I will invite contributions from one side and then the other, and also from interested persons. Please answer my questions as clearly and concisely as you can. There will be no formal presentation of cases or cross-examination. Please note that I have read all the written statements, so there's no need to repeat material, although you can draw my attention to something specific, and this is important to make sure we make good progress. However, if you do want to make a point or feel I'm moving on before you have said all you want to, do please let me know. I'm particularly concerned to make sure that everyone remains engaged, as it can be more demanding communicating via video link than in person. But therefore, I intend to sit no more than around an hour and a half at a time with breaks in between. If anyone needs or feels that an adjournment would be useful at any other time, do please let me know. For short breaks, I will turn off my camera and microphone. If you wish, you should be able to stay in the virtual meeting room. However, do please mute your microphone and turn off your camera if you wish to discuss detailed matters with others, as you remain audible and visible to myself and the other participants if you do not do so. If you do not finish before lunch, we will adjourn. I will leave my office completely so I cannot hear or see anything. Please remember to allow me to leave the meeting before you do, and I aim to finish by 5 p.m, if not earlier. If at any point you cannot hear or have a question or wish to speak, please raise your hand, or please use the hand function on the toolbar. If you use the hand function, please remember to lower it again when you have finished. Unlike in the physical event, during the hearing you can only see my head and shoulders, and reading body language is harder than in person. So I may be looking down, taking notes, or to my side. I also have a separate screen behind my tablet, so I may be looking at something on that. I might be reaching for some plans to my right. This does not mean that I'm not listening to you. Similarly, if I'm watching you speak, I'm likely to be looking at the image of you rather than directly into the camera. If anyone suffers any IT problems and loses their connection to the hearing, I will briefly adjourn. You should log straight back in the same way as you did initially. In the unlikely event of a major disruption, or if it becomes obvious that it is not possible to proceed as a digital event, I will adjourn the hearing. The case officer will then be in contact as soon as possible to explain the situation, how I proceed. But for now, let's travel hopefully. Does anyone have any questions or concerns about the technology or general management of today's event? Yeah, I see a hand raised. Mr. Hume?
Hello. Yeah, thank you very much for letting me speak. I'm a villager living in Calleywell Lane. I'm working today, and I'm unable, unfortunately, to be here for the whole time. However, I'm desperate to be able to be part of this. And so I was hopeful that you might be able to direct me as to when the best time would be for me to make some comments, and I'll work around my diary to make sure that that's prioritised. I hope that's okay.
Thank you for that. The structure of the hearing is set out in the agenda. So there's no kind of set slot for interested parties to say their piece. You're welcome to contribute at any point during the proceedings. If there are things that you want to say and you haven't had the opportunity to do so before you need to leave to go to work, then do let me know. You can say those. Your disadvantage, I think, is that you'll then miss parts of the discussion. But if you have an opportunity to say what you want to say before you need to leave us, then I think you've had an opportunity then. Does that sound reasonable? So are you flexible in any time when you need to do some work, or you do need to leave at a set time?
So I've booked out 10 till 11 as an example, but if, for example, that wasn't possible to be able to make some comments at that point, I could rearrange or reprioritise my day in some form. However, I obviously do have meetings that I've desperately tried to get out of today, but I'm unable to do at last minute, as I'm sure everyone can acknowledge. So I could speak any time within the next 50 minutes, or I could speak at allocated time later if someone was to nudge me and I'd come out.
All right. Well, let's see how we are coming up to 11 o'clock.
Thank you.
Okay. Right. No other questions? Right. During the discussion, I will invite contributions from one side and then the other, and also from interested persons. Again, please answer my questions as clearly and concisely as you can. No, I think I read that, didn't I? Yes, I wanted to say, please try to avoid, for the main parties and for myself, try to avoid planning jargon as far as possible. But it's something you said that somebody doesn't understand, do please ask for clarification. Before we start the discussion, there are a few formalities I need to complete. I'd like to take the names of all those who wish to speak and their interest in the case. So for the appellant, please.
Thank you, sir. We have several members of the project team here round the table. Myself, I'm Emma Hawkes. I'm Associate Director at DHA Planning, and I'm the planning consultant for the project.
Hello, sir. My name is Tim Hare. I'm a Director of Taylor Hare Architects.
Sorry, I didn't catch the name.
Tim Hare.
Oh, yes, thank you.
Thank you. Director of Taylor Hare Architects.
Yep.
So I'm Anthony Ralph, the developer at TG Designer Homes.
Mr. Rouse, was it?
It's Ralph, R-A-L-P-H.
Thank you.
Thank you.
Thank you.
I'm Matthew Woodhead. I'm a Director of DHA Planning, one of Emma's colleagues in the applicant team.
Thank you.
I'm Tim Allen, EN, Director of Kent Archaeological Projects.
Thank you very much.
Morning, sir. I'm Eleanor Trenfield, Landscape Architect and Director of EPLA.
Sorry, could you just repeat your surname for me, please?
Trenfield.
Sorry, could you spell it?
Yes, T-R-E-N.
Yep.
F-I-E-L-D.
Lovely, thank you. And sorry, and you were from?
EPLA, E-T, Eleanor
Yes.
Trenfield,
Yeah.
Landscape Architects.
Yeah, thank you. Yeah, lovely, thank you. Can I ask Emma Hawkes and yourself how you would prefer me to address you if I'm asking you to comment?
Given it's International Women's Day, I choose Ms, please. M.S.
Right.
Thank you.
And I will do the same, sir. Ms.
Okay.
Hawkes, please.
Okay, right. Thank you very much. Okay, that's from the appellant. From the council, please.
Good morning.
Morning.
I'm Alda Song. I'm a planning officer at Ashford Borough Council.
And how would you like me to address you?
Ms. would be perfect. Thank you.
Thank you. Are you by yourself, or do you have other?
No, I have a few colleagues. We have Miss Laura O'Brien. She's managing the technical side today, so you'll have seen her email in the invitations.
Okay, thank you.
I've got my colleague Mark Chaplin. Mark.
Hi, yes, my name is Mark Chaplin. I'm the placemaking team leader at Ashford Borough Council, and I'll be dealing with urban design and heritage matters today.
So you were a team leader?
Yes, placemaking.
Okay, thank
team.
you.
Thank you.
Yeah, thank you very much.
And finally, we have Daniel Carter.
Hello, sir. My name is Daniel Carter. I'm the spatial planning manager at Ashford Borough Council. In old money, sir, that's the local plan manager. So that's essentially what I am. I'm here primarily to talk about the Stodmarsh issue. I've also been given the joy to deal with the Stodmarsh response on behalf of the council. So I'm here to field any questions in relation to that.
Thank you very much. Who else do we have?
We also have Councillor Linda Harman.
Okay.
Oh, you're muted.
Good morning, sir.
Good morning.
I'm delighted to be here. I'm the Borough Councillor for Saxon Shore, which includes Aldington, but I'm also the Chair of Aldington and Bonington Parish Council.
Thank you, Councillor Harman.
And I'm quite happy to be addressed as Linda. Thank you.
Thank you for that. Would you mind if I stuck with Councillor Harman?
That's fine too.
That's fine, thank you. Yes, it's a lot. We have to have some degree of formality, but at the same time, it's what you're most comfortable with. So, provided you are comfortable with Councillor Harman, then
yep, no,
I think we'll stick with that.
I'm perfectly fine, and it also makes it complicated if people have different wishes, and you have to keep remembering who is who. Thank you.
Thank you. Sorry, I see Louise Sayman.
Yes, morning. My name is Louise Sayman. I'm a lawyer at Knights on behalf of the appellant.
Right. Sorry, I got you a lawyer on behalf of the appellant. Which firm?
Knights PLC.
Right. Okay, thank you. I don't think I do have.
Same for me as well, so I'm just the lawyer on behalf of the appellant as well. We're just here as a small extension to discuss the 106 issues.
Right. Again, how would you like me to address you if I need to ask you to speak or invite you to speak?
Same as everybody else is fine by me for consistency.
That's the same with me too.
Thank you. Right. Okay. Do we have anyone else who is likely to wish to speak? Stage.
Just to reiterate that I am a villager in Aldington, and I would be keen to speak, please. So.
Yep. All right. Thank you, Stu. Fine. Okay. Of course, if anybody does wish to speak, suddenly feels a desire or need to speak during the hearing, that's absolutely fine. You're not barred because you haven't said so right at the beginning. So do please contribute if you wish to, but do please let me know your name if I've not already taken it. And forgive me if I'm a little slow in picking up the names unless they appear on screen. Is the council maintaining an attendance list? Can I ask? A song, perhaps?
Yes, we are.
Thank you. And you'll be able to provide that to me by the end of the hearing, or at the end of the hearing,
yes,
through the case officer.
Yes, thank you.
Lovely. Thank you very much. I have to ask, does anyone intend, or indeed is doing so, filming or recording this event? No.
The hearing is actually being live streamed on the council's website, and it is actually being recorded as well. So a member of the public is able to access the hearing live stream via the council's website, wherein they will find a link to both the case documents as well as the live stream feed.
Okay, that's lovely. Thank you.
So we understand that there is a technical problem with the live link on the council's website.
Oh, is there?
Apparently, it's not accessible at the moment. It's asking you need permission to join. So perhaps the council can look into that to see whether or not a new link can be put on the council's website.
Yes, I wasn't aware of that. Laura, who is attending, should be able to get a message to the correct person. It looks like we may have just sent them the feed to this actual meeting rather than the public site, but hopefully we'll get that sorted soon.
Okay.
Yeah, that's no problem. I will have a look into that. I have double checked and it seems to work through a laptop rather than mobile phones, but I will just double check with that link and get a new one uploaded if that is the case.
Okay, thank you.
Okay, thank you. Does anyone have any objection to there being filmed or screened or streamed? No. Okay, thank you very much. I have copies of the representations made in response to the original planning application consultation and the appeal notification, and I will take these into account in reaching my decision. All documents and evidence had already been provided. However, I did notice from the appellant side reference to a protected species survey from December 2018. I don't seem to have a copy of that, at least I can't find one. Would it be possible for that to be provided to the case officer for me, please?
Absolutely, Mr. Small. We will get that sent to you by email as soon as we can.
Right. Okay, thank you very much. I'm not inviting any other evidence, but if you intend to submit anything else, do please tell me now. No one's anticipating that at this point in time. Okay, very good. Turning to the site visit, we will discuss this later on the agenda, but just a preliminary note. I have viewed the site on Google Maps, but I acknowledge the limitations of that medium, but it has helped me have a general awareness of the site and its surroundings. I will be making a formal site inspection later. At this stage, I anticipate the visit being tomorrow, as I will have some way to travel and I doubt we will finish in time today. My intention would be to close the hearing today because of the difficulties of conducting recording a discussion on site. Has the council or the appellant any views on that proposal at this stage? No. Okay, thank you. Well, we can review that later, but that's helpful to know at the moment. At this stage, do we know if anyone else, anyone wishes to attend the site visit? Or I assume that it's an accompanied site visit. Let me just ask the question. Who would wish to attend the site visit with me?
Sorry, I think I missed some of that. Just for a moment. Sorry. It's a little bit quiet on my speaker, even though I've got it on full. I just were you asking as to whether or not it was going to be an accompanied site visit?
Yes, just at this stage. And we can come back to the details later, but just so I have some idea, yes, would it be an accompanied site visit? And if so, who would wish to attend?
Well, from my point of view, I'm happy for it to be unaccompanied or accompanied. If it's going to be an accompanied site visit, then it would be myself who would attend on behalf of the council.
Thank you, Ms. Saul. I'll come to you in just a minute, Councillor Harman. Just from the appellant's side, do you have a view on that?
So I would concur with that. We are happy with an unaccompanied or accompanied site visit. If it is to be an accompanied site visit, it would be either myself or Eleanor Trenfield attending the site visit. It would depend on the timing of it tomorrow as to which of us would be able to attend.
Okay, all right, thank you. I'll come back to that. Councillor Harman.
Thank you, Ms. Small. I just wanted to ask if it was possible. I would very much like to be part of the site visit, but equally, if you prefer to do things alone, I would be happy with that too.
Okay, thank you. I should explain that if I close the hearing, as I said just now, if I close the hearing discussion today, then there would be no discussion of the merits of the case on site. It would be simply an opportunity to see me in person if that was something you wanted to do, but also to point out any sort of factual matters. But so I couldn't get into evidence. But if I have an unaccompanied site visit, do rest assured that I will see what I need to see on site. I know there are footpaths. I want to walk through the village. I want to walk through the conservation area. I will spend some time there. So let's leave that for the moment. Councillor Harman, will you be with us all day or?
Yes.
Okay, thank you. Mr. Hulme, did you have a view on whether or not you wanted to take part in an accompanied site visit, bearing in mind what I've just said?
I'm very happy to. I live next door, so or just down the lane, so I'm happy to if I'm able to extract myself from work. The only thing I was going to mention, Mr. Small, is that one of the things I was going to mention is around the time of day you might wish to attend. One thing you will notice from the Aldington Historic Ridgeline character area is that there is already an unfortunate planning error from 5 years ago where Quarry House assisted living was allowed to be built, and if you are approaching the site from the A20 route into Aldington, you'll see what I mean in terms of when things can unfortunately go wrong and leave a huge blot on the landscape and dark skies. So you may wish to consider, if it's possible, thinking about not just the daytime, but also as it gets dark, and see where the existing ridgeline, where it has been unfortunately damaged, what the impact could be on the surrounding area, because that site is viewable for up to 4 or 5 miles in some places. And you'll see the visual light from afar. But I appreciate that may not be possible, because that would probably end up, given these days where the light is 5 o'clock onwards. I don't even know. I can't even remember when it starts to get dark.
Okay, thank you. Okay, what I'm interested in, Mr. Hulme, what I'm worried about is if I leave a decision on whether or not to have an accompanied site visit until the end of proceedings, which is the normal case, and then we decide it should be accompanied, or indeed it should be unaccompanied, how we will let you know. That's my issue. Sorry, Councillor Harman.
That's fine. I shall be here all day, and I will update Nick at the end.
Okay, that's very kind. Thank you. I'll come back to the site visit. That will, Miss Song.
Sorry, I just wanted to mention my colleague Mark Chaplin has indicated that if it's an accompanied site visit, that he would also like to attend.
Thank you. Okay. Right. Okay. Thank you for that. We'll come back to arrangements later, and we'll see if where we are at that point in time. Fine. Now, we will need to have a discussion about what conditions might be appropriate were I to allow the appeal. I reassure interested parties that this is standard procedure. It does not indicate that I've made up my mind on the case, nor will the discussion affect the council's position in relation to the proposal. Now, I have a list of conditions as an appendix to the statement of common ground. We'll return to this at a relevant point in the agenda. But can I confirm from the appellants that you've seen this list of conditions and have agreed them?
Yes, sir, we have seen the list of conditions and we have agreed them with Ms Song prior to them being sent out to you by email.
Okay, thank you. We will also need to consider the Section 106 agreement, an appropriate point. I shall probably deal with any outstanding matters on the Section 106 in the discussion on conditions. Excuse me. Costs. I'm not inviting any applications for costs, but should any participant wish to submit a cost claim, this will need to be done before the end of the hearing. In addition, I have the power to initiate an award of costs in addition to any application made by the parties if I consider that unreasonable behaviour has occurred. If I were to do this, it would follow a written process with a relevant party after the appeal decision is issued. I'll return to costs later on the agenda. Is anyone at this stage planning to make a cost application? Okay, thank you.
At this stage, sir, no.
No, thank you. Thank you. Right, thank you. The main issues are set out on the agenda. I regard these to be whether the appeal site is an appropriate location for development, having regard to local and national policies, the accessibility of the site to facilities and services, and the effect of the proposed development on the character and appearance of the countryside. Appearance of the area. Secondly, the effect of the proposed development on the setting of the Aldington Claphill Conservation Area, its character and appearance. Whether the proposals make adequate provision for infrastructure, including affordable housing. Whether the proposals make adequate provision for self or custom built dwellings, and the effect of the proposed development on Stodmarsh designated habitats sites. In addition, I shall touch on housing land supply, and also one of the other matters. I said there were two additional items to add to the agenda. You have one is the Section 106, and the other is the designated habitat sites at Dungeness, which the appellant's ecological survey refers. So I'm hoping that we can do that fairly briefly, but I do need to cover that. Does anyone have any comments on these issues or matters? No, thank you. Are there any questions at this stage about the procedural side of the hearing? No, excellent, thank you. In that case, then I can turn to the agenda. I do have some preliminary matters to go through. Now, I've received a statement of common ground. Thank you for that. The statement I have, though, is not signed or dated and still says draft as a watermark. So is this a final version of the statement of common ground agreed by the main parties, or is it still draft? Can you please help me with that?
Indeed, it has been agreed. I apologize, it was a function of time, but I didn't have time to have it all signed before sending it to you, given the lateness of the day, but it has been agreed in principle between the two parties.
Right, and thank you, Ms. Song. And from the appellant side, talks perhaps?
Yep, I can concur with that. It has been agreed, but the reason this is still has draft on it is because it hasn't been signed and dated, but it is a final version that has been agreed by both parties.
Right, okay, thank you, that's helpful. I have the council's comments on the draft section 106 agreement. Has the appellant seen those, did you say?
Yes, they've been seen by the appellant solicitors.
Okay, so these are the comments that arrived in my inbox this morning. So those are the latest ones. So those have been passed to the solicitors.
Yes.
Have you had time to consider those?
We have, yes. So the comments that basically the update that was sent through to you yesterday, so we've got some kind of comments to add in terms of the position on that and the position with the 106 in terms of where we're up to. Do you want to go through that now, or did you want to leave that later to discuss? Or
I'll leave that to later. I think I just needed to make sure whether or not you need any time to consider those, but it appears that you are up together with that.
Yes, the comments that were sent through to can I just double check it as the email of the 7th of March time 1650 that you're referring to?
Yes, that sounds the right
yes
one.
Yeah, we have got those comments, yes, and they have been reviewed, so we can provide an update on that, and that's the reason for our attendance.
Lovely, thank you.
If I may, I would just note
yes,
the copy that was sent on the 7th of March is the same copy that you had received previously from the 5th of March. Which was directly forwarded to the appellant solicitors by Donna Lee, the council solicitor. So there's been no change between that revision and the copy that was sent to the planning inspectorate.
Right. Okay, thank you. Lovely, thank you. Right, thank you. I have a set of the application plans and the list of plans and documents. Thank you, that's very helpful. I have received the proposed diagram, local wildlife site buffer drawing number 1910_196 revision D, a proposed diagram site-wide local wildlife site boundary and mitigation drawing number 1910_197, and updated landscape strategy plan 1, drawing number 0065-L11, revision 3, to incorporate the proposed buffer zone. I understand that Kent County Council Ecology have been consulted on the revised landscape strategy, or the buffer really, and I've seen comments. Could the council advise me if Kent Wildlife Trust has been consulted and made any comments on the revised buffer?
Indeed, sir, we did send a consultation request to Kent Wildlife Trust. Unfortunately, and I did chase for the comments, but unfortunately we haven't received a further response. So they have not considered or sent through anyway any response to the revised information.
Okay, thank you. They've had the opportunity, that's important. Okay, lovely, thank you very much. The drainage strategy has been amended, and the appellants referred me to a response from Kent County Council raising no objection. I see from the statement of common ground that this is not a matter in dispute, so that's that. Finally, under my preliminary matters, has there been any progress on the neighbourhood plan? I see a number of references to the neighbourhood plan in representations. Can perhaps Councillor Harman, you could advise me of the latest position on the neighbourhood plan, please?
The neighbourhood plan is at almost at draft stage. We have conducted a local housing needs survey. We have consulted most recently on renewable energy and biodiversity matters with regards to how green is our plan. And we consistently have comments about how inappropriate this site is for development, and about the scale of it and the number of properties that are proposed. So the neighbourhood plan, unfortunately, is not in a position to be considered as a statutory document, but it does contain a high number of very relevant comments, and you can see for yourself the strength of feeling from a number of people that engaged in the consultation.
Thank you. I have the representations from interested parties before me. I'm not sure it's appropriate to have copies of the representations to the consultations on the neighbourhood plan. I've got those that relate directly to the proposal before me. So you say it's almost at draft stage, but there is no draft plan.
There's no draft in a minute. No, sorry.
No.
Sorry for us.
I just need to understand it's a time, just to kind of update.
I understand
Where we are, so that's fine. Thank you.
Can I just ask? I did submit the views and vistas map that is part of the neighbourhood plan, and it does include the view from the top of Calleywell Lane, which is a primary concern and very much a planning matter to be considered with this application.
Yes, thank you. Okay, I have that. Right, thank you. Okay, that deals with the preliminary matters from my point of view. So I'd like to move on to the main issues. And the first issue is whether the appeal site is an appropriate location for development, having regard to local and national policies, the accessibility of the site to facilities and services, and the effect of the proposed development on the character and appearance of the area. Firstly, could I ask the council to turn to policy SP1, please, of which I have a copy. Did have a copy. Yes, of SP1, please, and advise me of the implications of SP1 for the proposal, please.
Certainly, yes. I'm just turning to the page. It's SP1 is the main sort of strategic policy with regard to any and all development in the borough. It sets out the objectives in terms of delivering our vision, as well as setting out the target. It doesn't set out the targets, but the manner in which we hope to achieve sustainable development within the borough. I think it sets out a number of different criteria or objectives and the manner in which we hope to achieve sustainable growth in the borough. As such, any and all development proposed would be judged against that particular policy.
Are there any particular aspects of the policy you wish to draw my attention to?
To be quite honest, most of the policy, if you look at criteria A, which deals with accessible, sustainable locations, do you mean just in terms of this principal matter that we're dealing with now, or just generally?
This principal matter, I was thinking.
Okay, certainly. We would be looking at criteria A, which seeks to focus development at accessible and sustainable locations. We would look at policy criterion B as well, to conserve and enhance the borough's natural environment, given the issue of landscape and character assessment. I'll leave C because that relates more to the conservation area and heritage side. Criterion D, which seeks to have high quality design in a sustainable, accessible, safe, and promote which are sustainable, accessible, and safe, and promotes a safe sense of place. Criterion E, which looks at the infrastructure requirements in relation to supporting the developments being proposed. F, in terms of sustainable transport and access. G, for the mix of housing types and sizes to meet our housing needs in the district. Those are the relevant sections, I think, with respect to this particular development and this particular matter.
Okay, thank you, Ms. Song. Did the appellants have anything to say, Ms. Hawkes?
Only so that yes, it is recognised as a policy that we would need to comply with in terms of outlining the council's strategic objectives for development, and we'd say that in terms of going through each of the criteria which Ms. Song has referred to, that the development in this particular case does comply with the vision and the strategic objectives that are outlined within that policy.
Okay, thank you. Any further comments from anyone on policy SP1? Councillor Harman.
I'd just like to comment that criterion A quite categorically states that the starting point is to utilise infrastructure, facilities and services where possible. We're a rural location, we have few of those, and to make best use of suitable brownfield opportunities, which this certainly is not.
Okay, thank you. Ms. Hawkes, do you wish to come back?
Only to say, sir, that in terms of that criteria A, it talks about focusing development at accessible and sustainable locations, and we are of the view that this is an accessible and sustainable location on the edge of Aldington, which is recognised as a settlement in other policies within the local plan, which we will come on to, as an acceptable location for windfall development, i.e. on the edge of settlements. It will utilise existing infrastructure by way of being able to connect into Calleywell Lane, and clearly as part of the application documentation, we've clearly shown what the arrangements will be in terms of highways and in terms of drainage, and that the proposed development is acceptable to the statutory consultees in both cases, i.e. KCC highways and also in terms of KCC drainage.
Okay, thank you. Interested, oh, Ms. Song, sorry.
Just very briefly, I just wanted to mention that, of course, the policy SP1 as the strategic objective is very much what feeds into policy HOU 5, which we'll be looking at later. That takes the strategic objectives and elaborates in greater detail as to how we would like to see development come forward in the district, or sorry, in the borough, having regard to the main aims of the policy. There's clearly some difference of opinion. I won't go into that now with regard to whether it is a sustainable or not location. These are the arguments that have been put forward in the various statement of cases. The council's position is that whilst it is on the edge of the settlement, that the scale of the development and in terms of the scale of the development, in terms of the size, may be excessive with regard to the village and its infrastructure. Yes, it does have infrastructure, but Aldington is a village which has seen quite a settlement, which has seen quite a lot of growth, and it's looking at whether or not, whilst we may accept a certain level of windfall, whether this meets the criteria set out in HOU 5. So I'll leave that and that point sort of there until such time as we get to the policy considerations under that particular policy.
Thank you, Ms. Song. Lovely, thank you. The policy SP2, not raised by the council, but raised by interested parties. Ms. Song, could you perhaps explain the implications of policy SP2 for the proposed development?
Certainly, it was put forward in our statement of common ground in terms of the relevant policies, so I apologise if it has been missing in prior submissions. But SB2 relates to the strategic view of the strategic approach to housing delivery within the district. So as part of our local plan preparation, we examined a number of different areas throughout the borough to identify suitable locations for additional housing to meet the targets that are set for the borough. SP2 sets out that in the broad spectrum requirements and how we seek to achieve that. So it sets out that the majority of housing will be in Ashford, in the town and its periphery, and it sets a number attached to the level of increase we're hoping to achieve. And then it refers to the rural areas. So we have site allocations for achieving the housing delivery within rural areas, and that number is 1017 as set out in SP2. You will have seen in the statement of case that Aldington does have a number of 2 sites which have been allocated via this process. This particular site was considered during that stage, and there has been no allocation as a result of that process. The remaining delivery is it relates to windfall sites as well as previously committed developments. So the council has in its local plan accepted that we will deliver some of the required housing target via windfall sites. And it's for that reason that we have in the local plan both policy HAU 3 and HAU 5. HAU 3A is not relevant to this particular site, but the 2 policies seek to set out the council's position and criteria for how we would assess windfall delivery within the borough. So it seeks to further elaborate on the sort of general aim set out in policy SP2. Thank you.
Mr. Hume, I'm conscious of the time, but I just need to go back to Ms. Hawkes and the team for any comments on SP2, and then I'll come back to you. Okay. Ms. Hawkes.
Only to say, sir, that policy SP2 is clearly a strategic policy, and as Ms. Song has indicated, it is there to then inform other policies from it, including policy HOU 5, which is the key policy in this particular case. In terms of allocated sites within Aldington, yes, there are 2 allocated sites within Calleywell Lane, which within our statement of case we have referred to. Both of those sites deliver or are capable of delivering less housing than what was originally proposed as the allocations for both sites. Both sites originally in the local plan process were looking to achieve 30 dwellings on the 2 sites. That is not now possible. At the examination, which I attended along with the appellant, the inspector raised concerns on those 2 sites in Calleywell Lane in terms of impact on conservation area setting and views, and the number of allocated of the number of units, that could be accommodated on the 2 sites was reduced subsequently. So those 2 sites will not combined deliver the amount of housing which was originally intended. The appellant did put in a local plan representation promoting the site at Calleywell Lane as a housing allocated site within the local plan, but it was a much larger site. We were looking at an 80 dwelling allocation, but as Ms. Song has pointed out, it wasn't taken forward. It was the draft local plan, and at the hearing into the public examination into the local plan, the inspector did not invite conversations or discussions regarding alternative sites. So he only considered sites which had been put forward by the council in the draft local plan at that stage.
Thank you very much. Clearly, it's not for me to rerun the local plan examination. But that's helpful background. Ms. Song, did you have any further comment on that?
Only that I wasn't involved in the local plan process, but having said that, I believe that the council put forward the site. It is aware of the history and the concerns that were raised with regard to the capacity of the two allocated sites. Sorry, I should be clear on that point. And we accepted that that was a reasonable figure, having regard to the level of development and the previous development which has taken place within Aldington. So yes, it has reduced from a higher figure, which was proposed initially, but ultimately the figure of 18 was considered to be appropriate within the local plan targets. Having regard to the level of development that has happened within Aldington in the last 10 to 15 years. The settlement has considerably increased in size with respect to the number of dwellings. It is a village settlement, and therefore in abject numbers and figures, the number of overall dwellings within the village may seem quite small, but there has been a considerable increase in the number of units of residential dwellings permitted there through allocations and some windfall, and therefore when the numbers were reduced in relation to the allocated sites, it was considered to be appropriate in this context. I'm not sure if Dan Carter, my colleague, would like to say anything in this moment.
Yeah, just very briefly, sir. I mean, I happened to be there as part of the local plan preparation, but of course, I wouldn't want it to be badged that there was some sustainable housing number for Aldington that somehow got reduced. I mean, the process of the local plan and the inspectors that were assessing the local plan, and there happened to be two, sir, because there was a junior inspector and a senior inspector, was to look at the evidence that was put forward by the council in relation to that local plan. And if that was a sound approach, then that is what was signed off. And yes, the inspectors didn't entertain alternative sites, but that's because the sites that we put forward and the policy framework that we put forward was judged to be sound. Had it not been, then that would have been different. So the position here is that the inspectors have assessed the merits of the proposals coming forward in a local plan context and judged from a site allocation perspective that what is in the local plan is sound. It's as simple as that, and that is reflected in the inspector's report and the adopted development plan. That's all. Understood.
Councillor Hartman, I knew you put your hand up. I did promise Mr. Hume I would go back to him first. And Ms. Hawkes, I will come back to you, but at this point, it might interrupt the flow a little bit, but given Mr. Hume's sort of time constraints, Mr. Hume, would you like to say anything?
First of all, I'm very grateful for that. Thank you very much, Mr. Small. In terms of this subject matter, I can't talk to policy references. I'm a layperson in this speak. However, what I can talk to as a villager is sort of the fundamentals of sustainable planning. And if I take it from a layperson perspective, it's greenfield, it's grade 2 farmland, it's outside the identified settlement boundary, it would dwarf the directly neighbouring Clackhill Conservation Area. It would join up Aldington with a Stone Street Green Hamlet. It would hugely increase car dependency on and what I can describe as only sort of very dangerous single track blind corner roads. We haven't talked about Stodmarsh yet, but that's another planning consideration. And I also think bigger picture, Aldington is the last green buffer zone between East Ashford expansion and Otterpool to the other side. So if we start building out Aldington in the way that it's already had, which is 100 houses, I think, in the last 5 years, and almost 200 houses in the 10 years, to Ms. Song's point earlier, this is a small village that is very quickly becoming not Aldington, but Aldingtown. And I think we do need to reflect that. The one point I wanted to really flag, though, which I think is crucial to this on this particular point, is this is put on the most elevated and most undulated part of the Aldington ridgeline landscape character area. I cannot describe how visually elevated this site is on the ridgeline. You can see from so 5 miles away, you'd be able to see this site. You've already got the issue of the quarry house that I've already mentioned to, that's blotted the landscape on one other side. And I think we should just have reflection of the fact that the villagers who live there, from my maths, I think it was 136 villagers that objected to one that was supported. And to carry on to the point that Councillor Harman made earlier, in the Neighbourhood Plan sort of preliminary survey in 2020, villagers highlighted this field more than any other as the one that would best preserve the sense of Aldington's overall rurality. And I think that is a really important planning consideration to take into effect, because it's the villagers that live there. So I hope I haven't gone too far out of the realms of the specific policy references, because I'm afraid I can't engage at that level. But from a pragmatic perspective of someone who lives there, I can't think of a site more inappropriate to put a large, very dense amount of houses, which, I mean, I know we can come on to this, but the unsympathetic design, sort of urban form, zinc-clad, powder-coated aluminium. I've not seen a single other dwelling in Aldington that has that description on the most elevated part of the village, for a village that's already undergone significant expansion. And for all those reasons, I, on behalf of the other 136 villages that objected, and all the other villages as a whole that are part of the neighbourhood plan otherwise, would sincerely ask that this inappropriate proposal is rejected for what is, I think, the 4th or 5th time I think that this has come out of various local plans and committee hearings. Thank you.
Thank you, Mr. Hume. Don't worry about not referring to policies. It's your views I'm after. I will just say, from the appellant's point of view, that it's not. I appreciate there's strong local feeling, and obviously I take that into account. It's not so much the number of representations; it's the planning merits of the responses that are made. But rest assured that I have read all the representations and made notes, and we'll take this into account. Ms. Hawkes, I will come back to you in a moment, but just to say that a lot of the points that Mr. Hume raised, I will be dealing with in detail as we go through policy HOU 5. So if you could contain yourself, I think, for the moment, and I'm sure you want to come back on some of those points, but I will make sure you have the opportunity to do so. But let me go to Councillor Harman now, and anybody else who was speaking, and then we'll come back, Ms. Hawkes, just for this point particularly, before we get into HOU 5. I think still on policy SP2. Councillor Harman. Excuse me.
Thank you, Mr. Small. I just wanted to make the point that I was present at the hearing for the local plan, and that the points raised by the appellants were not the reasons why the site numbers were reduced. That was addressing what the inspector accepted was sustainable growth for our village, as raised by other people. This village has grown significantly. Currently, 600 houses. 10 years ago, we were nearer 400, 450. That is significant growth. And it was recognised in the local plan that Aldington needed to grow in a slower and more sustainable manner. And that was what was addressed through the local plan. Thank you.
Thank you very much. Ms Hawks, anything just to wrap up on policy SP2 before we go into HOU 5?
Yes, sir. Just to wrap up on it in terms of perhaps a takeaway point in terms of policy SB2 is in relation to the fact that it is looking at not just allocated sites, though, it is talking about windfall development sites as well. Clearly, we've talked a bit about the allocated sites within Aldington, but they were still put forward at the draft local plan stage for 30 dwellings. So there was at that time an acceptance that Aldington could, within its infrastructure provisions, accept 30 dwellings in terms of growth for allocated sites. But the other important point is that the strategic policy is allowing not just allocated sites to come forward, but there is the opportunity for windfall sites also to come forward in named settlements within policy HOU 5. But as you say, we're going to go into more detail on policy HOU 5 shortly.
Lovely, thank you, Ms Hawks. Right, thank you. Any final comments on policy SP2? In that case, then, Mr. Hume, if you need to leave us, do you feel that you've had the opportunity to say what you wanted to? Obviously, the question of the site visit is still up in the air a little bit, but I've noted your thoughts on that.
So yeah, I absolutely do. Thank you very much, sir. Thank you very much, Mr. Small. I was actually writing in the sidebar so as not to disrupt things any further. I'm just very grateful for you accommodating me. I was so desperate to contribute today. I've not done one of these before. But if I am needed at any further point, please please ask Councillor Harman, and I will do my absolute best to be back on the line within a period. But yes, I do feel like I have been able to share the key points I wanted to express at this sitting. So thank you very much for your time.
Okay, no, thank you for participating. I obviously have a copy of your representation. I noted down what you said, so I'm not sure we'll need to call on you again, but thank you for the offer. So thank you for your contribution.
And thank you very much, everyone. Thank you very much. Bye-bye.
Right, I'd like to move on to policy HOU 5. I thought I might take a break at about 11:30 if that suits everyone. So that means we can sort of start with policy HOU 5, but I'm confident we won't finish it by 11:30. But I think I might take a break around that time at a suitable point, just for whatever we need to do. So moving on to policy HOU 5 then. I think it's generally agreed that policy HOU 5 is a relevant policy. It's probably the most relevant, really, in determining this particular proposal. So I'd like to work through the criteria of policy HOU 5, please. Looking at A, the scale of development is proportionate to the size of the settlement. And I'd like to ask the council how proportionate is assessed, please. Sorry, was that clear?
So, yeah, sorry, I was just trying to unmute my system. Apologies for the slight delay there.
No.
We don't have an abject sort of percentage or figure set out in the policy. It's a question of judgment with respect to the size of the settlements. So the first opening preamble of the policy sets out the settlements alongside which we would like to see development directed, and that is not an fully comprehensive list of all villages within the borough. There are a number of settlements that are not listed in policy HOU 5, and that's important to remember insofar as in looking at this policy and in constructing this policy, we have already done as a local authority, a local planning authority, some element of assessment of the settlements and their infrastructure, their size and their suitability to take any additional growth. Aldington is within that list. But the criterion A is really trying to define a way in which we can assess proposals coming forward in relation to the individual scale of each settlement. So when looking at development proposals that come forward, we would be looking at the level of services that are there, the type of services which are there, and the potential impact of the growth being proposed on those services in terms of how well they can be integrated and absorbed by the existing facilities, and the speed at which I suppose those would be added within the settlement. I think the policy doesn't set out an objective figure as to what size of development we would consider to be windfall. However, that is a case of judgment with regard to us planning officers when we see a development and look at the scale of the settlement and what is proposed, and we need to make a judgment as to whether or not we think it can absorb that scale of scheme. And in terms of this proposal and policy HOU 5 criterion A, we do have some thoughts as to whether or not it exceeds what we would have considered to be windfall, and really ought to be something that should be considered in a new evaluation of site allocations potentially for housing growth within the borough. The local plan does make some provision for a reassessment of housing delivery and allocations after 5 years if it turns out that we are not delivering housing to the level at which we had hoped and anticipated in constructing the local plan. And it may be that this site and the level of development being proposed of this scale could be considered at that stage. But at this point, it is the council's position that the scale of development in this case would be excessive, bearing in mind that we also have site allocations already determined as part of the local plan with regard to the 2 allocated sites on Calleywell Lane. And there are other smaller windfall sites coming through the development management process. I think Dan Carter may wish to say something. I'm not sure. You've popped up on my screen. Sorry.
Sorry. Only to complement the points you've already raised. I mean, the honest answer, sir, that it's a difficult question to answer objectively, because we were in a world before the MPPF where essentially you took one step beyond a settlement. It was almost an in principle no. Now it's in certain locations and in principle maybe. So I think there are lots of considerations to factor into what we would consider proportionate in relation to the scheme here, and one of those would be how aligned it is to your site allocation strategy. If you were to build up a picture of the considerations that the inspectors made during the local plan process and opined on a framework of sites that they felt were sustainable, that partly tells you a narrative about the relative role, character and place of your borough. And obviously in Ashford we have a large town in Ashford Town, and that's disproportionate in terms of the services and facilities, and that's reflected in SP2. It's also reflected in HOU 5 in that Ashford is included within HOU 5, just as a range of other rural settlements are as well. So very difficult to give any percentage figure to it, very difficult to give a number to it. It's a combination of factors that influence you as a sort of decision maker in terms of what's the balance between the site allocation strategy and the windfall strategy? Absolutely, windfalls need to play a role, get that totally, and they do. But it's that correlation between the two processes as a feeding your understanding of the context here, which is why I think the allocations in Aldington and some of the debates we had at the examination for Aldington are relevant, because of course, if you have a plan-led system, that site allocation strategy and that windfall strategy need to be combined, don't they? And that's essentially what I wanted to say.
Okay, thank you both. Ms Hawkes.
Thank you, sir. Yes, it's clear in policy HOU 5 that there isn't a figure put on it. So depending on the settlement in question and the size of the settlement in question, it is a judgment. As Mr Carter said, it is a judgment that needs to be made in relation to an individual settlement as to whether or not the proposal that's being put forward is proportionate in size to the size of the settlement. Some important points to sort of note here, really, in terms of the number of dwellings in the parish of Aldington. There are 400 or just over 400 dwellings in the parish, and what we're looking at here in terms of a development is 33 dwellings. So therefore, we are less than 10% in terms of an increase in the number of dwellings within the settlement, and that includes the parish, the entire parish, not just the village. And it's also important to bear in mind what service provision you have in a village as to how much that village can effectively take as part of a development proposal coming forward under HOU 5. And we also go back again to the local plan and the discussions that took place, in that it was recognised that Aldington could take 30 dwellings at the time of the draft local plan. And we've also had another takeaway point would be the pre-app advice that we sought prior to the submission of the current application, following the withdrawal of the previous application, which was for 80 dwellings. We did seek pre-application advice with planning officers over particularly that point in terms of the scale of development which would be proportionate to Aldington. And as a result of those discussions that we had, we were looking at a development of 40, and it has decreased since that pre-app to what we have now, 33 dwellings. And that was on the basis of the advice received at the pre-application meeting by the planning officer at that time, who considered that 30 dwellings would be proportionate in scale and size to Aldington village.
Thank you. Okay, sorry, Ms Hawkes, had you finished to that point? Or did you just wait for me to catch up? Sorry, Ms Hawkes, can you hear me?
Sorry, sir. Yes, I finished on that point, sorry.
Okay, sorry, thank you. That's absolutely fine. I was just had my head down writing the notes, and I didn't know if you were just pausing for me to catch up. Ms Song, I see that you've raised your hand. I'll come to you in just a moment. I think we are where we are in that this is an application for 33 dwellings. A local plan has been adopted. I'm not, I'll need to reflect on this, but so I'm not making a judgment right now, but I think that's the point. That's where we are. You know, whatever happened at local plan inquiry, whatever happened before the local plan with the draft local plan, the plan's been found sound with the allocation it has and the policies it has. That's what I'm working to. So the background's helpful. But I need to reflect on just how determinative that might be. And the same with the pre-application advice. I understand the point, and that is helpful again, because it does get to the heart of my question. If the council are saying that this is not a proportionate increase, it's perfectly legitimate, I think, for me to ask on what basis has that judgment been made. And Ms Song and Mr Carter have responded to that. To Ms Song, did you want to say something further?
Yes, it was just a brief note, because you've obviously seen the pre-application advice, and my understanding is, and reading the advice and looking back at the history, there is no figure cited. Well, firstly, I should note, of course, that it's informal advice at officer level, but secondly, I should note that it's not very clear in the letter that there was a figure that the planning officer had in mind when suggesting that the proposal was inappropriate with respect to the 40 units that were shown in that advice inquiry, and what he or she considered, sorry, I forget if it was a she, what she considered to be appropriate in terms of a reduction. The letter merely says that it ought to be a significant decrease in number. There is no figure alluded to in the letter itself, and therefore I think it is a case of looking at the proposal put forward alongside the allocations and everything coming forward in Aldington itself, and making a judgment today with regard to whether or not this is indeed proportionate.
Thank you, Ms Song. I'll come back to Ms Hawkes in just a moment. Finger poised. Councillor Harman, you have your hand raised.
Thank you, sir. I just wanted to make 2 points really. One, as the obvious way to judge proportionate is that it shouldn't, for a windfall site, be almost twice as much as the allocated housing, which has been considered to be sustainable for a settlement. And secondly, to say that the appellant's figure of 400 houses for Aldington is actually showing just how much this settlement has grown, because that is the figure from the 2011 census, and the tax base for this settlement is now over 600, which gives you therefore the rapid growth that this village has endured. And it takes time for all those new homes to be absorbed and for communities to be rebuilt, and that is the reason why this community feels so strongly about this application.
Okay, thank you. Yes, I'm not rerunning the local plan inquiry, obviously, so let's not go there. But somewhere along the line, the council has, through the local plan inquiry, made a judgment that 18 houses is proportionate, and we're now talking 33 on top of those 18. So that's the council's point, I think, isn't it? So okay, that's fine. I don't think I need to ask the council anything more on that. But Ms Hawkes, your opportunity.
Sorry, sir, is it okay to speak?
Yes, thank you.
Okay, thank you. Yeah, just coming back on the comment from the councillor regarding the number of dwellings in the parish. I mean, that does also indicate, in terms of a proportionate percentage proportion, that you know, it's less than 3%, and clearly, if you're looking at the housing in terms of 18 houses on the allocated sites and 33 houses on the windfall site that's proposed to come forward in Aldington, then it would still be less than 10% as a proportionate figure. Just coming back again on the point relating to the pre-app, the pre-app was with Ashley Smith. We had a meeting with him at the council offices, and during the meeting we discussed what was in front of him in terms of a sketch scheme. Clearly the letter does talk about what was in front of him at that meeting, and therefore assesses it on 40. And Ms Song is correct, as you would have seen from the pre-app, that it does refer to 40 being not considered proportionate and that there would need to be a reduction. However, during the meeting there was reference to a figure. Now it is unfortunate, sir, that clearly that hasn't come out in the letter that's was presented following up the meeting that took place, but there was clearly a discussion during that meeting regarding proportionate growth in Aldington.
Okay. Right, thank you. Councillor Harman.
Sorry. Sorry, it's a legacy hand, sir.
Ah, yes, the legacy hand, yes. Okay, not to worry. I think I've explored as far as I need to the question of proportionality. Ms Song, you wanted to say something, I'm sorry.
Apologies, sir. I just wanted to make one point that, of course, we are focusing at the moment in the discussion with regard to the allocated sites on Calleywell Lane and the application site. But it should be noted, of course, that we don't operate in a bubble and that other sites do come forward through the windfall policies. And my understanding from my colleagues in monitoring, we've had 5 dwellings approved since the local plan adoption in Aldington, and therefore there is a constant rolling increase, albeit small scale, much smaller than the application scheme, but we need to view not only the Aldington not only in the context of the allocated sites on this site, but also the fact that other smaller schemes are coming forward as well. That should be taken into account when we judge the overall outcome of our decision-making process on what's going on in the village and its sustainability.
Thank you. That's a question of Councillor Harman, if I may. This concept of, I fully understand the amount of developments taken place. I think it was something like 123 dwellings, I saw the figure, since I think 2000. And yes, you're right, I saw the figure of 600 dwellings somewhere. It's the notion of it taking time for a community to absorb. I'm trying to remember the words you use, so I don't want to put words in your mouth, but have a look at my notes, see what I said. But yes, I just jotted down that it was rapid growth since 2011. I'll ask all the parties for thoughts on the ability of a community to accommodate new growth. Councillor Harman, since you raised it, maybe I'll start with you, if I may, please.
Thank you, sir. It's a village community is a very special place to live. We in Aldington have to be relatively self-sufficient. There have been many occasions in recent social history in which we've had to be sufficient. We get cut off by traffic queues caused by Brexit. We have power cuts on a regular basis. We have had storms that have knocked out our telephone communications. We have infrequent bus services. We give each other lifts. We're not near a doctor's. We look after our elderly. We work together as groups to look after each other. And what happened when the village grew very, very fast was that the new communities that came in, the new people that came in, were predominantly in two developments, one at the bottom of New Hill Road, which is known as Aldington Meadows, and has 70 houses on what was a brownfield site, and the other off Calleywell Lane in Wheatfields, which has over 40. And they kind of ended up like enclaves, where the people within them were not integrated into the village core, and there started to be a lot of division between the old villagers and the new ones. And as a parish council, we have actually taken to working over the last 3 or 4 years very much to erode this, and it has taken a long time to integrate the people that come to live in the new houses, and quite often people come into those new houses in a village like Aldington, and they then find that rural living isn't quite what they expected, and they don't like the dark, and they don't like the less buses, and they are not as self-sufficient as the rural people that have lived there traditionally. So all of these things take a long time to overcome, to work together, to find as a community the way around those things. So that's what I meant when I talked about the need to grow sustainably in a way that we can absorb as a village, and that we can continue to live as a strong community, which is how everyone in Aldington wants to live.
Thank you, Councillor Harman. As is convention, I'll give Ms Hawkes sort of the last word, but Ms Song, did you want to add anything to that?
Only that I was just trying to find the reference in one of the reports, so I do apologise because I haven't managed to find it. But I think that the scale of change which has happened in Aldington is something that is critical in looking at the sustainability of this development and its proportionality. I remember reading, I believe it was in the planning committee report, but I haven't found the reference yet, that the Aldington School, for example, has had special authorization to take more students than it would normally do, that they can take every student within a 1 mile radius, and even if that were to mean that they would exceed the classroom size of 20. And I think these sort of allocations and decisions that are being made by local infrastructure providers, service providers, is indicative of the type of change which is happening and what they're expecting, even with regard to what we are looking at in our plan-led process with our site allocations. They will have asked for that kind of permission, bearing in mind the current enrolment and needs of the community, as well as anticipating to some extent what growth is coming forward as a result of our planned growth and housing allocations. And I think it's important to look at the development and growth of the village in that regard, and to keep in mind how the local services are attempting to accommodate what we've already planned for and what they're already seeing. And I think that gives you a sort of a direction of a sort of an indication as to what's happening in the village itself, setting aside all the issues of accommodating new influx in terms of the cultural village culture. There are also these issues with regard to the service provision and the stresses that additional dwellings put on them. On the one hand, it's a positive, because obviously the more users you have of a service, the better that service can become. But equally, we have the pressure that there's a capacity to those facilities, and we need to bear in mind the potential impact of something of this size. I mean, the figure of 10% has been used or referred to thus far, and 10% sounds like a small figure objectively, but the impact of 10% on a village whose services can expand to an extent, but it's not something that happens speedily, and it has to be, and it happens over time most often. I think that that's quite a lot for a village of this size to try to absorb. That would really just in terms of relating the proportionality to the services, I think it's one thing to bear in mind with regard to what is actually happening on the ground with regard to these service providers.
Okay, thank you, Ms. Song. Ms. Hawkes.
Thank you, sir. I would say the important point here is that rural communities in particular need a critical mass in order to sustain them. In the case of Aldington, Aldington is relatively well off in terms of shops and services and facilities that the village already provides. It does have a primary school, it does have a village pub, it has 2 village shops, one selling a rather extensive array of fresh food, and it still has its post office. It does, as Councillor Harman says, suffer in terms of bus services and reduced services over time. But the important point here is having that critical mass in order to sustain the communities into the future. Village pubs are closing on a very regular basis, and to have to still have its pub, it does need to grow as a village in order to sustain those shops and services in the longer term. I know that Anthony Ralph would also like to speak at this point, sir, so if that's okay, I will pass over to him as well.
So if it's okay, firstly I want to apologise that I don't, I understand the principles of planning policy. The team around me kind of guide me and steer me, but as Nick did, so I want to apologise if I don't use the correct terminology. And I just felt on the back of what Councillor Hardman spoke about, it felt like we've just digressed slightly from policy. And then for me, there was just a few key points I wanted to raise. The village is of a fair size now, and at the early stage, I engaged with the village. I call it snuck in the back door at public meetings to hear firsthand what the locals felt our sort of offering of the scheme. I visited the school. I mean, I'm probably talking 5 or 6 years ago now. I met with the parish members, and what I learned was it is a close-knit community. It's a village where people are passionate about where they live, and that they feel quite proud of that. And that became very evident when the door was closed, you know, when the parish didn't want to talk to me. And whilst I engaged at the committee meeting, the parish claimed that I hadn't engaged with them on the development. But in that time and in the years this has been running, I still continually get contacted by people who've seen our work and know we have, you know, a scheme proposed in Aldington, where I'm approached. Some of these people, their children go to school in the village, but they can't find a home and they want to live in the village. And some people live in the village but want to upgrade to a product that we would build. So, and that's why I see it today, because I still feel strongly that so long as we achieve the planning policies, for me as a developer, this is a village that I'd want to build in, and I believe there is a demand there to fulfil it. You know, it means more people in the shops. Sure, if buses are running, if people aren't on those seats, then they'll stop running the buses. So we need a regular amount of growth to sustain these sort of services. And that's why I think a development of this size is beneficial, because it will help sustain the village rather than it dropping away. And then, you know, in 4 years' time, maybe it won't be sustainable to have developments like this.
Thank you. Councillor Harman.
Very briefly, I'd like to respond to that. I fully accept that villagers need to grow. The issue that we're discussing here is whether we need to grow this big in this place. And I very strongly feel that it's the location that is highly inappropriate.
Okay. Right. Okay, thank you. Does anybody want to say anything more? Say convention means yes, Ms Hawkes.
Sorry, sir. Can we just have confirmation from Councillor Harman that she's satisfied with the size? It is just the location that she's not happy with.
No, I said this big and in this place. It's too many and it's in the wrong location.
Okay. Okay, I think we've explored proportionality in some depth, and I think that's been very helpful for me. Can I just say everybody's been awfully polite and everybody's apologising to everybody else, which is very nice. But there really is, I don't think, at this stage, any cause for apologies for not knowing terminology or anything like that, or not having the immediate papers to hand, or not having written something in the past. So thank you all very much for being so polite, but don't worry, I'm not taking any offence or anything like that. I think it's a good time now, before I move on to, I want to explore a bit more about what services there are in the village and the walking distances, which is criterion B of policy HAU 5. I think now would be a good time to take a short break. Would 15 minutes be enough, or Miss Hawkes?
That would be fine, sir. Yeah.
Okay. So can I just cut that a little bit short and say, can I say 10 to 12 if we're all back for 11:50? It's 13 minutes by my clock. Acceptable?
Yep.
I will turn my camera and microphone off. So I will see you all again at 10 to 12. Thank you. I'll just wait for others to rejoin us. The song, are you there?
I am, yes, thank you.
Oh, that's okay.
Sorry, I must admit, I've got you down as a little picture-in-picture, so I wasn't sure if you were speaking just to me or if there were others involved as well.
Okay. Right, lovely. Thank you for being back promptly. I'd like to turn to criterion B of policy HAU 5 now. The site is within easy walking distance of basic day-to-day services in the nearest settlement, and or has access to sustainable methods of transport to access a range of services. Let me start perhaps with the council, Song. What is your view? What is the council's view on the accessibility to facilities and services from the site, please?
Well, in that regard, the council accepts that it is adjacent to the settlement boundary. It is policy HAU 5 in terms of its supporting text sets out a sort of guide figure by which we planning officers assess development. It's not a strict figure, but it is one that is useful, and that is a figure of 800 meters walkable, easy walking distance between the development site and the range of services. And the way we measure that is not by virtue of the proximity of the site to the development, the boundary of the settlement, but rather to the services themselves. And in this instance, we are slightly above the 800 figure for some of the facilities. The post office is nearby in the conservation area, but the pub and the, oh, apologies, I've got a phone call coming for some reason, and it might reduce my mic sound, so thank you. I'm not quite sure how that managed to get through, so I will just make that setting now. I apologize for that. And so technically, when you look at the officer report, it is just beyond the 800 meter figure. But as I said, that's not a hard and fast a number, and we take into account the fact that it is reasonably easy to walk that distance, and there is relatively easy walking access to the pub and the primary school and the village hall, and on that basis we have not raised an objection in relation to this particular matter. Criterion of policy HAU 5.
Yeah.
We do note, however, that the bus service, as with so many rural villages, is quite irregular. They do have a Monday to Friday bus service. Checking the schedule over the weekend, it suggested that it starts at 7:30 and finishes at around 6, but that's only Monday to Friday, and the first service and the penultimate service are only during term time, so it's really to deal with school traffic. So in terms of bus services, there is a bus, and it does go to Ashford Centre. But it is not of the sort where you get much in the way of regular use to go into the towns.
Okay, sorry, let me just catch up. Okay, so sorry, I understood you to say that the council was not raising an objection in respect of criterion B. Did I?
In relation to this specific criterion? No.
Yes, this specific criterion,
no.
not policy. Oh, okay, thank you.
We acknowledge that it's a little bit beyond the 800 meter rule, but in terms of many rural village contexts, it's actually reasonably well placed with regard to walkability to services such as local shops, schools, and whatnot. The capacity is another issue, as we've dealt with before, but in terms of the walkability, it would roughly meet the guidelines within this criterion.
Okay, thank you. Councillor Harman.
Thank you. I'd like to comment on the criterion in conjunction with what is considered to be basic day-to-day services, because whilst I agree with the council with regards to the walkability and the fact that this is completely adjacent to the village confines, I think there has to be a question about growing communities that are quite obviously going to be car dependent, and that in the context of the sustainability conversations that are being had right at the moment in our council, then creating car dependent communities should be something that is actively avoided, and all of us in Aldington are car dependent. The other thing that I think should be a key consideration is around energy provision, and the two larger new developments in Aldington have had LPG gas tanks installed, which I think also in considering how we develop in the future should be something that is actively avoided. The other thing is regarding broadband. Broadband is very much a basic day-to-day necessity, and every time we have new developments attached into the service, the rest of us suffer a slowing down and dipping in supply. So I think that these things all should be counted as basic day-to-day. The two shops and the post office, the shop and the post office that have been mentioned are indeed there, and some residents do shop in them regularly. The post office shop is used extensively by our older residents, but they are not anywhere near able to be your only shopping. All shopping is done from the supermarkets, and people go there by car. Thank you.
Thank you. Ms Hawkes.
So I think the important point to note here is that Aldington is a very well equipped village. It does have a primary school, it does have two village shops, including its post office, and it also has a village pub. And I think it would be helpful to you as part of the consideration of the appeal to actually go and see those facilities and see what is actually on offer within the shops. It is accepted that in terms of food shopping, that people would have to look outside, although there is, of course, the option of delivery, home delivery services that would cover the area. But as a village, it is very well equipped and does have access, residents would have access to day-to-day services. There isn't a doctor's surgery in the village, however, the nearest doctor's surgery is in Sellinge, and it is, from a recent search, still taking on patients, and its catchment area includes Aldington itself. Picking up on the point by Councillor Harman in terms of energy, in terms of the energy that would be proposed on this particular development, we'd be looking at air source heat pumps.
Thank you. Yeah, thank you. That's pretty much, I think. Yes, I will. I do intend to look at the facilities and services on offer as part of my site visit. So yes, I have that. Okay, that I think that covers. Is there anything anybody else wants to say about criterion B?
I think the only other thing I'd like to add, sir, just in terms of, and I know it's not disputed by Ms Song and the council in terms of the 800 metre, but it is important to note that in the manual for streets, that does set out that in terms of rural settlements in particular, rather than having a fixation in terms of the distance, it is more about the actual walk and the character of the walk and how easy it is to walk. And I think it would also be helpful to you, sir, in terms of doing the walk from the site to the primary school entrance, because the primary school is the furthest facility from the appeal site. And it is important to note that it is a surfaced route. There are footpaths on either side of Roman Road. They are wide paths, and it is a pleasant walk that you could do with young children. It is buggy friendly, it is scooter friendly, and therefore, you know, it's whilst some of the dwellings may be beyond the 800 metre, the character of the walk in this particular case to get to the shops and services that are available in Aldington, it is a reasonable distance to walk.
Okay, thank you. Ms Song.
So just to reinforce that point, as I noted, the 800 metre rule is or 800 metre guide is a guide, and we judge it on the basis of the nature of the particular area and the character of the road. There are times when 800 meters is considered to be too far, and so it is there just as the decision making, something to help us in terms of evaluating the sites. But I do think that, you know, the points that Councillor Harman made are very important with regard to the facilities. Aldington does have a number of facilities that are that make it slightly better equipped than some villages, and that is the basis upon which we make that judgment on this particular criterion. But again, turning to that point of whether those services are sufficient and proportionate to the level of growth being proposed here, we'll always revert back to the consideration of criteria of the proposal against criterion A of the policy. So it may be that there is a shop, but as to whether or not that shop can facilitate the needs of the village of Aldington, or the settlement of Aldington, I should say, if the development were to be approved, that is a slightly different question. And so I just want to stipulate that they are slightly separate matters, but it's for that reason that we haven't technically raised an objection with respect to criterion B, but we obviously have concerns as an authority with regard to the first criterion which we've addressed.
Thank you. Ms Hawkes, was there anything further you wanted to say?
Yeah, can we just clarify, Ms Song, in terms of that final point that you were making there? Are you saying that the shop wouldn't be able to cope with an additional 33 dwellings, or the pub wouldn't want additional business created by an additional 33 dwellings?
No, can I just? Yeah, I mean, sorry, I'll just interject here. Clearly, there's no cross-examination. That's not what I understood Ms Song to be saying. But I'll let Ms Song respond. But just as a general point, no cross-examination, please.
No, indeed, that isn't the point I was making. I make no comment in regards to the economic desires of the businesses and facilities that are taking place in operating in Aldington. No, it was just a question of the fact that we acknowledge that there are services and there are facilities within this village or within this settlement. I should say I use the word settlement instead of village because I wanted to demarcate the fact that it is a settlement as we've defined it in HOU 5 and not a village, which might not have been included within the policy. But it is unusual to have these sort of facilities in a rural settlement context, and strictly speaking with regard to criterion B, it does mean that people who live in the development would be able to walk to those facilities, but whether or not they are of a size and nature that would, that would satisfy the requirements with regard to a development of this size, of this scale, is a secondary question, which again goes back to criterion A. So it's no judgment as to whether or not they would want, the businesses would want any more potential clients. It's a question of whether or not the scale of development is proportionate to the scale of the facilities within the settlement itself.
Thank you. Probably my turn to apologise. That really perhaps wasn't moving into cross-examination. I just wanted to make sure it did, and that was just more a clarification of what Ms. Song has said. So I think, Ms. Hawkes, do you have that clarification now?
Yes, that's fine, sir. Thank you.
Okay, thank you. In that case, can I move on to criterion C? About safe access on local road network and the traffic generally accommodated, etc. I noticed there's a lot of representations from interested parties about traffic in Aldington, but I believe there are no highways authority objections to the scheme subject to conditions. Ms. Song's nodding, so I think that's understandable.
Yes, that's correct.
Okay, thank you. Ms. Harman, do you want to say anything about the traffic side of things and access particularly?
The concerns expressed by the various parties that have commented are general. As the village grows, as development encroaches from all sides, as the borough itself expands outwards, there is greater use of the rural lanes. The rural lanes are all national speed limit roads. Calleywell Lane itself, obviously at the top end, where this application is proposed, is within the 30-mile-an-hour speed limit de-restriction for the core village. But we do find, as a general rule of thumb, that because as a village we are relatively unpoliced, we do have our own speed indicator device, and we frequently have excessive speeding, both in Calleywell Lane and along Roman Road, because of course there are no consequences. As part of the neighbourhood planning, we are looking at what can be done to discourage this, but it's very difficult for local communities. Further down Calleywell Lane, there is no footpath, and as in the case on further lanes, so that if this development were to go ahead, the residents that would come to it would, if they wanted to walk a circular route, they would find that half of it had footpaths, the bit that's in the actual village confines, and half of it didn't. And the bit that doesn't, they would be being passed at 40, 50, maybe even 60 miles an hour by cars. And obviously, I'd just like to add that one of the things that adds to this is the fact that if people don't want to drive to supermarkets, they are having deliveries. And so there's an awful lot of that sort of traffic too coming in and out of our village. I hope that helps.
Yes, thank you, Councillor. It does. Thank you. Ms. Hawkes.
Just to say, sir, that the proposal has been assessed by KCC Highways, and as Ms. Song has confirmed there are no objections to the proposed access to the development as proposed. It would be the development would include footpaths, obviously the retention of the existing public right of way that crosses the site will be maintained on its same alignment, and as we have discussed in relation to the previous criteria, access to all of the shops and services and facilities within the village will be accessible from the development via surface paths, and will be a pleasant route. There are various walking and cycling footpaths and routes in the vicinity of the local area, and we've also talked about the local bus service, as Ms Song has confirmed to you in terms of what is available in terms of access to local bus services. So there is recognition within the local plan that there will be a reliance in rural areas. There will be a reliance on the private car. However, there are a network of paths and footpaths, and there are options available in terms of public transport links for this proposed development.
Thank you. I read the comments from Kent County Council Highways, and they raised no objection subject to a number of conditions. One of those conditions, I think all the others have been reflected in the conditions that we'll discuss later, but one of the conditions was that the appellant should fund warning signage and lining improvements. Ms Song, did you have any comments on that? Sorry, I rather sprung that upon you perhaps, but.
No, I don't. I had noticed that that comment within the document in terms of the documents we have on our file, but we have not included that in relation to any of the conditions or with regard to the obligations at this point. I don't think they came back with any further requirements when we reconsulted.
Okay, thank you. Ms Hawkes, do you have anything to say on that?
No, only that the appellant would have no objection. So if you feel that condition should be included in the list of conditions, if you were minded to grant approval for development, but that's something which could be dealt with by way of condition, then we would be happy for that to be included.
Okay, thank you. Okay, I think
so I should just note that obviously with regard to any signage, they would need to be approved by the council in advance in order to ensure that there was no harm given the sensitivity of the site in terms of its rural context as well as the conservation area.
Yes, I think the Highway Authority were looking for signage, I think, on the bends in Calleywell Lane, and I'm presuming there'll be standard roads, and we're looking for a contribution, but I wasn't sure what they meant exactly by lining improvements. Okay, I will reflect on that. If I impose the condition, it would take the form of a gramping condition, I imagine. I'll need to think about that. But yes, it would be the form of signage would be. I'll come to you in a moment, Councillor Harman. The form of signage would obviously be agreed by the County Council as being suitable for highways. But I just wanted to flag up that had been raised by the Highway Authority. Councillor Harman, excuse me.
I just wanted to add, sir, for your knowledge, that Kent County Council has a highway improvements plan, which is in place from the Parish Council.
Okay, and forgive me.
And hopefully there'll be some items on there that would be relevant.
Right, okay. So you're not drawing my attention to anything specifically in the highway improvement plan?
Well, one of the items was specifically about slowing traffic as it comes out of Calleywell Lane and up into Calleywell Lane, because that is a circuit that is frequently walked. And as I described earlier, only 50% of it is within a restricted area for speed. It has no footpaths.
Okay, thank you. Right, okay, thank you. Ms. Hawks, anything more to say, anything final to say on the access side? I'll come on to public transport, cycling, walking again as the next criterion, but anything on the access itself specifically?
No, I don't think so, sir. I think we've covered it.
Okay, thank you very much. Right then, good. So we move on to criterion D. The event is located where it's possible to maximise the use of public transport, cycling and walking. We've covered this to an extent already, so there's no need to repeat the points that have been made and I've noted down. But yes, just on the bus services side of things, my understanding is that there's a bus service on a Thursday, there is a school bus, and is there a weekly service once a day, is that right? But not at weekends? Councillor Harman.
Can I speak? This was a topic of discussion at a recent workshop about how green is our plan, where it was pointed out that if you want to go into town on the bus, you have the choice of either having 50 minutes between the bus that arrives in town from Aldington and the need to return. So you have the choice of either 50 minutes, in which case you can go to the bank quickly, or staying for 3 hours or longer. It is possible to get, obviously, the school children use the buses. So going to school by bus from Aldington is perfectly possible, but it's not possible to commute. So the key location from a village such as ours is into the international station in Ashford, and it is not possible to commute by bus. The other thing that I think has already been mentioned was about the footpaths. There are public rights of way. Public rights of way generally are used for leisure and not to get anywhere in particular. Again, the parish council is looking at this as part of our neighbourhood plan, but these footpaths are not practical for day-to-day use. You cannot walk from our village to the next village. You cannot get by bus to the doctor's surgeries, either in Sellinge or in Ham Street. You cannot cycle safely because of the fact that country lanes are statistically known to have higher accident rates, and they are national speed limit roads, and many people unfortunately drive very stupidly on them. So you are generating a car dependent community by building in a location such as this.
Thank you. Ms. Hawks.
So I understand there is a bus service. Bus service 125 does go to the station, and there are 6 buses a day, with the first bus at 7:30 in the morning and buses returning during the peak hours in the evening. So there is. However, the 7:30 does not go to the Ashford International Station. but it's only.
Sorry, Carl.
Apologies. It does go to Central Ashford, and then it would be walking from Central Ashford to Ashford International Station.
Thank you. Okay, Ms. Song.
The bus, sorry, the bus, just to confirm, sir, the actual bus journey is 30 minutes.
Right. Sorry, Ms. Song.
Just wanted to clarify, I too have seen that bus schedule. I don't know I couldn't tell from my online search as to whether that was a current timetable, but it sounded familiar to the hours stated by Ms. Hawkes. I would note that it's Monday to Friday only. The buses are at 2 to 2.5 hour intervals from Aldington, and the 7:30 train, the bus, and the 5 or thereabouts bus service are term time only. So they're not really, as Councillor Harman noted, they're not really designed for commuter use, given the schedule and the frequency or not, as you may wish to deem it, of the services.
Okay, I understand. Thank you. I noticed that the SLAR, and for interest party, that's Strategic Housing and Availability Assessment, refers to some local services and public transport options to larger hubs for this site. Presumably, by those public transport options, you mean the bus service that we talked about? The song, sorry.
Yes, I would assume so. Certainly at the moment, that is the only bus service that I'm aware of for Aldington. It does go to, as Ms. Hawke said, Ashford Town Centre and the International Train Station, and they would be considered the local hub. But as noted, it is a service that is Monday to Friday only, and with certain gaps within the timetable.
Okay, thank you. Ms. Hawkes, just on cycling, are you suggesting that cycling would be a likely, or obviously possible, but do you think people are likely to cycle from the site to Ashford?
I think it's not impossible, sir, and there may well be some keen cyclists who would choose to do it, but it's probably not going to be the norm, sir, no.
Thank you.
I mean, it is only the team told me here. It's only 6 miles, so it is there as an option, so in terms of a mode of transport to get you to the station.
Yes, I understand that. I think it comes back to it's not necessarily just the distance; it's the suitability of the route as well. Okay, well, I can. I don't think I'll actually cycle it, but I'll certainly have a look at the route as part of my site visit. Okay, right. Thank you for that. Is there anything anybody else wants to say about criterion D? No. Okay, thank you. In that case, then, I'll move on to criterion E, conserving and enhancing the natural environment. Now, I will conserving and enhancing the natural environment, preserving and enhancing any heritage assets in the locality. I'll deal with the heritage assets as part of my next main issue, and I'll deal with the Stodmast issue as another main issue later on. But if I just deal with the kind of the biodiversity of the site, can I start with the appellants, please? I have copies of the Ecological Survey report dated January 2018, and I've already mentioned I don't seem to have a copy of the Protected Species report December 2018. Has there been any more recent surveys than those?
No, sir, there haven't been any more recent surveys than those. Obviously, the application was submitted in February 2020, and at that point, the surveys were valid, were fully valid. Right. Have you been able to send a copy of the protected species report to me? So I haven't checked. I haven't had an opportunity yet. So
no, that's fine.
I will do it at the lunchtime break. Yes,
that's absolutely fine. I just haven't had the chance to check, so it wasn't a criticism. I don't know if it includes some caveat that it's only valid perhaps for 2 years. That's why I'm asking for it. What I need to know, and I'll no doubt that will help me in this, is whether or not there's a reasonable likelihood of protected species being present on the site.
It is farmland, sir, in terms of the actual character of the site, and clearly, you know, that's been maintained in terms of the field being farmed right up to the present, and is still being farmed. In terms of the commentary on the survey work that's been carried out, clearly you would have seen, as Ms Song has forwarded to you, the latest response from KCC Ecology, which, you know, it was obviously looking at the buffer proposed, but does also, you know, refer to the surveys that have been carried out previously and the results of those studies.
Okay, thank you. Okay, thank you for that. If I turn to Ms Song, does the council have any comments on the conclusions of the appellant's biodiversity metric? Sorry, Ms Song, you're on mute still.
I do apologise.
Not at all, we all do it.
In terms of the most recent information, we have, I mean, I'll break it down into different parts. In terms of the original application submission, the KCC Ecology or Biodiversity and Kent Wildlife Trust have obviously had a look and at the proposal and scheme. With regard to the ecological element of it, at that time they raised no objection subject to conditions, and those conditions are incorporated in the proposed conditions list that were submitted to you with the statement of common ground. In relation to the age of the protected species report, I am no ecologist, and therefore I can't speak as to whether or not there is any with any authority as to whether or not there's any propensity for any protected species to have moved in the interim period. I would note that it would be our usual practice, and I would expect our consultants to, if there was a new submission today, to have included a more recent survey, but clearly, because normally they would like to see surveys dated between 12 and 24 months, depending on the species identified. In this instance, clearly there's been a time lapse since the first application was submitted. Notwithstanding that, though, KCC did have the opportunity to come back, although we did ask them to comment specifically with regard to the amendment on the local wildlife site buffer. They had an opportunity at that point to reconsider and potentially revise or amend their comments, and they did not do so. So I will just leave it with our consultants as to whether or not the protected species information can be considered in date, and also leave it down to your discretion as well, consideration. Turning, I don't know if you want to deal with the buffer zone to the local wildlife site at this point, or
yes, if you if you have yes, by all means, yes.
well, in terms of well, really in terms of just the overall ecological impact. It had been, from my understanding, it had been agreed that a sort of buffer zone between the residential development and the local wildlife site would be necessary in order to prevent potential harm to the site. Somehow or another, various parties missed that when we were looking at this particular submission, that Kent Wildlife Trust duly brought that back to our attention, and it's on that basis that the scheme has had a kind of an amendment shown with regard to these new drawings submitted in October. We unfortunately don't have a response from Kent Wildlife Trust, but we did manage to get one from KCC, and they have some reservations with regard to the scheme, and you can see that within their comments. But having discussed it with them, we consider that if we had the time to evaluate a detailed scheme, that this would be possible. It could be a suitable mitigation solution in this instance. Unfortunately, at this point, all we have is a demarcation of a zone. But in order for the buffer zone to be appropriate and effective in achieving its aims, we would need to look at the sort of planting and management of that, and in so doing, we would take into account, of course, that these are back gardens, and there are security issues to be considered and balanced against the ecological matters. But one of the things that we would be looking for with regard to the local wildlife site buffer is information about planting. That planting ought to happen at pre-construction stage and protected during that time in order to ensure that it is a suitable buffer. And clearly there would also need to be long-term management as well of the buffer to ensure that that area is not accessed. So it would be commonly observed that when you have residential gardens against woodlands, you sometimes get gates in those gardens whereby the residents directly access the site, and in order for the buffer zone to be effective, we would need to prevent that somehow. And so the pre-commencement condition, the pre-commencement conditions that was suggested in the list recently would seek to get that level of detail from the appellant before making any decision as to whether or not that buffer, in order to ensure that that buffer zone is in fact an appropriate mitigation solution.
Understood, thank you. And yes, the conditions include a proposed condition to that effect. So that's right, isn't it? So I understand that you need the details of the planting and so on, but that could be secured through a condition. Is that right?
We believe so. In discussing it with KCC, it requires quite a lot of detail that we don't have at the moment, but we think that an appropriate solution could be found as part of that. But the solution isn't just about planting and separating and segregating the area. There needs to be more detail in terms of how it's managed when it's planted, how it's secured for future in terms of access, and what might happen if any of that, if there was an encroachment in that land. So these are all elements that need further consideration, but we think we can manage that under the pre-commencement condition proposed.
Okay. Ms. Hawkes, do you have any comments on that?
Yes, just to confirm. sir, that yeah, there have been discussions regarding the buffer zone. Clearly, it was required by KCC Ecology at a later stage in the application process. It can be delivered. It's shown to be majority of it 10 metres in width, with a very small section going down to 8.5 metres in width. But with this has clearly been agreed by KCC Ecology in the response that they come back with, but it is about the mechanism and how that can be delivered and managed. As Ms Song has pointed out, and as you have seen in the list of proposed conditions, that it is felt that this could be dealt with by way of condition to secure the appropriate planting and management of that area. Also to advise in terms of the Section 106 agreement that we will be discussing later on, that there is provisions in there in terms of the open space requirements, but also the management company who will be the ecological buffer will be can be brought in to the management company area that will be managing the open spaces throughout the development.
Excellent. Okay, thank you. Ms Song.
Just a procedural note, obviously we've had these revised drawings in October. In order to achieve the buffer zone set out in the drawings, the residential gardens of plots 20 to 25 have had to be reduced in their depth. And just noting that if it's considered to be appropriate with regard to the mitigation measure, in addition to addressing the detailed design of that, we would probably need some new drawings showing the revised plots, because when I was checking, I realized I didn't have any scaled drawings of the revised plot layouts, and so I was trying to measure out some elements of the garden sizes, for example, by just using indicative features on the drawings to work out where the line of the gardens were at the back. So I'm not sure that we've had those revised drawings. So it would be important to have those prior to any decision.
Right, okay, thank you. Ms Hawkes, do you have any comment on that?
On the buffer zone plan, so you will see that there are that there is an annotation on there in terms of the garden depths, but as Ms Song points out, if there is a requirement to also update any of the plot layout plans that have been produced, then certainly the architects are willing to take that. We'll take that away, and we can get those amended drawings to you to reflect what's shown on the buffer zone plan, and we can do that relatively quickly.
So, sorry. So I was hoping that the additional plans I referred to at the beginning, 1910_196 and 1910_197. I hope that those show what's necessary, but you're telling me
that no, they do, sir. They do show what's necessary. So those drawings have been updated in terms of showing the buffer zone and the revised garden depths for the plots affected. However, if Ms Song feels that there are other drawings where we've shown the plot layouts where that needs to be updated, then we would certainly pick that up. Yeah, the landscape plan is also correct. So those plans that you have in front of you and that you are determining the PL on the basis of have all been updated to indicate the ecological buffer and the revised garden depths.
Okay, thank you. Ms Song, what's your point? Sorry, that there were other plans.
It was just really with regard to the fact that I was just noting the landscape buffer zone is shown, and we have received those drawings, and the landscaping drawings have been shown, but obviously we've received the original tranche of drawings that were submitted with as part of the application did not show that buffer zone in relation to the residential plot layouts. So it was just a sort of aside, but an important one in terms of setting out that we would need revised plot site plans and block plans and plot plans to reflect the revised garden. So, for example, I'm looking here at the moment at the site-wide parking plan, and the gardens there do appear to extend into what is the buffer zone. So, in order to ensure consistency across all the drawings and clarity with regard to any permission, I was just flagging up the fact that those plans would just need to be reissued and revised. It wasn't meant as in any way as a criticism of the buffer zone itself. It was more about just noting that we would need a correct set of plans. So the list of plans that you've been given in terms of those original drawings do need to have an amendment with regard to the buffer.
So we have checked, it is plan 103 and 104, which are probably the plans which haven't been updated, which were submitted originally with the application, and which should have also been updated for consistency so that you have up-to-date set of plans.
113, 114 and 120. The wider site plans that would also need updated.
113, 114 and 120.
Right, okay. I don't want to get into condition side of things, but could this be dealt with in terms of the condition for the buffer zone with a kind of one of the conditions is to build in accordance with the approved plans, and then another condition talks about the buffer zone. Could that be dealt with by notwithstanding condition 2 sort of preface, or does the council feel that it really needs to have a set of amended plans? I mean, ultimately it's for my
I mean, normally we would expect a revised set of plans before issuing a decision, such that it was clear with regard to condition 2 as to what we are approving, and the fact that the gardens are shown extending up to the edge of the local wildlife site. We would normally have sought to have that addressed prior to issuing the decision, because the notice itself would contain reference to the drawings as they stand, and if there would be a slight confusion as to whether the gardens, if we approved drawings that showed the local wildlife buffer and drawings that showed the gardens excluding the local wildlife buffer, there would be a degree of uncertainty arising in that situation. So my preference would always be to get an amended set of plans. It's a relatively simple process, as long as if we're happy that the buffer zone is an appropriate solution and we can get further details on that, that's fine. But it's just really just showing the revised edge of the development as permitted.
Yes, okay, I understand that. Clearly, as a general principle, it's not the purpose of the appeal system to evolve a scheme, but I have been willing to accept the revised plans on the grounds that those who needed to be consulted should have had the opportunity to comment, particularly Kent Wildlife Trust and Kent Council Ecology, have had the opportunity to do so. I'll have to think about it, but my initial thought is that if revised plans are submitted that reflect the plans that I've already accepted, then those who would have or should have had the opportunity to comment wouldn't be deprived of doing so if I was to accept those. Okay, let's think about that, because that would bring us into, my setting a deadline for the submission of these amended drawings, and what have you. So I'll come back to that at the end, because we may well need to think about revision to the section 106. So it may be that there's going to be some matters that need resolving after I effectively close the hearing. So that would get us a set of amended plans then. So, okay, all right, I understood the point. Thank you. I do have some questions for the appellant on the biodiversity metric. How would the management and monitoring measures be secured? Please, Ms. Hawkes.
Yes, sir. The monitoring and management measures would be secured as part of the Section 106 agreement, and as part of the management plan and management company that would be set up.
Right, yeah, okay. And what would happen if the desired condition of the habitats has not been achieved? Ms. Hawkes.
Clearly there would be a monitoring system in place. So if it hasn't been achieved, then there would need to be measures, steps taken in order to address that. So that would be, I mean, that's a requirement in terms of the monitoring that would need to take place. So it would be something that the KCC Ecology and the ecologists would need to establish where it hasn't, where it is, where it has not met it. What we would say is, given what we have here in terms of the metric that's been carried out, bearing in mind the existing site and that it is in agricultural use, that the biodiversity net gains in this particular case are considerable, they are significant.
Yes, thank you. I did have a question on the biodiversity net gain report. I'm sure I'm just being dense, but perhaps you can help me with this. I don't know. Do you have a copy of the biodiversity net gain report?
Yeah, I do in front of me, sir. Yeah.
Right, thank you. In paragraph 4.3.6, it says the on-site habitat enhancement and creation results in an increase of 70.16 habitable units, percentage increase of 146.49. And then paragraph 5.32, it says the total proposed new and enhanced habitat has been, I think, has been calculated 20.81 habitat units, an overall percentage increase of 177.62%. On the face of it, can you explain, just clarify for me, why those figures differ between paragraphs 4.3.6 and 5.32, please?
We think so. This is in relation to the Western Woodland Buffer. So the second total, the total that's referred to in paragraph 5.32 includes the woodland buffer to the west, and the one in 4.3.6 does not. I think it talks about, because they refer to the calculation in the paragraph above 4.3.6, which takes into account what they have considered. Because, what do you think, Aidan?
My understanding is more of the rear gardens are now within a wildlife buffer, which increases the area, which increases the opportunity for habitat enhancement.
Okay. All right, thank you. Sorry, just catching up on that. Right, okay, thank you for that. I've covered the buffer zone point, so that's done. Right, okay, Councillor Harman.
Thank you, sir. I wanted to come back in on the statement that's been made about the management of the buffer zone, as there are other examples of this type of arrangement in Aldington, specifically in the Aldington Meadows development. And there are also examples of management companies being put in place in 2 developments in the parish, both of which are very, very strongly objected to by the residents that live in those developments, and both of which are currently in the process of residents seeking to take decision making around the management of the green spaces that surround their streets into their own hands. And I'd also like to point out that the core of the village is a parished village, and that the management of all of the green spaces is done by the parish council. So I'm not sure whether this is the right place or whether it's part of the 106 agreement, but that should this application go ahead, the best solution for the community would be that it's not a management company, but that the discussions are made with the parish council and funding provided as appropriate.
Okay, okay. Sorry. Ms. Song.
Yes, in terms of the point made by Councillor Harman, obviously there hasn't been any consideration at this stage, as it wasn't part of the proposal to look at parish council management of the open spaces. But when we get to the discussion about the Section 106, one of the outstanding matters is in relation to the open space and the management company, and one of the objectives of the council solicitor in relation to that particular section and schedule is to deal with some of the concerns that have been expressed by residents of new developments where there are management companies involved, as to the decision making and their ability to feed into that. So this is part of the discussion, in terms of my understanding of what's happening between the solicitors on both sides, as to the arrangements, because it is the council's view that that local residents should be full members of the management committee, because we are aware of the fact that where management companies are set up, there are issues of governance and decisions which affect obviously the owners of the properties financially, and we believe that they ought to have a say in that matter. Therefore, now turning to the management company with regard to the scheme, it is my understanding that the local wildlife buffer, for example, would come under the heading of the management company. It's for that reason that, but obviously these are details which we would need to agree with the appellant when we have a more detailed plan. But we would expect any sort of management plan, we would expect the submission of a management plan, and that management plan should set out things such as mitigation, as well as as any arrangements that would be in place should there be a problem with regard to the buffer zone. So we would expect regular monitoring of the buffer zone and regular assessment as to whether or not it is working in the way in which it should. As with any sort of ecological management plan, it's no different from what we would expect in many ecological management plans, where we would expect long-term monitoring.
Okay, thank you. Ms. Hawks, anything more to say?
Just to say, sir, that the song is entirely correct in that it is the section 106 that is the mechanism for securing the details in terms of the management company and the management scheme and the area covered by the management scheme. If it would be helpful as a bit of background, sir, Mr. Ralph can provide some information, perhaps now just briefly, in terms of other schemes which he has worked on and where there has been a management scheme in place.
Yeah, if I may, sir.
Yep.
Had probably about 6 schemes in the last 4 years. One scheme which has been really successful was in the Borough of Ashford in a village location. And we had quite a lot of ecology on site, so we required licences from Natural England, etc. And again, the platform of that, we now have quite a good template for setting up the management companies, and then within that we incorporate all of the relevant legal paperwork that's required, because as part of sometimes ecology, if you require licences for, say, Great Crested News, there is onward management, and for I think the first 2 years they count and just see how the family, the ecology is growing as in colonies. So our model works quite well, and it always sits in line with the 106 agreements. So it is always managed by the residents; they take ownership of it. That seems to work better because it's a bit like if you've got a house with a back garden, you mow your own lawn and you look after it. So it's a format that works, and it's a model that we have and we're used to. So if it's in the 106, we're quite happy with all of that and agreeing to it.
Thank you. Right, thank you for that. I think that dealt with criterion E as far as I'm concerned. I'm just conscious of the time. Criterion F, policy HOUS 5, high quality design. We said quite a lot about design, characters we go through, but I suspect there'd be quite a lot to say under that particular criterion. It would be good, though, I think, if we could just deal with this main issue. So I think, unless anybody's violently opposed, I'd like to carry on with this final criterion before we break for lunch. Any howls of protest? No, okay, thank you. I think having had the break earlier, that we quite haven't had an hour and a half back at it, so just noticed getting gloomier in this room. In that case, then I'd like to move on to criterion F, please, of the policy. Promote access to what? Oh, sorry. I'm on high quality design. I'm on the wrong policy there. Anyway, I've got it here. Yes, basically high quality design. Could I start with Masong, please? Could you take me through policy ENV3A and its applicability or implications for the proposal, please? Finally, there we go.
Certainly, I'm just flipping to that page. Sorry, I was on HOU 5 still, so. Generally speaking, ENV3 is the overarching policy that we look at. It's in 2 parts. In this instance, we're looking at ENV3A, which deals with the council's view on landscape matters and the visual amenities of the, in this instance, the countryside. Sorry, I seem to not be able to find the page today. There we go. So it's the overarching policy which we refer to in reference to areas of landscape character and design. We make reference there to various forms of topography and landscape characteristics. We also advise that developers and applicants refer to the guidance in our landscape character SPD, as well as the landscape character assessments that apply to the site. In this instance, we've got national, county and local designations of such. And these are detailed in both the Planning Committee report and the Statement of the Statement of Case, so I won't repeat them necessarily here. And I think it identifies that we really ought to be looking at the particular characteristics and significant features of the landscape of the site itself, and the manner in which the development can sympathetically sit within that landscape. We recognise, turning a little bit to how this informs policy HAU 5, we recognise obviously that in allowing any windfall site that there is a degree of urbanization of such, or certainly an introduction of built form in what may or may not be a green site, whether that be garden land or countryside. But policy HAU 5 seeks to build on the general sort of landscape policy framework set out in ENV3A and put it into the context of looking at how that can be assessed with regard to a windfall development in this particular. And so we accept in allowing potentially under HAU 5 development adjacent or close to the settlement boundary, that there may be some change of character, but it's about the scale of that change of character and whether that can be achieved without causing harm. And it's the council's position that this proposal falls on the wrong side of that planning judgment, in part because of its scale, in part because of its design and layout and the design of the dwellings. That's the sort of overarching view. I'm sure we'll get into the detail shortly.
Okay, no, thank you. That's very helpful. Okay. Ms. Hawks, do you, or any of your colleagues wish to say anything on sort of the approach of ENV3A in terms of assessing landscape character or criterion F of HOUS? Sorry, HAU 5.
Yes, I can take that. I think it would be worth talking you through the evolution of the proposals, if that's okay with you, because I think that gives a good kind of approach to how we've designed it. So there is criticism about the design and location and scale. But if we may just do a presentation very briefly, myself and the architect, about the design and how landscape and architecture works together, would that be okay with you?
Yes, thank you. If it's reasonably brief, I think, please.
Sure. So the original application was 80 dwellings. We reduced this down to 33. Taylor Hare are the architects, and we work together, landscape and architecture and ecology, quite closely. And we responded to a lot of the comments that were raised from the previous scheme that was withdrawn. So shall I talk through the landscape measures and then?
Yeah.
Okay, so one of the first things we did was there was acknowledgement of the conservation area to the south and how we look to kind of buffer that, and we incorporated a linear park which is between 15 to 20 metres wide, which would incorporate native tree planting and a really attractive route, improving pedestrian connections within the site. and connecting up to the existing public right-of-way network. These trees would incorporate field maples, oak, birch, hornbeam, everything that's appropriate to this area. And in the longer term, we see this as filtering views from the rear properties of the conservation area as well. So I'll pick that up within the visual assessment part when we go on to that later. Other measures that we did was to incorporate the public right-of-way in its current position as is good design, and incorporating this within a quite wide green infrastructure network. So we've got a pocket park which is adjoined to the public right-of-way, which is about 30 metres kind of wide in size and even wider in kind of east-west dimensions, taking you through from the conservation area through the development. On the other side, where you exit the public right-of-way to the north, we're incorporating an area we're calling the Calleywell Orchard. So this is an area of orchard fruit trees, which would be apples, cherries, pears, and would be a really nice nod to the local character and the fact that we are in Kent and it's part of the fruit belt. And what we've also done is use this orchard to offset development from Calleywell Lane, so it reduces the visual impact of properties as you're driving along Calleywell Lane. Other measures we've done, so we've talked about the wildlife buffer along the west, and then other additional measures are increased permeability, pedestrian permeability through the site, so connecting up from this linear park and this pocket park northwards to our what we're calling the meadow area to the north, and I think crucially, sir, another point to make is that we are looking quite closely at how we can improve connectivity throughout the site for pedestrians. So we don't just see it as, you know, improving the public right-of-way connections, but also to the wider landscape, and bearing in mind that we're proposing significant new areas of woodland planting. We see this as a significant amenity benefit as well.
Yeah, going on to sort of layout, and orientation of buildings and how we develop the layout. There's sort of, Eleanor's already spoken about the specific constraints around the site. There's obviously the conservation area to the south, which was major concern when we first started developing the proposals and making sure there was enough distance between the backs of listed heritage assets and the conservation area. We're including the gardens, the linear park and buffer, and then the proposed gardens. The back-to-back distance is around 50 metres between properties, built form. And that was always a conversation through design development about how wide that buffer should be to ensure that the proposal doesn't impact too greatly upon the conservation area, but at the same time that the proposal still adjoins and feels part of Aldington and doesn't venture off too far into the landscape. So that was a key sort of move in regards to how to lay the houses out. Beyond that as well was looking at those key views which we've referenced in the latest drawing information on drawing 211222103. Is there are views from the conservation area which, during our pre-application advice discussions, were picked up by the planning officers about how you could keep that connectivity, visual connectivity of the landscape beyond. And we've created these zones A, B and C that try to reinforce and enhance that to make sure we don't build built form within that, and where built form has occurred, it's only single story and lower in its impact and they're not visible from the conservation area. Going beyond that, still boundary treatments have been really crucial and important. So boundary treatments on the northern side of the site are all native hedgerows, they're open fences, reducing the impact of boundary treatments as it moves off into the countryside, which became a key kind of driver for the design, which is this gradation of development into the countryside. That picked up on some of the themes that were given in response from the council for the previous application, where the properties along Calleywell Lane needed to still engage with the village and still be close enough to the village. So that's slightly more dense, if you like, closer to the conservation area and the village as a whole, and then that gradation slowly reduces in its density as it moves further north and west. Further to that, just a point on density, in fact, looking at the density of the area as a whole, the conservation area has a density currently of 17.6. The Taylor Wimpey development adjacent, which a chief planning permission has been built, has a density of 22.5, while the proposed development is only 14.5, showing that actually the density of the proposal is quite loose as an arrangement anyway, and low in its numbers in regards to the developable area on the site. Which I think kind of reinforces some of the points in the earlier policy discussions we were having in regards to how many numbers should be on the site. In regards to, we feel as though we approach the design and layout of the scheme is correct for the grain and linear grain of the village development, and that kind of goes on to discussions of how Aldington originally was, and in our design and access statement we've shown how the progression of development has occurred in Aldington across the years, from what is the conservation area through to then linear ribbon development along Roman Road post World War II, to then in the last 20 to 30 years having more cul-de-sac modern developments that have now started to develop along the east side of Calleywell Lane. So that's sort of looking at that and how our development then relates to those. Then specifically, just briefly moving on into regards to the specifics of the layout and how the layout's been designed, which I feel as though really takes this scheme way beyond most residential developments that are currently being proposed of this scale, is where we did a thorough analysis of the not just the conservation area and our understanding of what makes a really good quality traditional environment in regards to the relationship of road edge, wall, fence, front garden, different hedgerows, different uses of boundary treatment. We did a study both in a number of other villages, which is Addisham, Ickham, Barham, just to name a few, about what makes a Kent village have the appeal of its historic notion. And we applied those little tricks and techniques to the design of the development. It's why, as you go through the development, there are enclosures of walls, garden walls that break down the mass of the building beyond, particular placement of hedgerows, the relationship of how you'll see the relationship between 10, 11, 12 and 13 in relation to the opposite side of the road, 32 and 31, that 10, 11, 12, 13 are pushed back away from the road edge with car parking, and then they are broken as a front line of development, whereas the houses opposite have enclosed parking with small garden walls, which are more akin to the variation that you find within conservation areas, rather than being just laid out as a traditional Taylor Wimpey scheme or modern scheme. Beyond that, you'll see the variation even more between 14, 15, and 16. The variation of the plane and front of the building varies, and opposite, again, the edge condition is different on the opposite side of the road. This results in a varied mixed pattern of development, which is much more as you find within a conservation area than it is within more modern developments where everything's just set back to certain sort of arbitrary distances to do with highways requirements. And this goes on, there's details in the buildings in regards to where there are cat slides to lower the impact of the buildings. Both number 20 as a cat slide to lower the impact when viewing along the linear corridor and close to the countryside. And also, as you proceed out into number 24 and number 27, equally larger dwellings with larger cat slides, arcing back to sort of more of that traditional vernacular in terms of the form of the buildings. So that's sort of a brief synopsis of some of the thinking which has been very in-depth in this proposal for why we think this layout is actually far beyond, and really we think could actually enhance in the long term actually the conservation area compared with actually some of the development that has occurred in the past in Aldington.
Right, okay, thank you for that brief run through. I fear that I've let it drift, it's down to me really, away from the sort of strategic landscape character that I started with into the sort of detailed specifics of the scheme. Mr. Chaplin.
Thank you, sir. Can I come back on a few of those points, just for matters of clarification, really? I think we've looking at the linear park and the dimensions of it. I think in places it seems to narrow down to less than 10 metres. So I think saying it's 15 to 20 metres wide, you might need to check that. We're not convinced whether it actually is a park. It seems to me that it's more like a buffer. It's quite narrow. It's at the back of all the dwellings, nothing fronts onto it. Not actually convinced it's a meaningful open space of adding particular value for the residents. It's hidden. Who will use this green space? It's out of view, and there's no natural surveillance and properties. So it feels more like a buffer rather than a park. I think it was stated that there was 50-metre gaps between the buildings and those in the buildings in the conservation. I think you might need to check that, because I think there's several that are within 50 metres of some of the existing dwellings there, particularly on the fringe of the site and the south part of the site. In terms of the density, I think we'd need to ourselves, or yourself would have to have a check to make sure that the densities have been calculated and are comparable on a like-for-like basis. I think there's an official way of calculating density that perhaps we need to go away and have a look at. So that's just a few points on some of the facts that were stated there. I think from my wider perspective on the merits of the layout, I think this is undoubtedly a suburban layout. It's a suburban character that bears little resemblance to the historic character of the conservation area. The pattern of development is pretty linear. It's consistent along a very engineered road that's basically designed for the efficient turning of refuse vehicles and things. It's very wide and over-engineered, nothing like the narrow rural informal lanes that run through most of the village. Yeah, the winding cul-de-sacs in elements, the layout of the streets and the highways are poorly enclosed. They sort of dissipate at the end. There's no enclosure or continuity to built form there. They just leak away, and on placemaking grounds that's bad practice. And generally the over-engineered status of the roads, as I say, the curbs, the parking spaces, the lighting, the junction radii, the amount of hard standing that's being created here. This is a very suburban solution. The street is dominated by car parking in front of dwellings, and so parking will really dominate the place. There's not that many street trees to help soften that either. So it's going to be quite a harsh environment, again, out of keeping with much of the historic character of the village. Sorry, just bear with me a second. Scale and height of the development, coming on to the architect's points about the design. I think the scale and height are considerably higher than are set on higher land in comparison to the conservation and the dwellings in the conservation area. And looking at their cross sections of the site provided by the applicant, it seems to be that the ridge heights of the new dwellings will be about 2 to 3 metres above the ridge heights of the dwellings in the conservation area. So I'd refer you to their plan to compare that. And architecturally, I think the built form is too consistent. The buildings are too consistent and quite simple in form. They're all pretty much all gable-ended buildings with 1 or 2 additional side or rear extensions, but they're all largely gable-ended, whereas in the village there's lots of hipped and half-hipped dwellings, so it's quite different in the overall roof form. But the overall detailing appearance fails to create a rich variety and complexity and quite decorative elements that are typically found in the original parts of the village. So there's quite a few shortcomings in both the layout, the design, the relationship between buildings and open spaces in our opinion. Thank you.
Thank you. Beginning to wish I'd stop for lunch, but Ms Hawkes, sorry, Councillor Harman. Can I take Councillor Harman first? Ms Song, now I'll come back to Ms Hawkes. Councillor Harman.
I thank the officer for the summary, which I think encapsulates the view of the residents. This is an urban design. It looks like an urban design. It will feel like one. And I wanted to come back on the question of density, because I wonder whether the woodland is being counted as part of the density calculation here, which you know, that's not the perception that one has when you go through a development. The density is what you see and feel when you're standing in the middle of the built form, not taking into account any other part of the area. With regards to the development that's taken place already, you know, we really are trying through the neighbourhood planning process to actually stop the installation of urban designs in a rural environment. And one of the things that we have undertaken is a design guidelines exercise, none of which came up with buildings that look like this. The key characteristic of our community is actually ragstone. We're a former ragstone quarry. If you look at the conservation area, if you look at the oldest and the heritage buildings, they're all ragstone. So the design itself does not speak to the people that live here. The other thing is very much about the landscape character itself. One of the key viewing points is from that top corner at the top end of this site as it faces on to Calleywell Lane. That is the field entrance, and that is where you have the expansive view that goes diagonally across this site. That is the open landscape character that we are used to, and that we're really trying to protect here, because there are so many places where it has been eroded. And so through the neighbourhood planning exercise, we are hoping that we can put policies in place. And I know you can't refer to them at the moment, but I really appeal to you, sir, to consider when you come to your site visit, stand in that place, look across. When the applicant was looking at their vision lines, why did they not stand there in that corner and design the street accordingly? There is no concession here to the open landscape character that this application proposes to replace.
Okay, thank you, Councillor Harman. Ms Hawkes, I was waiting to see if any hands went up, but Ms Hawkes. Sorry, Ms Song, I thought, yes, I did, yeah. Okay, sorry, Ms Hawkes, if you can just hang on for a minute. Ms Song.
Sorry, I put it down because I knew you'd acknowledged it before, so rather than letting it stay up. I think there are a couple of points at the moment Councillor Harman has drawn us back out to the wider landscape consideration. Thus far, there's been some detailed consideration of the actual design of the scheme itself, and notwithstanding the comments made on both sides, I think one thing I'd like to re-emphasize, and that's been clear in the officer report and the statement that had been previously submitted, is that the landscaping, whilst we always appreciate the insertion of green space and around and within developments, there is a sense from officers that the green space is mainly there to hide the development, and that it's not that well integrated within the scheme, because at its heart the landscaping is there to mask the scale of the development that's going on behind the site. and that's something that has been voiced in the council submissions and details thus far. Now, having regard to the development of the village towards the east side, the settlement to the east side of Calleywell Lane, it is important to note that there is a sort of chronology there as well, and that that the development that was permitted, Wheatfields to the east, was an allocated site. We allocated it for, we estimated and hoped that we would achieve a growth of figure 40, and that is what has been delivered. That has been built in the last sort of 5 years. Looking at the history of the site as well, that site was in effect an infill site, because the extra care facility, Quarry House, to the north of that was erected prior to the development itself, and therefore its context is very different. It's also not, it's also, and therefore it was sort of within, to an extent, the built confines of the development or of the settlement itself. In this instance, we have a field at the edge, at the western edge, and at a very important sort of a gateway into Aldington. It's an area which has been identified on a number of counts as being important for its landscape value, and that landscape value has two sides. Obviously, there's the area, there's the issue of the conservation area and its setting. But also there's the issue of the contribution that openness to the field makes in terms of appreciating the ridge and the views through and across. And when you go to the site, you will see that even from Calleywell Lane, there are breaks in the hedge. Whilst there is hedging along that boundary, there are breaks in that hedging, and you get a real sense of the rolling hillsides and beyond the field. There is obviously some degree of woodland to the north and the west, and that does provide some sense of enclosure, but the views are there at the moment, and it's the loss of this type of view and that type of setting which is important. And I think in terms of the scale of the development, it is at the edge of the settlement, and we've acknowledged that it may be sustainable with respect to the 800-metre guidance, but to insert a development of this density at what is the rural boundary of the settlement, we believe would be harmful in terms of the landscape and visual amenity of the area. We appreciate that over time, the landscape buffers in the form of the orchards, etc., might minimize the impact, but that doesn't mean that it's overcoming the harm in terms of the visual element. But there's also the other side of there's also the other element of inserting this sort of what my colleague has rightly referred to, I believe, as a suburban form at the edge of what is a very or adjacent to what is a very linear conservation area. And so I don't think that whilst the development has been designed around a linear access road, I don't think that it doesn't appear when you look at the overall pattern of development that's visible in this section of Aldington, that it reflects that sort of that it's complementary to that sort of pattern. I understand that there is the development on Wheatfields, but when looking back at the reports in relation to that site, when we considered that that development, we were aiming for high quality development, certainly, but we considered that because it was away from the conservation area, it didn't have. We could accommodate a certain degree of variation from the form and style of dwellings that you see within the settlement itself. But I think in this context, when you have the conservation area and a very, very distinct linear pattern visible there, that we need to say that they are very different contexts, and therefore that one can't necessarily equate what's happened on the east side of Calleywell Lane with what we might deem to be acceptable on the west. Because, as I say, with regard to the pattern of development, we had the Select Close development come in with 16 dwellings, which again was permitted as local needs housing. We had the extra care housing set at the higher ridge end, which has drawn some criticism today, and the Wheatfields development infilled between those two sections. So I think that the evolution of the village and the site context is very different, and it's on that basis that we consider that this edge of village, edge of conservation area site is so critical. And whilst over, the policy might allow for some form of development of the site in terms of some of the other criteria, what's proposed in front of us today is just doesn't fit into that context suitably.
Right. Well, thank you all very much. Ms. Hawkes, just to say that I will obviously be making my own judgment on these matters when I visit the site. So I've taken all the points down. Ms. Hawkes, as having the final word, is there anything you wanted to add?
Yes, I think we've got a couple of members of the team here who would like to just add some final points to that. So, Eleanor.
Yes, so much to say in terms of coming back with regard to the comments that we made on the design. But I think that, fundamentally, in terms of landscape character and views, I would just like to make the point that no matter what the councils say, the baseline is what it is. We have the extra care to the east, we have the Taylor Wimpey site, we have residential development east of Calleywell Lane, and that forms part of the approach into Aldington. We see that our development sits quite sensitively within this wider context, and I think that whilst I appreciate that there are glimpsed views from Calleywell Lane across the site in certain positions where there are breaks in the hedgerow, the actual containment of the site is quite high visually. So it is quite visually contained, and that is because we have woodland to the west and to the north. So what I can do is talk you through some of the photographs which might be quite useful for you.
Sorry, I'll be looking at this myself during part of my site visit. So although the photographs are helpful for me to get an understanding, and I've looked at the photographs in the landscape and visual impact assessment, I'm not sure that going through them on a small screen in front of me is actually going to add anything to what I can see for myself when I visit the site, hopefully tomorrow. Do you think it will add something?
Well, that's fine if that's what you'd prefer. What I would say is just I think I would like to make the point that we are looking towards Aldington from much of the wider landscape, and what you're seeing is a wooded ridge line. So I in the character assessments it talks about wide open views from the ridge line to the north, for example, but what it doesn't do is a more nuanced approach in what is actually happening in Aldington. And I think if you've read our rebuttal statements and you've possibly also read the report by LMS, Land Management Services, that was done originally on the original LVIA, which agreed with a lot of our points that yes, there is these wider open views, but as you're coming into Aldington, this does change. It becomes much more visually contained. You don't get views out from the conservation area, for example, and where you do get views out from the site, they are a kind of limited corridor where there is a gap in hedgerow looking northwest. So you'll see that on site yourself, but that's just to signpost you, if I may.
Okay, no, thank you. That is helpful.
And then in terms of the wider character, we have these woodland parcels They are an important resource locally, and you know, we're incorporating another 6 hectares of woodland here as well. So whilst we're looking at this scheme and we think this scheme is a great scheme on its own merits anyway, in addition, we're also proposing all this additional new woodland. So that's, you know, massively increasing the habitat value, addressing carbon sequestration, it's improving soil quality, all the things that we've listed within our addendum, which I probably don't need to talk you through again. But there are some real benefits to the scheme that I don't think the council have really engaged with.
I would also like to just interject as well in regards to what has been said in regards to the layout of the scheme. I'd actually say that the figure ground of the south side of the access road is very similar to the figure ground and density of the conservation area. And then, as I said before, it reduces to the north side, and as it goes out into the landscape, where all the properties are effectively detached or semi-detached. There's no overarching sort of terraces, etc. when people have been saying it's urbanised. There's a huge amount of green landscaping. Where possible, we're using different surfaces, road surfaces, shared surfaces, to break down that feeling of too much of the highway, so that actually in its nature it feels really rural. And that takes me on to the housing, really, the houses and the design of the architecture. It's during the design development, as you'll look through the design act statement, you'll see kind of quite a key aspect is how Aldington originally was a collection of farms and farm buildings that set in their landscape, and the architectural approach brings together agricultural forms and buildings with houses, with conservation areas and more traditional house types. And we've done this successfully in a number of locations elsewhere, in conservation areas, in the A1B, where this type of architecture has come together and has actually been really, really successful in the outcome of that architecture, in the design. So yeah, I was sort of coming back on some of the points to do with this feeling suburban. I would say it feels more, we tried to approach it to make it feel more agricultural in its nature, more of the countryside in its rural setting. And I think page 32 of the design and access statement, the visual, looking back into the development from the north, really kind of captures that and shows that in regards to the boundary treatments and how the buildings and architecture sit. And also, as we've stated, we are using and proposing to use some ragstone walling, just to come back on that point, throughout the site.
Okay, thank you. Right.
So I think there was just one final point that Mr. Ralph wanted to make, if that's okay.
Tim covered mine.
Oh, yeah. Been covered. Yeah. Sorry, apologies. It's been covered.
Okay, right. Thank you. I do have a couple of questions before we break for lunch. I think we've covered a few of them. Can I just check with the council, please, Ms. Song? Do you have any comments on the conclusions of the appellant's landscape and visual impact assessment and the addendum? Do you have any comments on the viewpoints and the views that are being selected in that? I'm just looking to see what I need to see tomorrow, and I've already picked up Councillor Harman's point about viewing from the northeast corner.
Sorry, I haven't quite got the actual document in front of me. I think generally speaking, there isn't much more to say. We've addressed the landscape elements on a number of fronts, both through our various reports and in Mr. Howson's letter. I understand that the landscape consultant doesn't consider that we've taken those points on board. I would disagree. We do see and understand that there is some mitigation planting being put forward, but I think our assessment as to the successfulness and the effectiveness and the appropriateness of that scheme and strategy, we come to a different conclusion. And so I believe that those elements have been adequately taken into account.
Okay, so sorry, the actual question was, did the council have any comments on the landscape visual impact assessment and addendum? And it would appear not. No, okay.
I don't think it added a huge amount to what had already been said previously.
No, okay. Fine, okay, thanks. So I can use that as a basis for my my site visit tomorrow. Okay. One thing I wanted to explore, and hopefully fairly briefly, there's a lot being said about the visibility of the proposed development, but does visibility equate to harm? That's the kind of philosophical concept, really. Ms. Song, you're shaking your head.
No, I don't think so. It's about the proposal proposal in front of us. So I've already acknowledged that in policy HOU 5, there is, although we have criteria there in relation to the impact on the natural environment and the character and appearance of the area, the policy in itself is one which would allow for the insertion of development outside the settlement. So there is, to an extent, an acceptance that the character of that plot within which the new dwelling will be erected will change to an extent. The question is whether or not that change is sympathetic to and appropriate to the landscape and character of the area in which it's inserted. And it's the council's view in this instance that that balance hasn't been achieved.
Okay, thank you. I will give Ms. Hawks and her team the last say in a moment, but the council's talked about the entrance to Aldington, and this being one of the entrances in their evidence. So the proposals include a community orchard and a landscape buffer zone to the north of the development between Calleywell Lane and the development. What the council consider to be, if they consider that to be inappropriate, what will the council consider to be an appropriate entrance to the village?
Sorry, just unmuting there. I don't think I can set out a proposal, but that's not my remit here. However, I think that whenever we have edge of settlement development, we would like to see that edge of settlement development reflect that situation and character. So we would not wish to see necessarily an extension of the urban area outward, but something that is a bit softer in terms of its density, layout, and visual impact. So in other sites in and around the district, we would like to see perhaps less dense, more planting, and these sort of elements. I think in this particular instance, we have a highly visible site. It's one that is on a ridge, and therefore there are long-term long views as well as short views. But in terms of, we would like to see in this instance something that reflects better the pattern of development that we would expect to see in this sort of village setting, this rural countryside setting.
Okay, thank you. So I will bring the appellant in just a moment. I did pick up on the zinc cladding for some of the proposed dwellings, and the kind of rationale behind that. Clearly, that's not considered appropriate by the council and indeed by some interested parties. Could materials just be addressed through a condition if I was minded to grant permission? Could it be dealt with that way?
Is that a question directed to me?
Sorry, it's my fault. Yes.
No, no, that's okay. I just wasn't sure if it was directed to the appointment
that's
myself.
fine. I can make it clear.
In theory, yes, provided you're happy with the overall design of the buildings themselves, and consider that an alternative material would be appropriate, or could make the building appropriate. In other words, because as my colleague Mark Chaplin noted, he had some reservations about the design itself. But if you were happy with the design, but perhaps not the material, then certainly that could be something that we would look at in relation to a condition.
Okay, thank you. All right, that was that. Very nearly done. I did notice that Kent Police had a number of comments on the layout. I'm not sure if those have actually been addressed at all. Masong, did you have any comments on that?
No, I do note that the Kent Police comments were received, and we did have some consideration of those in previous reports. It hasn't been considered by the council to be a reason to warrant refusal specifically on the security issues. Some of those issues could be potentially addressed by condition in relation to the landscaping, detailed landscaping design, and the type of planting between the houses and the park buffer, whichever term you wish to use. And on that basis, we haven't raised an objection.
Okay, lovely, thank you. Right, Ms. Hawkes, would you like to wrap this up for us, please?
I will do my very best, but I know that there are several members of the team here who would like to help with that wrapping up. So if I could first turn to Tim Allen.
Thank you. So mentioned ancient settlement development, and my ears pricked up because obviously I'm an archaeologist. I'm very interested in ancient settlement development. That's what I do. You're going there into the whole area of heritage, obviously, and the point about heritage, it's a tricky business, which is why English Heritage changed their name to Historic England, because they didn't know quite how to define it. But it is complex, but it's a work in progress. You've put your finger on it when you said ancient settlement development. In other words, they were in the past and they continue and they go into the future. Now, one of the things that we try very hard to do is avoid an essentially nostalgic approach to the whole thing. And I do sense this during this whole hearing. Oh, if only we can go back, if only things could be as they were, new people, new things. I felt this very much with the reaction to the proposals of the development. I thought when they say urban, what they really mean is contemporary, because things have changed. Houses aren't built as they were built before. Houses never have been built the way they were before. This is the way settlements develop. This is how they keep alive. And so I felt that the whole thing was backward looking, as if we can stop time, as if we can make things as it always were. Bear in mind that this site used to be a quarry site. It was used as a landfill site by Ashford Borough Council until 1974 for inert domestic waste. It's classified by the environmental agents as historic landfill. So this greenfield site wasn't a greenfield site, it was once a brownfield site. Now it's going to change again. The village will change again, it will develop, it has to. It can either develop or it can die. And so I felt very strongly that there was a sort of, oh, I have to say it, not in my backyard thing going on here, big time. And so that's what I'd like to say.
Okay, thanks, because it was veering off what is actually helpful to me.
Yes, I understand that. I apologise.
I understand you feel passionately about it, but like it or not, there is requirement within policies and national planning policy to respect local character, and that reflected both in terms of the form of development, the layout of development, and the design of the development, and that's the things I got to look at. So anyway, Miss Hawks, any others from your team or
yes,
yourself?
Just coming back on the landscape character points that have been raised.
If I make 3 points, the first one was the criticism about the linear park. So I would just like to kind of point you, when you're on site, sir, you may see people walking up and down east-west along that boundary, and we saw that as an existing design line which we have incorporated sympathetically within the scheme and respected it. So that's one justification for the linear park. The second point, I think Ms Song said that the scheme needed to be less dense with more planting, was when you asked her how the scheme could improve. I mean, the density is as Tim has said, lower than what's in the conservation area, and more planting. I mean, it's an extremely green scheme on the basis of it, and we've got significant amounts of trees within the scheme, and also bear in mind the new woodland mitigation as well. And the point about being highly visible on a ridge, which Ms Song said, yes, it's part of a ridgeline structure, but it is not highly visible. So if I can point you to a couple of the views when you go on site, you will see that the site itself is not highly visible. It's very well contained, and this was a point that was agreed by LMS when we first did the original application. So you will see the structure of Aldington from the various viewpoints within the area, but you'll see a wooded ridgeline structure. You do not see the site. So I'd just like to make that point. And then the final point is about the officer's comments, the latest officer's comments. So Paul Hawson, and we were just slightly puzzled with what he was trying to get at, because I felt that he was acknowledging the beneficial effects, but then saying, well, they're not that relevant because they'll take so much time to establish. But I think you shouldn't be looking at it in that way. Woodland is an important resource and it takes time to establish, and that's why it's so valuable. So to just dismiss it out of hand because it takes too long to establish just doesn't seem a kind of logical approach and position to take. Unless I've misunderstood what the council was saying there. Thank you.
Okay, thank you. I think I've have enough from the discussion. I will give one last opportunity for any party to say anything final. I mean, say convention is that I have to go back to the appellant for the final word, but Councillor Harman.
Thank you, sir. Just very quickly, from a visibility point of view, I'd just like to also point out to you, when you come to visit the site tomorrow, that whilst not taking your eyes off the road, obviously from a safety point of view, you look as you're coming in off the A20, because the landscape actually falls into a deep valley coming down off the A20 into a valley and then back up Calleywell Lane. So it is visible. It's visible from the other side of the valley. It's visible at every time we go in and out of the village from this entrance, and you will see that for yourself.
Okay, thank you. Yes, I will look carefully. Yes, I'll make my own judgments on that. Right. Well, I'm sorry that took longer than I anticipated. But on the other hand, I think that's been very helpful to me. I propose now to break for lunch, and then move on after lunch to the effect on the setting of the conservation area. Again, there may be a little bit of overlap with what we've already done, but hopefully we can avoid that. But are we all okay to break for lunch now, Ms. Song?
Just very quickly, it's more of a technical procedural matter here. I need to move meeting room. I'm currently at the council's offices. I get chucked out at about 4 o'clock. So I was just hoping that we could perhaps take that into account with respect to your break times, because I will need to move rooms. It's not a big process, but I just have to move a floor and to another side of the building. So I was just hoping I could ask for a little bit of a consideration as to potential break and time measures.
Okay, thank you. I made a note of that, but do remind me if it escapes my mind in the excitement of the discussion. In that case, then, can we break for lunch? I normally break for an hour. Oh. Sorry.
Sorry, sir.
Sorry, it was just to help you, sir. In response to the councillor's comment, if you do want to look at views across the valley from the north, do have a look at viewpoint 7. So that's along a public right of way, and you will see the cross valley views. You will see what we're talking about in terms of this wooded ridge line and the fact that the site is very well screened. You do see the extra care apartments to your left.
You see that happen. You see some of the houses on the ridge line currently, but that's one of the reasons we tucked all our buildings into the southwest corner as much as possible, so that we didn't encroach out into that view corridor when viewing from the northwest.
Okay, thank you. Right, sorry, I was saying that I normally break for an hour for lunch. Could we make it 45 minutes? Would that be sufficient for everyone? I am keen to try to keep moving as rapidly as possible, so at the same time making sure I have all the information I need. So could we say 1:45 to resume? Sorry, 2:45 to resume. Does that make sense to everyone?
Yes, sir, that's fine.
Yes, sir.
Okay, lovely. Right, thank you very much. So I have to turn off my camera and microphone, and I shall leave the room. Find the cursor. Right. Well, welcome back, everyone. Thanks for being prompt and on time. That's very helpful. I'd like to move on now to look at the effect of proposed development on the setting of the Aldington Claphill Conservation Area. Before I do, was there any further thoughts arising from this morning's discussion that you feel you must impart to me? No? Okay, that's good, thank you. Okay, so looking at the effect on the conservation area then, Ms Song, if I could start with you, could you please briefly explain the significance, character and appearance of the conservation area, if that's within your remit, please?
Yes, sorry, there was a message popping up on my screen as I tried to unmute. I think one of the, as Councillor Harman mentioned, there is a historic character in terms of the architectural appearance of the dwellings. I think in this particular instance, we have a very tight conservation area, really centred around the junction of Roman Road, Bank Road, and I think it's Frith Road. And one of the key characteristics with regard as relevant to this particular application is its setting within the context of open fields and countryside. So whilst there has been development in Aldington, much of that development has been taking place to the west and the east, but in particular to the east. And as such, the setting of that conservation area has been preserved very much over time through circumstance in part. And whilst it's not the council's intention to suggest that that historic settlements must remain in their past form, we are concerned that one of the key features of this particular area is its openness. And the fact that it is that the historic pattern of development is visible from the surrounding area, through the field, from the footpaths, from the roads, and that a development of this scale would be harmful to that historic setting.
Okay, that forgive me, that didn't really answer the question. The question I was asking is, what is the character and appearance of the conservation area? Obviously, that's what I have to look at. I mean, the statutory test doesn't apply because it's not in the conservation area, but the framework, National Planning Policy Framework for interested parties, is still relevant. So what I'm looking at is for just a snapshot of your understanding, the council's understanding of what the character and appearance of the conservation area is. And I see Mr. Chaplin's come online, so maybe he wishes to take this.
Yes, thank you, sir. Yes, I think if I just quickly recap what the character of the conservation area is, I think on the north side of the conservation area, on the north side of the street, it's a little bit more constrained. The development, the pattern of development is a little bit more consistent and encloses the street scene. Whereas to the south of the conservation area, there's bigger houses, detached properties in bigger plots. So it's a slightly more informal sort of character to the south. So the housing along the north edge is a little bit more consistent in terms of their proximity to the street. Some are set back, some are set forward. So it's quite an interesting character there. There's some glimpses and gaps between buildings of the countryside beyond. That's key. As you move along the street, you'll see glimpses to the higher land to the north, and also some quite very interesting views and vistas to the south. And part of the character also of the conservation is some street trees and lots of soft hedgerows, some informal elements with quite a lack of curbs, quite narrow lanes, sunken lanes, quite a rich sort of character in the street scene. But actually the key part is the countryside actually engulfs into, it extends into the conservation area, and there's some elements where the greenery sort of fills in the gaps between properties very much. So there's a lot of softness and a lot of rural informality mixed in amongst the dwellings. So I think that sort of encapsulates the main sort of elements of the conservation area. The road is set in a dip. It's an established, a long ancient route, a Roman road, and that quite interesting dip in the landscape in the street, and the juxtaposition of the buildings with the junction is also quite an interesting part of the character.
Thank you very much. Obviously, I'll give Ms Hawkes or probably Mr Allen a chance to come back in a moment, but I'm looking at the conservation area assessment, and that I think dates from 1995. Presumably there's hasn't been an update to that. I've got the latest version, have I?
No, the council is in the process of updating a number of the conservation area appraisals, but that hasn't taken place with respect to this particular area.
Okay, thanks. As long as I'm looking at the right one. The appraisal describes the conservation areas basically inward looking. Unless you can draw my attention to them, the sort of this penetration of the countryside into the conservation area and the views out. I mean, obviously the views to the south wouldn't be affected by the proposed development. So is there anything particular in the conservation area character appraisal that you would wish to draw my attention to, Mr Chaplin? Okay, Councillor Harman, I see you. I'll be with you in a moment.
Okay. Sorry, I was on mute there. Apologies.
Okay.
It's the gaps between some of the buildings that are important, where you glimpse the countryside behind. I think that's very important, and that happens to the north as well as to the south. There are several points along Roman Road where you can see the glimpses of the higher land behind, and you see trees and the woodland behind as well. That interesting relationship between the buildings, the landscape and the woodland is something that you really appreciate on site, and I urge you to have a look at that tomorrow when you're there. But also things that stand out, perhaps I should have mentioned it earlier, is the rich mix of materials we've got. We've got ragstone and we've got timber weatherboarding, clay tile hanging, really high quality roofscape materials, and a variety of different roofscapes and roof forms as well. And as I was saying, you've got smaller properties on the north side of Roman Road set in small plots, but you've also got some bigger properties to the south, so some bigger landscape plots as well. So there is sort of a diversity and a richness and a distinctiveness within that element of the character of the conservation area. So I think on the south side of Roman Road, the countryside does extend wide up to Roman Road, slightly different on the north side, but there are very clear gaps that you can see, and you will see the development behind on this site. Thank you.
Okay, thank you. And just to perhaps seeming to labour the point before I go to the appellants, what contribution does the, sorry, Councillor Harman, I haven't forgotten you, what contribution does the site make to the character and appearance of the conservation area? Is there anything more you want to add, or?
I think if I were just to add one element, and that is that the conservation area appraisal does talk about the contribution of green spaces and the importance of that there is a sort of a break between the residential development and the countryside beyond, and I think that it's that sort of general setting with regard to in terms of the historic development. We have the conservation area itself. But it's important in relation to its setting within the open countryside. And when I note that we had some informal discussions internally before my time here, but I I have seen them with regard to the contribution of the gardens, for example, to the rear gardens of the dwellings, in terms of ensuring that the development pattern, that they sort of reinforce the conservation areas sort of general setting with respect to the road. And so I think there is an element to which the conservation area can't be entirely abstracted from the wider sort of open space around it.
Okay, thank you. Councillor Harman.
Thank you, sir. The conservation area is situated on the apex of the ridge that forms a key part of the landscape character, and it is, as the name would suggest, one of the areas in which we have some of the most traditional buildings, which we have been accused of being backward looking rather than forward looking. But it is one of the concerns locally that there is a distinct clash because of the close proximity in the design that is proposed, the materials specifically, and the clash with the conservation area and the key character of that. One of the things that we are hoping within the neighbourhood plan that we will address through our design guide is to actually try to continue a local vernacular through design guidelines in order to stop in order to prevent the erosion of the rural character and the village character of our community. I do recognise that there is often a pastiche interpretation of what a country house may or may not look like, but the reality of the country homes, the farmsteads, which is what this community was originally, is encapsulated in this conservation area, small as it may be. It is precious. In terms of the gaps and views through to the countryside, I'd like to draw your attention to the fact that the public right-of-way actually comes out down the side of the post office shop. So it is a route that's used frequently, and through that pathway that you then come out and off the built area and straight out into open countryside, the views of which are also very open at the moment and can't possibly be if this area is developed. So I think that there are distinct glimpses of countryside from within the built confines, but most significantly, just ahead of the conservation area, it is the view that I have mentioned several times, but I'm sorry I can't labour too much how important it is from the top of Calleywell Lane. So most of the rest of the development has been infill over the years, and it has been one property at a time, whereas right now we're talking about quite a large development in the eyes of a small community such as ours.
Thank you, Councillor Harman. Okay, perhaps yeah, let me ask Mr. Allen, you might have some thoughts on this. Is that right? Or Ms. Hawkes?
Sorry.
Okay.
Okay. Sorry. Can you hear me?
Yes, you were breaking up a little bit, but if you can move perhaps just a little closer to the microphone, that might help. That's all right.
I'll speak louder.
Oh, thank you. That is helpful, honestly. Thank you.
The conservation area is interesting, and it does represent the core of the Clap Hill development. The clue is in the name of the oldest building, which is By the Way, which suggests that it was the only building you know, you could identify it because it was the only building by the way presumably being Roman road. That dates to the middle part of the 1500s. It's probably the farmhouse around which the development clustered. Eventually, as basically as a roadside settlement. Most of the other two listed buildings, grade 2 listed, are mid 18th century. I'm unsure as to when the development site as proposed is an old quarry site, as I mentioned previously, and it's it was then reused as a landfill site, but in, I think it was 1798 in the OS map, it's even there, it's described as the old quarry. So it's likely that the development formed, the origins, if you like, of the settlement are to do with quarry workers and people servicing the quarry. So there's in terms of heritage and landscape, the two are quite closely linked to that extent. But like all these, as I mentioned, probably ad nauseum, these settlements change through time very rapidly. Interestingly, there are only a couple of 3 old houses in the conservation area. All the other houses are actually modern to the east and the left and the west, which I think I just see that as part and parcel of the way village life changes through the years, you know. That's all. Those are my thoughts.
I might just pitch in regards to a little bit to do with the conservation area, and I think some of the points were already raised, but our analysis certainly would follow that of the report you stated that was is inward looking in regards to the conservation area assessment. And in fact, when you arrive, when you're on the junction of Calleywell Lane and Roman Road, and you look west, it's quite clear how at that point the density increases, the lane narrows, the lane drops away into a slight hollow as you move into the conservation area. And at that point also is where boundary conditions, as I discussed before, become rich in terms of their texture, their nature, their how much they vary from one property to the next. And that analysis we did of that boundary condition is what intrinsically informed the proposed development, and all our boundaries and setbacks of our proposed development stems directly out of that found condition within the conservation area. As you move along that conservation area, on the north side, it is more densely packed with houses in more of a terrace arrangement, though at different setbacks. There are the odd glimpse through, as previously stated, to the countryside, but it's really just the tops of trees that you can see in the distance, not real expansive views. And then that feeling of enclosure and inward looking kind of increases when you look along Firth Road that leads to the south. That lane is even narrower. There's no footpath on either side of the road. It's got dense hedgerows either side, just allowing the peaks of roof lines to stick up and pitch out and appear above those hedge lines. So it does feel very enclosed in its nature within there. And at the same time, you'll always find is that the road is quite considerably lower than the houses on the west side of Firth Road. So there is a big variation in topography as well. And you could say that if you were in the houses down Firth Road, that the houses on the north side of the road are quite a lot higher in ridge height than the ones down the hill. And in a natural way, the topography in a rolling landscape does alter and change. And it does increase as you go to the north from Firth Road, but equally the actual apex of the ridge line is much further to the east, is the actual highest ground locally. And equally, it's sort of one point is that the northern houses, their gardens dig into the bank behind, where the ground rises to the north, and the likelihood is those houses are hunkered in there on the south side of the ridge line, protecting themselves from the worst of the elements to the north. So yeah, it's kind of an interesting little hollow how those buildings come together in their dense nature, really, and it's really varied. And as mentioned, the materials are varied, from the ragstone to the red brick to the timber cladding, and the tile roofs, all of which we're proposing to use on the proposal. So yes, I think our proposals do stem directly out of a thorough understanding and analysis of the character of the conservation area.
Okay, thank you. Councillor Harman.
I'd like to just come back and maybe bring your attention to the fact that the oldest buildings, apart from the hall houses, the farmhouse that have been mentioned, are all rural cottages of a terrace nature. So they're small and they're very, very linear. And if there was to be an expansion of the conservation area, I would expect to see that in terms of bordering a street, rather than the cul-de-sac design that we have here. And when you visit the site, as you come to the top of Calleywell Lane and you look to your right, you will see that there is a row of terraces that have been built in a red brick and clay tile hung manner that are widely regarded as well designed in the village and well fitting in that area, and do complement the existing building vernacular.
Sorry, could you just repeat exactly where that was again, please?
It's there's a row of cottages.
Yep.
Just to your right as you turn into Roman Road. It's on the opposite side of the road. They have various herbal names, and they're a modern build.
That's okay. Yeah.
But you will see them if you stand at the top of Calleywell Lane and look to the right.
All right, lovely. Thank you very much. Look out for those.
Oh, excuse me, sir. Can we just come back on that?
In regards to the properties along the north side of the road, they are small little cottages, and I'd just like to say that in our proposal along the southern side of our proposal, there are a number of smaller 2-bed houses in that arrangement where they are held close together in semi-detached or terraced form along the southern side in relation to the grain and the density of the conservation area. Their unit numbers 18, 15, 12, 11, 8 and 7, 3 and 4 are all 2 beds, and then adjacent to those they are all 3 beds, still remaining small, whereas we have placed the larger 4-bed dwellings to the north as the density degrades into the landscape.
Okay, thank you. Mr. Chaplin.
So I just wanted to add one final point to what the character of the conservation area is. A key part is the approach along the footpath over the top of the hill into the conservation area. That approach, that impression, the views you get of the buildings and the landscape and the woodland is really key to the character of conservation areas. The approaches into the conservation areas are always an integral part of its character, and I think that footpath is one of the most impressive sort of approaches you can get. The angle of the footpath and its openness and its direct connection into the centre of the conservation area is quite important to its character. And the housing just to the south of that in the corner of the site, I think that's on the highest bit of land on the site as well, so that's going to have quite a visual impact there where that cluster of homes are. Thank you.
Yeah, thank you for that. That you reminded me actually that one of the things I was going to pick up was the again, going back to the conservation area appraisal, it actually refers to an unsightly view from the public footpath. That seems to be perhaps a little bit at odds with what you just said, although character doesn't equate to quality necessarily. So do you have any comments on that part of the appraisal, Mr. Chairman?
Sure, yes, thank you. Yeah, I think that was written in the mid-90s, I believe, so sort of 20, 30 years ago. I don't know if it's changed dramatically in that time. Maybe it has, maybe it hasn't. I think at some point there was quite a lot of domestic paraphernalia that had crept in, perhaps along that edge, which I think it hints at was sort of slightly degrading of the setting. I think that's pretty much gone now. I think the landscape and some of the mature trees have rooted and really sort of softened that whole edge. So it's it looks like a key part of the character is that approach into it and the high quality views you see through the buildings of the landscape to the south in particular.
Well, that's something. Yes, thank you for that. I'll look for when I'm out on site.
Thanks.
I see Councillor Harman, did you? Sorry, Ms. Song.
I was just going to come back on the unsightly and just
briefly,
just make a comment that the landowner knows very well that we have been clearing out a lot of the land and done that by a team of volunteers only fairly recently out of the woodland to the north.
Okay, thank you. Ms. Song.
Just a very brief comment. I think ultimately it's when you're on the ground and looking at the site from the road in Roman Road that you appreciate, because it's been previously mentioned that there's a bit of a dip, and I think as you walk, and it's not a very steep dip, incline, but I think as you approach it from the west and the east, because of the slight dip in the road, you do get a sense of the sort of setting of the conservation area with the open spaces behind, and in particular what with the topography and the slightly higher land levels in relation to of the site in relation to the conservation area. I think that's where this idea that there would be this sense of enclosure within that conservation area that has been the concern, and I think that's really something that you'll only really appreciate and see when you're on the ground.
Thank you. Yes, well, obviously I will look at that. Before I come back to the appellants, Ms. Song, you had the stage for Mr. Chaplin. Has the council any comments on the conclusion of the appellant's heritage impact assessment, particularly that I picked out from the assessment that says no direct views into the application site from public highways within the conservation area, but there's been a lot of talk about views between gaps between buildings. So I'll go back to the appellant and ask them to explain that in just a moment. But since you had the floor, Ms. Song, do you have anything to comment on that? I mean, on the conclusions of the heritage impact assessment generally as well?
Well, I think we have indicated in various reports that there are some views into the site, and I think that notwithstanding the fact that there is a topographical difference in level, I at the moment the views through are open, notwithstanding the various built form that forms part of the actual conservation area itself and is associated with those dwellings. The development will considerably alter that relationship and that aspect, and I think that's where we consider that those views are still important. We also have the views from the conservation area itself, from the buildings themselves into the site, as well as the views from the public footpath. So I don't necessarily agree that there are no views. I think there are quite a lot of views actually of the setting, both from internally within the conservation area outwards, and also from the public footpath and the field into the conservation area. So I wouldn't necessarily agree with that conclusion.
Okay, thank you. Mr. Chaplin, did you have anything to add to that before I ask Mr. Allen or Ms. Hawkes to respond?
Yes, thank you, sir. Yeah, I think Alden's completely right. There are several points along Roman Road where you can glimpse northwards and several points where you can glimpse southwards of the landscape and the setting. It's quite interesting as you come up Frith Road where it meets Roman Road, there's quite a constrained where the terrace of housing sits, terrace of cottages, there's quite a constrained view there, and that enclosure and that sense of enclosure is really strong, and that's a key part of its character. But then as you move away, as you go up Roman Road in both directions, east and west, the gaps become more noticeable and the gaps become more obvious, and it's that interesting blend of the two, of the constraint elements in the centre, and then it becomes more spacious and the more gaps become more obvious between buildings as you move further away from that centre of the conservation area. And that's reflective of how the conservation area has slowly grown organically over a number of years.
Okay, thank you. Ms. Hawkes, Mr. Allen, wish to respond?
Yes, it's the conservation area includes the houses that lie north and adjacent to Roman Road. When I say that, well, when we came to the conclusion there were no views, we obviously walked around. You can certainly glimpse through to the field between the gaps between the houses. Whether that amounts to a view, I suppose, is a subjective judgment. But we didn't deem it to be a view. We didn't think that it had any bearing on the impact, the visual impact in terms of the proposed site. You would be able to glimpse either the new development if it were to be built, or indeed the screening trees, saplings and so forth. We're not disputing that. I just don't think it constitutes to significant impact, negative impact on in terms of the visual assessment. I'm pretty sure of that. You know, we walked up and down and decided that was the case.
I'd only add that we talked about earlier on drawing number 211222103, which shows these view corridors, if you like. That's the one. So A and B really is the only gaps really where you get a glimpse of the field. And when we're saying the field, it's sort of the trees and the hedgerows in the distance. It's not an expansive view of the field looking up when you're 3 or 4 meters below the height of the field. And then corridor C really is reinforcing the character and nature of the brow. And in regards to what Mark said, is the view coming back from the footpath, the view of the conservation area is the back of houses, is the back of all of the old houses. And our linear park and the way that we have set the buildings further away and the gardens further away, that linear park is a mirror of the condition of the conservation area. So you have the backs of buildings, the backs of gardens, and those gardens are not going to be bound in close wall fences. They're going to be bound in hedgerows and native tree planting. They'll be soft, they'll be overlooked. And that's a good quality design decision to make sure that those conditions mirror one another and respect one another. And the conservation area also, the corridors C along the footpath, those buildings are pulled back. So as you come along that footpath, the view actually, the expanse of that view opens along the linear path so that actually you can clearly see the backs of all of those buildings just as you do at the moment. So in that regard, we feel like that layout and the way we have done that with the houses really does reinforce that view at the backs of the houses rather than diminish it.
Thank you. Okay, Ms. Song.
Just a very quick point. I think one of the key elements is that we're considering in part the setting of the conservation area, and whilst I appreciate that the development will preserve some view of the back of the dwellings, that setting will be considerably changed and altered by way of not only by way of the fact that one, we've introduced this linear path, but certainly by the bulk and the regularity and density of the development proposed. So whilst the council would appreciate that on one level there is some view left of the conservation area from the north, it's the quality of it's not just the view of it, it's actually the setting of that conservation area which is of concern, and one of the key elements that we consider with regard to this conservation area is the openness. You may not be able to see the physical field behind the conservation area because of the land levels, but there is a sense of openness in terms of the open sky. Now, I'm not suggesting in any way that we have to preserve all open sky, but it's about working out whether the scale and density of this development would preserve that feeling of openness once you had a line of roofs visible at the rear of the conservation area.
Okay, thank you. I get that, that's fine. I understand the points raised. Consequently, if I was to, having visited the site and made my own judgment, conclude that there was harm to the significance of the conservation area, and I concluded that harm is less than substantial, we agreed, aren't we, that I think but I think it's paragraph 202 now of the National Planning Policy Framework, I would need to balance that harm against the public benefits of the proposal. I don't imagine there's any disagreement with that proposition. No, okay, that's fine, thank you. Does the Ms. Hawks or anyone else from your side wish to say anything more about public benefits? You have listed those in your evidence, of course, and you've described them as we've gone through the discussions today, but was there anything else you wanted to say on that?
No, I don't think there is, sir. I think, as you say, we've covered it off today during the discussions, and we've also covered it off thoroughly within our evidence.
Okay, Ms. Song, did you want to, or do you, Mr. Chaplin?
No, thank you.
No, okay, that's very good. Finally, no, sorry, penultimately, in the appellant's, in the council's statement of case, there's a reference to policy ENV 14. It's not cited in the indicated reasons for refusal. Is the council contending that that's a relevant policy for me to consider?
Yes, policy ENV 14 is the policy designed, well, in fact, dedicated to conservation areas in the local plan. I think that was perhaps just an oversight because there are, of course, references to the conservation of heritage assets in policy HOU 5. So normally I would expect to see that in relation to the potential impact on the setting of the conservation area.
Sorry, are you saying the oversight was not including the reason of refusal, or the oversight was including it in the statement of case? Let me get to. Sorry, I'm not trying to catch anybody out here. But
no. I'm sorry. I'm just trying to review as well. Sorry, apologies.
That's right. Let me just say that the policy ENV 14 refers, I think, specifically to development within conservation.
Yes.
So is it applicable to this proposal?
No, sorry. I think that's actually. I think it probably ought to have been ENV 13, but ultimately but ultimately I think it's captured in HOU 5 anyway with regard to the
sorry, it's captured in
impact on the heritage assets.
So it's captured in which one? Sorry.
In criterion E or
Yeah.
D of policy HOU 5.
Yeah, okay, yeah.
We've dealt
yeah.
with the first portion of that policy earlier in relation to the natural environment, but clearly there's also a requirement there to preserve or enhance any heritage assets in the locality.
Okay.
So
Thank
in
you.
essence, ENB 13 would be, in some ways, its inclusion would have been a bit more comprehensive, but it's not necessary in this context.
Okay. I'll come back to that point. Ms. Hawkes, Mr. Allen, any response to that?
Only to point out, sir, that yes, policy M14 is specifically in relation to development or redevelopment within conservation areas. So we wouldn't see that as a particularly relevant in this case, as this is development outside of conservation area. Do take Ms. Song's point that policy EMV 13, it refers to the conservation and enhancement of heritage assets. But I think we've covered it off in terms of the discussion that we've had and in terms of the impact on the setting of conservation area.
Yeah, okay, thank you. Final question then, I think we can perhaps agree on this fairly quickly. As we've established, the conservation area includes 3 listed buildings. Are there any views on the effect of the proposals on the setting of those listed buildings? Now, Ms. Songs, I start with you. Or Mr. Chaplin, I don't mind which.
No, we thought that in terms of the setting of the listed building, that there was sufficient distance such that it wouldn't adversely harm those particular heritage assets. The objection and the concerns raised were specific to those of the conservation area.
Okay, thank you. Ms. Hawkes, Mr. Allen.
Can I just mention that there is one potential heritage issue, and that is that the very southernmost strip of the proposed development area does fall within an area of archaeological potential. Yeah. That's the area that runs either side for a short span of Roman road. We didn't think that the potential was high enough to warrant any further work, and it contributed to our judgment that the potential was sufficiently low to warrant either just a watching brief or an evaluation if the development were to go ahead.
Okay, thank you. Any further comments on heritage issues, conservation here particularly? No. Okay, lovely, thank you. The next couple of issues I had were obviously written before I'd seen the section 106, and given the sort of by the time it got to me, let's say first thing this morning, there didn't seem a lot of point in changing the agenda, and indeed I might not have to. So the next item is whether the proposals make adequate provision for infrastructure, including affordable housing, on the assumption that if I accept section 106, Ms. Song, is the council satisfied that proposals make sufficient provision, or is this something that we need to discuss when we discuss the section 106?
No, the quantity of affordable housing identified thus far is acceptable.
Okay, thank you. So on the basis of I found the section 106 to be acceptable, will the council be saying, what will the council's view be on that reason for refusal?
It has, that particular element has been negotiated during the course of the time since the appeal was submitted.
Okay, thank you. Similarly, sorry, provision for self or custom build dwellings. Again, can I have the council's view on whether that's been addressed or not?
At this stage, the quantity of self-build plots has been agreed. We don't have any detail as to which of those would be, which of the plots has been identified for self-build as far as I can see, but that can be addressed obviously whilst negotiating the Section 106. We are, however, in terms of the legal agreement, looking at some of the wording in relation to the self-build element, because there is, in terms of how that self-build is managed at the moment, the appellant's version is asking for it to be allowed to be developer-led, and in the council's view, the self-build plots ought to be genuinely self-build. But in terms of the actual quantity, we believe that they have met the requirement.
Right, thank you. Ms Hawkes, do you have anything to say on those two matters, please?
No, so only in terms of the self-build element and the identification of plots. There is, with the Section 106 agreement, a 10-year plan which identifies the affordable housing provision at the moment. As part of that plan, the appellant would be willing to identify the two plots on that plan so that it was clearly linked to Section 106, but clear in terms of which plots could be for self-build or custom build housing. In terms of the wording of that, the self-build, custom build element, Song is right in that that is part of the final negotiations on the Section 106. But obviously we would be keen to ensure that on a development of this size, where you have two plots coming forward, that there is some, there would be some element of being able to have the consistency in approach in terms of the design element. So what we wouldn't be wanting to see is that something is coming forward which doesn't align with the materials and that are being proposed on the main site. So that is an element for discussion really as part of the Section 106 negotiations as to how that is dealt with.
Thank you very much. Thank you. In that case, I'll move on to the fifth main issue I identified, the effect of proposed development on the Stod Marsh designated habitat sites. So I'm watching the time, Ms Song, so I will give you time to relocate.
I apologise. I forgot to mention someone has negotiated with my colleagues, and I don't have to move. So so I am set here, so that's fine. Thank you very much for your consideration.
Okay. Okay. Well, that's good. Thank you. Ms Song, can I ask you, has there been any update to Natural England's advice on Stod Marsh since November 2020? Sorry, I think you had a colleague who was going to deal with these, weren't they? Yeah, Mr. Carter.
Yeah, sorry, sir. I get all the great jobs. The simple answer is no. What I would be setting out is that the significance of the Stod Marsh issue shouldn't be underestimated. Now, to be very clear, I'm not here to represent Natural England. I'm not representing yourself, sir, or anything like that. I'm merely trying to articulate some of the issues and consequences of, since that advice has dropped on the council, how that impacts on decision making, whether that's us being the decision maker or indeed in this context yourself being the decision maker. Now that advice was issued to us, it was reissued in November, but just clarified a few points. And ever since that time, we've had to make sure that development that comes forward can achieve neutrality, nutrient neutrality. It's a term that we've become also familiar with, and indeed other local planning authorities in the Stour catchment have become used to that term as well. Now, that is not betterment. it is neutral. You have to achieve neutrality. Now, essentially, very, very simply in all of this is what the evidence is suggesting to us is that the solution to mitigate phosphates and nitrates, and it's phosphates that's the particular issue for us, which is different to other areas like the Solent. There are two main solutions, if you like. One is wetlands and the other is woodlands. Now, the wetland solution is the solution that the council are proposing themselves in terms of they're looking at land acquisition for a strategic wetland somewhere, and wetlands use up the least amount of land take possible in terms of delivering the phosphorus mitigation that we're required. That's not to say that any other solution might be okay, or that we favour wetlands over woodlands or anything like that. That's not our position, and that's not our case. However, if I just come back to where we are as decision makers, what I expect in terms of what is presented in front of me so I can make a decision, the process is essentially the application comes in, it's supported by evidence as to how they're going to achieve neutrality. We've hired consultants, sir, at our own expense as the council, to deal with the appropriate assessment process. So the evidence comes in from the applicant. We assess that down the appropriate assessment route that we've got these independent consultants to look at. And then after that, and during that process, Natural England comments on that. Now, so if I'm being honest, Natural England don't tend to comment on anything other than an appropriate assessment. And they don't tend to agree with anything that falls out of an appropriate assessment unless it's consistent with their advice. That's what I'm finding through my decision-making process. Now, of course, this context here, what we're talking about, we're not the decision maker as the council. That passes to you as decision maker in terms of how do you assess whether or not this scheme can achieve neutrality? And that's obviously down the route of going down the appropriate assessment to make that assessment and make that judgment. And then hopefully Natural England commenting on that appropriate assessment to steer you and guide you as to whether or not they can achieve neutrality. Now, I'm not here to judge the merits of their case or otherwise. There are a few considerations for me when I get something. One is, what are the planning considerations? So, for example, if by virtue of delivering a wetland, they're not delivering any of their other sports provision or green spaces or informal open space, that might be a planning judgment that I say, well, no, that's a suboptimum scheme. We're not in that context here. So I'm not suggesting I have an issue with woodland creation as part of mitigation. All I would say, sir, is based on the work that I've done so far over the last 15 months and working with Natural England, the wetland that they're proposing is substantially smaller than the wetland, than the minimum amount in the Natural England advice, which says that talks about 2 hectares of wetlands, which is one of the reasons why finding a solution to all of this is very difficult, because wetlands may well be less land hungry than woodlands, but they're still quite land hungry. 2 hectares is quite a substantial area of wetland to mitigate harm on your site, which is why a great number of schemes, sir, in the catchment, in the borough, are caught until there is a strategic solution. And what I mean by that is a strategic wetland, ideally led by the council, that generates credits, and then you can claim against those credits and you can go down the route of granting planning permission once those credits are available. I appreciate it's a very, very quick run through, sir, of all of the issues that we're sort of facing here. But let me just reiterate, I'm not acting on behalf of Natural England or anything like that. I'm not even suggesting for 1 minute that I have a problem with what's being proposed. But I think if I could pass on what I've learned throughout all of this process, I think that's the issue that's in hand at the moment.
Yes, thank you very much, Mr. Carter. Yes, I do have some familiarity with nutrient issues, both at Stod Marsh as it happens, but also in the Solent as well. So yes, I do appreciate the nuances here. I saw a hand raised from the appellants, but because of the way the screens, so that's it. That's the one. Yeah, thanks very much.
I've realised we've been here all day, and I've just realised it's difficult for you to see our arms going up when there's so many of us in the room. So apologies for that. And I just wanted to sort of come back on that neutrality. I mean, we're all aware this came about in the summer of 20, and I very quickly, having known nothing about nitrate neutrality, spent several months understanding it, and I engaged with Water Environmental back in July, August of 2020, as I felt they were the appropriate body who could sort of guide me through it. I have this site in Ashford, I have 2 in Canterbury, and they're all falling under it, so I had to learn very quickly. And what I understand is the Water Environmental are also acting, I believe, also on behalf of Ashford as their advisor. They have done my assessment. We're fortunate that we own this land, and there's pretty much enough land to plant woodland. And the benefit also is that the actual use of the land at the moment is mainly cereal crop, which is one of the biggest factors for creating this issue with nitrate neutrality. So I feel confident that Water Environmental have done their studies correctly and have come up with a solution for our scheme that is sufficient, that gives us that nitrate neutrality. We speak of the size of the wetland. The wetland is actually just a bolt-on because we fell slightly short of the required hectareage. And so that's kind of like our top-up solution to ensure that we create nitrate neutrality. So my trust is in Water Environmental, that they presented this to Natural England, and it's sufficient to not stand in the way of this application.
Okay, thanks, sir. I'm just catching up with the notes. Okay.
Would you like me to come back on some of those points, sir? It's not that I don't have sympathy for the issue here. The fundamental point in all of this, as I see it from what is being presented, is, are the wetlands part of the solution or are they not? And if they are part of the solution, it may well be that some smaller wetlands are technically able to achieve the issue of phosphate and nutrient neutrality. The evidence so far, and this is why Natural England's guidance has suggested 2 hectares, is that it's a little bit more erratic the smaller than 2 hectares you go, which is why the advice sets out 2 hectares. It's not that you cannot achieve neutrality in phosphates or nitrates in wetlands that are smaller, it's just the evidence is not there beyond a reasonable scientific doubt to set out that you should be going below 2 hectares. Now, I know Water Environment, they are helping us with our strategy, and part of their strategy is to try and find on-site solutions to mitigate the harm created here. But the fundamental question for the appropriate assessment to assess in this context, there are some others as well, but the fundamental one is, does the wetland play a role in achieving neutrality? Not almost neutrality, not close to, and let's try and get to neutrality. Does it play a role in achieving neutrality? And if it does, then the wetland is substantially under the amount that the advice is setting out that Natural England will support. So I personally, and it was up to Natural England to come back and comment on this, and like I've said, they don't tend to comment unless there is an appropriate assessment in play. I'm not aware of them supporting any under 2 hectares at this point, and that is what I'm sure you will get back from them, sir, when the appropriate assessment is done and they've concluded. That doesn't stop you making a decision, sir, obviously. That doesn't stop you making a decision. It's just an informed decision. But that is my understanding. The fundamental question is, does the wetland mitigate to achieve neutrality or does it not?
Understood, thank you. Yes, if I'm minded to allow the appeal, then I will need to refer to Natural England and seek their advice. Can I ask Ms Hawkes or your colleagues, have you spoken to Natural England at all, or do you know if Water Environment have spoken to Natural England at all about these proposals?
They did not. I'd have to check that. I know they submitted to Natural England, but Water Environmental put it forward. And you are right there that there's a specific size to wetlands, but this is a hybrid scheme. So this is a bolt-on, and the principle of this scheme is based on the woodlands, and that's where I think there's a variation. So that just need checking, I guess, or clarifying with Natural England.
It is absolutely seen as it's a combined approach. So it is wetland and woodland, and as Mr. Raff has pointed out, Water Environment have been engaged by the council to do their borough-wide strategy, and we know that they have considerable experience of dealing with Natural England in terms of solutions and creating solutions which will be appropriate and will achieve nutrient neutrality.
Okay, I understood. Well, if there's nothing I can look at from Natural England on this particular issue other than the generic advice on nutrient neutrality for Stodmarsh, then so be it. It would be up to me as a competent authority to and consult them and seek their views on anything I try to go forward with. Can I just ask though, the revised plans that with the revised buffer zone, does that show? Do we have a revised plan that shows the enlarged retention pond? That's what I'm just double checking. I know it's reference to the retention pond being enlarged, but is that actually shown in any of the submitted drawings?
Yes, sir. It's shown on the plan 1910/197. So. Yeah.
Okay, that's what I thought, but I thought I'd better check that. So, okay, thank you for that. I'll come back to the wilderness in a moment, but just so I don't lose sight of it. In the council's evidence, there's reference to another appeal at land at the junction of Romney Marsh Road, north of Roman Road, Ashford. Has there been any decision on that you can tell me about, please?
Well, so this is partly to just express where we've got to with some of these things as well, almost for sort of information purposes, if nothing else. That there have been a few schemes that have been refused on Stod Marsh alone, i.e. there's no mitigation that we can rely on and therefore we can't approve it. The one that I was involved most recently is the Stour Park appeal, and that did promote a wetland of 2 hectares to mitigate that scheme. Although it was dismissed on other grounds, primarily on the green corridor. So, of course, the inspector didn't reference anything to do with the appropriateness or otherwise of the mitigation that is being proposed, because he didn't need to, of course, because he was dismissing the appeal. So there's not a lot at the moment in terms of local sort of case law on where Natural England stand in all of this. All I can say, sir, and it was a frustration I had at that appeal as well, is that their position is set out in the advice. Water Environment are doing work for us in terms of the strategy for the council. Now, that, of course, is a strategy, and that is consistent with Natural England's advice. We're not looking at any sites below 2 hectares. But everything I've come across from Natural England that relates to appropriate assessments, whoever the decision maker may be, is it goes back to their advice, and they don't tend to depart from that advice at all. And that's what they then conclude. And that then therefore leaves the decision maker in a situation to say, do we think this can achieve neutrality or not? And the issue there, sir, it's a very black and white issue. You either can achieve neutrality or you can't. And if you can't, then there's the issue over the European law, as you'll be aware of.
Yeah, I think it's reasonable scientific certainty. So there is a little shade of grey, but
there is. So just very briefly on the 2 hectare point, it is. I know we've dealt with it elsewhere, and I'm not an expert on water issues, sir, so please don't think I am. The 2 hectare point is based on scientific evidence at the moment, largely based on work in America, actually, that looked at a certain size of wetlands, and when the size of wetlands goes down, some of them work very well, but some of them don't very well. So that work very well. So it's the consistency of the wetland itself to absorb the nutrients in terms of the size that's needed, whether it's part of another bit of a solution or not. It's actually the function and efficiency of that wetland in of itself that's the main point. And what they're saying is, and our consultants ACOM haven't departed from this advice yet, which is there's no other scientific work yet done. There might be, but there's no other scientific work yet done that says actually the position of 2 hectares at your starting point is a reasonable starting point. If there is, and more evidence can be promoted, and there's wetlands that are less than 2 hectares that are as efficient and as are consistent, then there is that scientific doubt point, which would allow our consultants to start saying, okay, well, we might be able to start allowing for under 2 hectares. So the 2 hectare point has been raised before in other applications and in other schemes. That's where the 2 hectares come from.
Okay, was it Mr. Ralph, did you have your hand up?
Yes, thank you. Yeah, I think with this one, I think, look, none of us are experts in water. We're all based on information and knowledge that we've got. I think the cases that we're referencing this against in Ashford, I would ask a question. I don't need it answered, but were they purely wetlands or were they hybrid with woodlands? The page 15 of the Water Environmental, who both myself and Ashford and other councils are relying on, their conclusion is that the 6.1 hectares of woodland and a small offset of wetland is sufficient. So I have to go with that judgment and leave it with that. So yeah, thank you.
Fine, I'll just say, yes, I think we'll have to go on the evidence we have. If we wanted to pursue that further with sort of technical cross-examination, then first of all, water environmental will obviously be conflicted, it would seem, in the first place. And secondly, we would have to move to an inquiry, which I'm not sure anybody particularly wants. So I'll ask you, Ms. Song, to so we don't say in just a moment, but just to say that I've taken the points on board, I've had the report, and if I'm minded to allow the appeal, then I would do so after consulting Natural England and completing the appropriate assessment. Ms. Song.
Just brief points, really. One is that, of course, Natural England accepts that potentially there are other solutions that are involved, but clearly what they would need is an evidence-based solution, and they would want clear evidence that what is being proposed is appropriate, and so it'll come down to a judgment on whether it is definitely going to mitigate the impact and create a nutrient neutral development. The second thing is going back to your question about the appeal. It was dismissed. And there was very little consideration in the appeal itself as to Stodmarsh, because the inspector concluded that he was refusing on other planning merits basis, so he did not actually conduct the appropriate assessment as part of that appeal.
Okay, thank you. That's understood. Is there a hand?
Sorry, yeah, just one small point. Obviously, it's a little point, but if no one actually builds any of these wetlands or woodlands or mitigation measures, we will never actually have the evidence of whether one works or doesn't work. I'll just suggest that.
Okay. Good. Okay, thank you. I do have a couple more questions on this issue, I'm afraid. On the point of the new woodland being provided, I think the nutrient assessment says 6.1 hectares of new woodland. It's been put to me by an interested party that actually 1 hectare of that is already woodland, and therefore the actual new woodland is only 5.1 hectares. Ms. Hawkes and team, do you have any comment on that?
So on the plan that we've submitted to you that shows the extent of woodland, it does refer in the orange patch area to the figure including an area of existing woodland. That it doesn't measure 1 hectare though, but there is an element of existing woodland within it. That is one of the reasons why we have the hybrid scheme with the wetland as well, to compensate for that.
Okay, so still maintain that overall your position is that based on the conclusions of water environmental, that's adequate mitigation.
Yeah, correct.
It struck me that if okay, maybe not 1 hectare, but if part of the woodland already existing, would that have been deducted from the arable land being taken out of production? But anyway, that doesn't matter. We get to the same conclusion at the end, is that the position is to set out water environmental report that, as far as you're concerned, it's adequate mitigation through the kind of hybrid scheme. Notwithstanding Mr. Carter's point about the smaller size of the wetland area. Okay, I think that encapsulates that. What I am curious about, what I do want to pursue, and we will come on to section 106 shortly. Can I ask why the council considers that mitigation should be secured through section 106 rather than through unilateral undertaking?
Yes. I think it's just the complexity of the agreement. This this is not a case of a simple financial contribution, whereas some councils may have a strategic solution in place which generates tariffs which the developer would undertake to contribute as part of the development. We have a situation here where it's a private mitigation measure, and in order to secure the long-term management, because the mitigation would be expected to be in perpetuity, which would be at least 125 years, depending on who you speak to, but in essence, the duration of the development, the life of the development. And with regard to the Section 106, a unilateral undertaking would only bind the owner of the site at present, but we would need to bind the land in order to secure the long-term mitigation measures. And indeed potentially any management structure put in place and their successors in title to ensure the long-term effects of the woodland and wetland are maintained and protected and secured. So it's really just simply for that reason. We would also normally expect it to be a separate Section 106. Purely because of the nature of the various clauses and covenants that need to be applied. It would probably make the existing main Section 106, which deals with affordable housing, which already has quite a lot of sections in and of itself, rather complicated. So it's really for that reason that we consider that the Section 106 is more appropriate. And I think when you look at the UU that has been put forward, you know, that it doesn't go really far enough with regard to the measures that we would expect to secure the mitigation. It certainly sets out that the woodlands would be planted and that there would be some management, but we need it to go a bit further with regard, or we would expect if we were doing the appropriate assessment and looking at the Section 106, because it's not just about what they're aim to provide and seek to provide, it's the full package. And so as part of the appropriate assessment, we will be looking at the legal agreement and whether it actually does what we need it to do in order to overcome this issue. And certainly at the moment with the UU, you know, I would set out that it probably needs to be a Section 106, but also I think that the provisions within the UU are perhaps something that would need further attention if we were the competent authority looking at this.
Thank you, that's very helpful. Ms. Hawkes and practical legal advisors, you have any response to that?
Yeah, if I can kick off, sir, but then I will bring in Laura and Louise. We have at present presented it in terms of a UU, a draft UU, and also in terms of a additional schedule within Section 106. The appellant really doesn't mind how it is dealt with, whether or not it is dealt with as a separate UU or whether it is part of the Section 106 agreement. But clearly it is important that it is secured, and also the management of the woodland is secured as part of that. There is a potential solution here in terms of if it is part of the Section 106, then it would bring it in as under the management of the other areas of open space that we have. But alternatively, it could be dealt with as a separate UU, and we could make sure that there are additional provisions in there with regards to management. I'll leave Laura and Louise to respond as to whether or not it is appropriate to have it as a separate Section 106, but certainly we feel that as the appellant has gone a long way to presenting it in terms of how it can be delivered as part of either Section 106 or as part of a separate UU.
Okay, thank you.
if it would be helpful, sir, just to add to that. As Emma has very helpfully just set out, like say we have got the 106 UU, which is a standalone document just with the woodland land mitigation obligation in it at the moment. My view personally is that a UU is sufficient, and a UU still binds the land and runs with the land. So it would still be sufficient, in my view, for those obligations to be secured by way of UU. The issue that we have got is that we haven't had any input at all from the council on that UU as of yet. The first time we were made aware that this potentially needs to go into agreement was via the statement of common ground on the 5th of March that was going between the parties. So we, as Emma has said, as the appellant, are happy for it to either go into the UU or the agreement. Drafted that schedule basically into both documents, and are just waiting for the council to confirm how they would like to proceed on that basis, and if any drafting amendments are required in that respect.
Okay, Ms. Song.
I think this is a slight chicken and egg problem with regard to the UU and the legal agreement with Stodmarsh, because if, as the competent authority, if we were making this decision, we would be carrying out the appropriate assessment, and part of that appropriate assessment process would include the examination and review of any legal agreements put forward by the appellant, or in that case the applicant, and whether or not it is adequate to secure the mitigation. Because, as I say, it's about the package rather than just the planting or the setting up of the woodlands. In this instance, we are not the competent authority, and therefore there's very little for us to be able at this stage to sort of negotiate, because it's down to looking at the agreement in combination with the proposal, and that consideration has been taken out of our hands by virtue of this appeal, and the information that has and there was never really a point at which we were ever in that role with regard to this application. Perhaps at the time of I mean that's not true. We obviously refused on the basis that there was insufficient information, but the information wasn't there at any point during which we had the ability to determine the application, and so we've never really reviewed it. But so at this point we present the concerns in relation to what we've seen, because it's there in the appeal, and the documents have been submitted, but they have been submitted to you. So it's difficult for us as the local planning authority to negotiate these measures when we don't know ultimately what the assessment of the technical aspect is going to be. So in the absence of that input and that evidence and that determination, it is very difficult for us as an authority to agree terms, because they may not be relevant by the time you carry out the appropriate assessment, and so we're really not able to comment beyond the sort of generic heading of what type of agreement we would expect and what type of headings and clauses we would hope to see in the agreement. But beyond that, unfortunately I have to pass the baton to yourself and to the Planning Inspectorate as the competent authority.
Understood. I mean, I'm in the position that it's for the appellant to put forward a robust case, including adequate mitigation for any potential likely significant effects, or any likely significant effects, forget potential, on a designated habitat site. So it's not for me to kind of negotiate between the parties and Natural England and try and sort that out. I deal with what's put before me. If there's a chance of, obviously we've heard from the appellant that they're acting in good faith on the advice they've received from their consultants. So if they're satisfied with that approach, then I would suggest it's for them to put that forward in whatever form they think appropriate, and then I can take into account the council's concerns on that, and perhaps with Natural England's advice, make a decision on it. Now, whether the appellant wishes to discuss that further with the council, I suppose on a without prejudice basis, on the basis of the good, the advice they've got from their consultants. So the council would be acting with a caveat, well, you're not sure if that's actually going to be adequate or not. The issue would be that for me to determine that on advice from Natural England and based on the evidence I've got before me, and then if I find that it is, I would need that mechanism before me in order to ensure that the management and provision was all up together. So that's the position I'm in. I don't think it's really for me to decide the way forward. I think the ball, I'm afraid, is really in the appellant's court on this to put forward the case that they want to, or maybe they feel that they've done that, and go from there. So, Ms. Swindles, did you want to come back on that?
I think it's just to reiterate the point that the drafting has been offered to cover the point off in the UU for consideration, and additionally that drafting has been added to the agreement so that there was flexibility there in terms of how that mitigation is secured. And I think ultimately there just needs to be consideration and some, like say, maybe potentially further consideration as to and discussions between the council, as you've suggested, so just in terms of the best way to potentially do that. But ultimately the appellant is happy either way for that to go in the UU or the agreement itself.
Okay, thank you. Ms. Song, was that a no, you don't have to.
It's a I'm pondering.
Okay,
really.
it's a pondering gesture.
I think I appreciate that this is an unusual situation, perhaps, and most ideally we would have had at least we would have conducted, as the local planning authority, some assessment of the scheme before it came to you, but obviously due to the evolution of this matter that hasn't been possible. But as I say, ultimately it is down to the appellant to put forward a scheme, and that scheme is a package, and if you are satisfied that the legal agreement and the mitigation measures are suitable and appropriate, having had conversations, evaluated the evidence, and having had some response back from Natural England, then certainly it would come down to the council to negotiate those specific terms. But certainly without having been in a position to look at the technical aspects, there is quite a lot of work to be done in my opinion, in relation to the legal agreement. I don't think that what's put forward there presents a long-term strategy and solution that would be suitable with regard to the level of management that we and Natural England would expect. And so that therein lies my concern, and this is why it's a bit of a chicken egg, because as we negotiate the legal agreement in order to obtain some of those aspects, that constantly informs your appropriate assessment process. So it's trying to work out how to manage that within the context of an appeal situation, because I don't know to what extent you can allow that kind of negotiation to carry on following the closure of the hearing and dealing with and morphing that solution, because during that period your appropriate assessment is just effectively delayed and can't be concluded, and so this is the sort of procedural issue in my mind, and obviously I don't have a lot of experience on this element, so I would have to but I just raised the issue for your consideration, and it is not an easy one to get one's head around in terms of this matter, because and that's the reason why the council thus far has made sort of overarching and general comments about the proposal put forward, but not actually looked at sort of engaged in detail, because everything we do then affects everything that you have to do thereafter.
Understood. Mr. Ralph, I saw you put your hand up.
Yeah, thank you, sir. I just want clarification there. So we're discussing specifically the 106 or the wording within the 106 relating to the Stobmarsh nitrate neutrality.
The question naturally was, why did the council feel it needed to be a 106 rather than a unilateral undertaking, which my song has answered, and why not part of the main 106, which again has been answered. While we're on the subject, what I don't think I can do, what I do know I need to have before me is, if it's a section 106, I's dotted, T's crossed, signed, dated, all up together, in order for me to be confident, assuming that the mitigation measures are adequate, that they can be delivered. If I don't have that, then I can't be certain, even if the mitigation measures as a package do work, that they will be delivered and managed in perpetuity. So I can't, sorry, I'll come back to, I know there's hands going up, I'll come back to you. So while I'm on a roll, I can't come back and sort of say, well, give me something and I'll have a look at it and think, oh, you're on the right lines. I'll allow the, it's on the assumption I allow the appeal, go away and sort it out. It won't work like that. I need to be satisfied as the competent authority up front. Now, it's your jobs, if you like, to put the evidence to me and the reasons why you think it does or doesn't work. And for me, with the advice of Natural England, to take that view. What I can do is, even if I close the hearing, I can allow a short period of time for a section 106 or however you want to go forward to be sorted out and sent to me. What I do need is it up together and agreed, or at least the position of the parties agreed at that time. There won't be any kind of extensions of time, and after that I'll go ahead and start writing my decision. So anyway, sorry, Mr. Ralph and then Mr. Carter.
Yeah, thank you, sir. Okay, I mean it's a good point. My understanding, and Laura, if you could confirm it, is actually we're at the end of that negotiation now. Unfortunately for us, Ashford and their solicitor have been very late in providing information and making negotiation very difficult. But in the last sort of, I'd say 48 hours, we're at that final throw of just probably 2 small points which are to be agreed. The principle has been agreed, it's just to find the detail. So I would imagine it wouldn't take more than a week to finalise the 106 from both sides. Laura, would you agree with that?
In terms of the 106 itself, just taking the nutrient neutrality point out, I understand that the only 2 points that we've got left are the open space provision to agree, and the indoor sports facility. We are just waiting for some information on the council, and then there just needs to be a discussion that was referred to earlier about plot numbers being referred to with reference to the 10-year plan in terms of the affordable. Those are the only 3 outstanding points, otherwise the section 106 is agreed in principle. The open space provision itself, again, this would previously agreed drafting, but we'd received a redraft recently from the council where the provisions are slightly more onerous. It's only the triggers that the appellant just has some concern with in terms of negotiating and finalising those triggers, because previously agreed drafting has been changed. otherwise everything itself in the 106 is agreed, subject to those minor points being finalised.
Yeah, so we are close to being there with it.
So that was the main 106 excluding nutrients. Yeah.
Yes, correct.
So what would be? I'll come back to Mr. Carter and Ms. Song in a moment. Did you want to suggest, if we go down this route?
So with regards to the unilateral notice, the nitrate neutrality, as I understand, recently a Kent-based developer had a scheme approved in Ashford with Water Environmental doing the study, and they submitted to Natural England. And fortunately for me, that my solicitors have recently, I believe, have signed off a UU for him with Ashford solicitors, and we've just adopted that principle into our UU. Laura, would that be correct?
Yes, so I was just going to come back to the UU because having just revisited, there are provisions in there in terms of delivery and management in perpetuity. So I think what needs to happen, because we haven't had any comments from the council on the UU. I think the appellant isn't actually certain whether that UU has been agreed, but my understanding from my predecessor colleague is that this UU was based on a draft used for another scheme, so it was kind of previously agreed wording.
Is that agreed with Ashford and their solicitor who you're dealing with now?
It was with the solicitor who we're dealing with. Louise, was it with the same council, do we know?
It was with the same solicitor. I will just double check that it was with the same council. We can double check
if it's the same council. But yes, that's additionally a point with the UU in that it has got provisions in there that the council are raising concerns about. There is quite an element of detail in there, I would say, and I think that just needs to be reviewed properly by the council solicitor and formal comments provided to us on it, because we've not received anything to date.
No, but Laura, fundamentally, we're using a tried and tested and approved, almost copy and paste, yeah, of a site in Ashford with Ashford solicitor, and you being the solicitor that also acted for that other client, yeah?
Correct.
Yeah, okay.
Okay, Mr. Carter. Sorry.
Yeah, I don't want to say the obvious, obviously, but it's all very difficult to do in the abstract of an appropriate assessment that does look at the management and maintenance regime as part of the assessment. And indeed, we've had our consultants look at various schemes coming forward and have raised issues over how we're going to get to the sort of 80 to 125 year timeline to make sure whatever is put in on the site works and is monitored and is being delivered in the way that it is. And here you've got the issue of it both being woodlands and wetlands, making sure that wetland is built in accordance with X and is growing whatever it needs to grow in order to carry that nutrient load, etc., etc. So the scheme that's being referred to is a large scheme on the edge of Ashford that has got planning permission now, that had an appropriate assessment in tandem with it, was one of our largest site allocations in the local plan, and is delivering an on-site strategic wetland as a means of providing its mitigation. That enabled us to provide the detail that was necessary, both from you've passed the appropriate assessment test because we've got enough to guide us that think we can do this, to actually signing whatever agreement was signed off at the end of the day. So some of this is, I understand the frustrations in some of all of this. I get it, totally get it. But that's some of the consequences of what we're dealing with here, and certainly in the absence of an appropriate assessment to guide us, and partly on the how we're going to manage and maintain this over time to be certain that you pass that legal test. That's some of the difficulties that we're facing.
Okay, so I will come to you, I promise. But on that strategic scheme at Ashford, there must have been some management maintenance arrangement for perpetuity. I don't need to go into the details of that, but presumably the council was satisfied that it worked on that site. And although we're dealing presumably with a smaller scheme here,
yeah,
in principle, I don't follow necessarily why the management principles wouldn't wouldn't still be applicable. Anyway, Ms. Song.
With regard, well, I'll deal with the first point actually, which was the point made by Ms. Swindles. I must admit, my understanding is that the council solicitor is working with them on another site, but from the conversations I had with them, I must advise that I'll have to double check with our solicitor, because that's not my understanding in terms of what arrangements were in place. So certainly I will double check and come back to you with regard to if you need me to, in relation to whether or not there is an agreed UU or section 106 for an alternative site, because the council's solicitor's position when I've discussed this with her has always been that it ought to be a section 106. So I'm a little bit surprised by the comment. But in terms of the time frame for negotiating a section 106, setting aside the main 106 with all the various schedules, in my experience in dealing with section 106 is in relation to protection of special protection areas and Natural England and appropriate assessments. Natural England would be part of that discussion in relation to the overall management. So, for example, they have a list of approved management sort of not organizations, and in terms, certainly in terms, not, I don't really know whether they have one yet with respect to nutrient neutrality matters, but I do know that they have such organizations in place when it comes to looking at some of the other environmental mitigation measures put forward from the HRA regulations, like in terms of signs, for example. So it would not be an unusual process to consult Natural England on the and this is why this is very difficult for us as an authority to negotiate the section 106 without the appropriate assessment, because Natural England would comment on the appropriateness of the mitigation measures, or I would expect them to, and as a result of that, those comments, we would be expected to negotiate the changes if appropriate changes could be identified. But in this instance, there is an absence of that information. We don't have their viewpoint as to whether or not we have done enough to secure the measures. So I think it would be difficult to estimate the time frame for agreeing the section 106. We could agree some sort of structure and template, but how that, you know, but that would still need to go to Natural England for comment, or that has been the procedure I've worked under in other authorities, because as I say, it is a package, and Natural England would want to see the entire package.
Yes, certainly in carrying out my appropriate assessment, I would want to consult Natural England on the details of the mitigation measures and how those would be secured. In fact, you know, I couldn't undertake conclude on my appropriate assessment positively unless I had those details and I was satisfied that they were adequate. Without them, I couldn't conclude with any certainty that there wouldn't be any adverse or any likely significant effects, and they would be adverse on the integrity of the sites. Yes, I do understand the council's issue and difficulty of putting your name to a document that purports to or would secure something that you are not, as a council, confident would be sufficient. So I do get that. So again, I think the ball rests again in the appellant's court. Councillor Harman, did you wish to contribute?
Yes, so I've listened very intensely to this debate, and obviously it's a hugely complex subject, and I'm not even remotely qualified to comment on the nutrient neutrality, but I would like to comment on the necessity, well, the two things. One, the site that was being referred to, that has been agreed by the same solicitor with a legal agreement for nutrient neutrality, I think I'm correct in saying, is mostly based on wetland and not woodland. And I must say that I'm concerned as a member of the community that will be left to live with this, should it be you be minded to approve, that there's a large amount of ground here that is being proposed to be planted with trees, and trees are actually it's very easy to pop them in the ground and say you've achieved the job, but they actually require an awful lot of looking after. So I think that this agreement for maintenance in perpetuity, not only in terms of meeting the nutrient neutrality, is very important in terms of the landscape and what we're going to be left to live with. That's all, sir.
Okay. I'm not sure we can move this on much further, really. As far as I can see, it's for me to make a decision on the evidence put before me. I'm prepared to allow a limited period of time. I can still officially close hearing, but with a specific request for any further discussion to take place, and the outcome to be submitted to me within a prescribed timescale on this. Or it may be that, having heard what the council has said, it's entirely up to the appellant. In fact, I'm not even going to say what I'm going to say, just in case it's construed as a steer. It's up for the appellant to decide how it wishes to go forward. If it wants to discuss with the council, then perfectly entitled to do so, or try to do so. It's up to the council whether or not they want to discuss. That's not for me. What I want at the end of the day is something before me that at least the appellant says this will do the job. If the council has concerns with that, that's perfectly valid. Then I'll take those into account and move forward from that. But I can't sort of leave it open-ended. So can I just have a kind of concluding comment on this? Particularly the Stodmarsh issue from the appellant side. Do you need some time to have a quick discussion on this outside of my hearing, or outside, my sight and vision, or are you happy to express a view now how you wish to go forward?
Sorry, Sam, let me just. That's okay.
That's fine.
Apologies, sir. A bit of a tech issue there. I think suffice to say that we will discuss the matter further with Knights, and we will with Laura and with Louise, and we will revert back to the council with our suggested way forward in terms of dealing with the mitigation as part of either Section 106 or the UU. But I'd also like to say, just in terms of a conclusion, in terms of the information that we have provided to you as the determining authority, obviously we've got the water environment report, and we have the plan showing the woodland and the wetland area, and we will also have within a short period of time something for you in terms of the legal mechanism for securing that. So in our view, you have what you require to carry out an appropriate assessment with Natural England, and we will continue outside of the hearing in terms of the negotiations on the Section 106 and UU. Sorry,
so just to be clear, you're saying that your position is I'll have enough information from Water Environmental and the UU put to me already to make an appropriate assessment, but you want to discuss the Section 106 further with the council for the other issues?
Yes.
Okay. I will look at the section 106 for the main issues otherwise. But I'm happy to proceed on that basis, that Stodmarsh issue is now entirely with me and with Natural England to proceed. I've got the concerns of the council, I understand those. Ms. Song, Mr. Carter, if I proceed on that basis, do you feel that that would be appropriate, or?
Yes, sir. I think that is where we are at, and that's certainly the sort of approach we've adopted for other schemes. But again, just to reiterate, I'm not speaking on Natural England's behalf here. It's merely that
I'm not,
this is what has been happening, not just on this site, on others, and it is a consequence of the situation we find ourselves in.
Right. Okay, so I'll proceed on the basis of the information I have before me, including the opponent's UU and the water environmental report. I've got concerns of the council on the other hand. It's for me to make an appropriate assessment based on those, and consult Natural England and proceed from there. And obviously, if there's any response from Natural England, that would be copied into the parties and a necessary opportunity given for views to be taken. Right, so I think we've finished with Stodmarsh for the moment. Well, finished with Stodmarsh. I'm not intending to go back to it. Does anybody need a break for the moment, or do you wish to carry on? Carry on? Okay, yep. Okay, all right, yep, carry on then. I'm just looking for the statement of common ground amongst these papers. I'm moving on now to what I have as other matters. So I'll come on to planning conditions and section 106 in just a moment, if there's more to be said on that. In terms of the other matters, housing land supply, I see that position is now confirmed in this statement of common ground. So it's confirmed that the council has a slight shortfall in its 5-year housing land supply. I understand that there are difficulties with the Stodmarsh issue going forward, but is the council seeking to address this shortfall in the near future, or what's the sort of direction of travel on that?
Well, sir, you're right. The Stodmarsh issue certainly doesn't help. I'll go that far. Covers a large proportion of our borough, which has been identified in our local plan as being the most sustainable location for the majority of housing growth moving forward. So, in terms of the importance of the issue, we get it, and we are seeking to rectify the position. One of the strands of that, sir, and there are a few different strands to try and deal with the sort of Stodmarsh issue. One of the strands of that is a land acquisition strategy looking at acquiring land to deliver strategic wetlands, and that may be a series of small wetlands, it may be medium size, it may be one large one, and we're in active negotiations at the moment with various landowners to look to deliver a wetland. And once that wetland obviously was granted planning permission, assuming it did get planning permission, we would be in a position to generate nitrate and phosphate credits, because it's not just the nitrate issue we need to deal with, it's the phosphate issue we need to deal with as well. And assuming all of those things go according to plan, sir, we'll be in a position where we can start attributing credits to those planning applications that are caught by the advice, so they can secure neutrality. Up to that point, we are resolving to grant planning permissions subject to finding a Stodmarsh solution. So we are, if you like, doing all we can, and that's what we're actively responding to at the moment. And the only other thing I would point out, sir, and I know it's probably been said before, is that let's not forget that we had an adopted plan in 2018, and this issue and this advice was dropped on us after our plan. So we've not had an opportunity yet to lead a response through the plan-led system, and it is a significant issue for us to deal with. So we are, I think, doing as much as we can to rectify that position and deal with the shortfall, as you've alluded to. And we're confident that we will be able to find a solution, certainly the short to medium term, And then if a longer term solution is needed that's more strategic, then obviously the local plan has some time to catch up, because we'll have some ability to generate credits.
Do you have a timescale for this land acquisition?
I do. So if you just bear with me, I'm having some slight technical difficulty, because I asked a colleague to send that through today, and they have done, and I'm just struggling to find it. It is in our 5-year land supply position statement, which is the
okay?
latest.
That's fine.
Yes,
okay.
But I will endeavour to. Apologies. I will endeavour to actually.
Sorry, I should have double checked that. I just kind of thought of that and then thought, yes, it's probably in there. I can look at the housing land supply statement. I've got a copy of that.
Okay, it's basically land acquisition early part of this year, progression of a planning application, and then looking at, once you've got the planning application, the detail for a wetland, there's some certainty. Looking at AAs, there's some certainty. You can start granting permission for schemes that are caught by Stod Marsh. They'll need an occupation restriction on them though, until that wetland is established enough to actually mop up the nitrates and phosphates. That's about 2 summers. So that's roughly what you're looking at.
Okay, thank you. Ms Hawkes, do you wish to say anything at this juncture?
I think the only thing I wish to say at this juncture, sir, is just in terms of there are sites that could come forward that can address the Stod Marsh issue, and this is one of those sites. So the appeal site is a site which can consume its own smoke, as it were, in relation to the Stod Marsh issue, and therefore would be able to deliver affordable housing and market housing, much needed housing, to help the Borough Council boost its housing land supply when a lot of the district is very much constrained, and there are sites that can't come forward until the borough-wide strategy is in place, and it looks like that strategy won't be in place for a considerable amount of time yet.
Right, okay, thank you. Any further comments on that? I do just need to check one thing. What's that one? Sorry, within just a moment, let me just pull up this. Right, okay, that coming up. Right, okay. Sorry, forgive me, I'm just. I did have another other matter. I noticed that in the ecological survey report from the appellant dated January 2018, there is reference to the site being with the impact risk zone of the Dungeness designated habitat sites. Are there any implications for these designated sites on the proposed development? Maybe I turn to Ms Hawkes first.
Yes, sir. In the report, I'm assuming you're referring to, or I will refer you to paragraph 4.3 in the report that talks about impact risk zones.
Yeah.
But it also refers to the standing advice from Natural England for developments within the impact risk zone, which relates to developments including airports, helipads and other aviation proposals, or developments which may significantly affect air quality, such as incinerators, landfill and wastewater treatment works. It is therefore not considered that a residential development of the type proposed will have a negative impact on the nearby designated sites, and Natural England does not need to be informed. So that's sort of taken directly from the ecological report.
Okay. Ms Song, do you have any comments on this?
No. In short, Natural England have been consulted. They have seen the ecological report, as have KCC Biodiversity, and we haven't had any adverse comments in relation to this particular matter.
Okay, thank you. Okay, that's helpful. Okay, what I was looking for, but I didn't want to close that. I just wanted to double check the maybe it's the unilateral undertaking was all signed, and here we go. I think that's it. That's what I'm looking for. Sorry, let me just call this up. I seem to have some technical problems now. Nothing seems to be opening. No. Okay. Can I ask the appellant then, the unilateral undertaking provided to me in respect to Stop Marsh and was then possibly Schedule 18 in the Section 106, was that completed? Sorry, I should be checking this, but I can't open it at the moment.
No, that hasn't been completed, sir. I can confirm that.
Right.
It is in draft form, just simply because, like I say, we were trying to get comments from the council on it. So the unilateral undertaking is in draft form, as is the Section 106 agreement.
Okay. I'm not sure we developed a timescale for clearly, unless I have a completed unilateral undertaking before me, I'm not going to be able to give much weight to it, if any. So again, that's something that I'm prepared to allow a short period of time after the hearing's closed for that to be submitted to me. But I'll come back to that. Let me just make sure I do. You're right. Okay, I'll deal with that just before I deal with my closing statement. Right, thank you. We've dealt with the Dungeness sites. Right, if we go through planning conditions now, actually the 106, which I had opened, then closed, and now can't open again now. I wanted the council to explain its concerns with the here we go. That's what I wanted. Right. So maybe, open that as well. Yes, if the council could take me through the 106 and explain its concerns, if you feel that's not been covered already. I know there's concerns about open space and sport. Are these matters, that's what I'm looking for, again, that can be addressed, giving a little bit more time? I think Mr. Ralph suggested it could be done in about 5 days, and I think Miss Winders might have gulped to that point, but I don't say that she couldn't do it. So again, it's something I'm prepared to allow some extra time after close of the hearing in accordance with a specific timetable to be sorted out. So Ms. Song, can you kind of give me an indication of whether the concerns the council has are kind of fundamental, or are they matters that could be, do you think, potentially resolved giving a few extra days?
Well, I'm not the solicitor, and unfortunately I don't have the council solicitor here with me. So I can just express what I understand to be the situation. I think that there are a few elements where it's just about a clarification of details on our part. There are a couple elements where we need some responses from the appellant in relation to identification of certain aspects, and one of those, for example, would be so we would, for example, need to identify the indoor sports facility towards which their contributions would be going. They need to come back and provide us with a plan showing which houses will meet the M42 standard in accordance with our policy. We haven't had that plan yet. So these are matters, I think, that are relatively straightforward. It's an information gathering exercise, and we can get them get those pieces of information sent through. There are some matters which are more complicated as far as I'm understanding it, and that really is down to the open space provision. The appellant has mentioned that there was a change in the document. From my discussions with the solicitor, that was based on the fact that she has incorporated, I think the document originally was generated by Knights, and what our solicitor attempted to do when reviewing that was to put it in the council standard format and to reflect the council's normal expected terms. As a result of that, there's been some discussion and going back and forth, and we have, in principle, it would appear, agreed most things apart from the wording and the provisions of the open space aspect. Now, Ms. Swindles mentioned what she considered to be some of the outstanding points on that matter. Those are not the points that I understood to be the issue. And so obviously there is some discussion that needs to happen between the solicitors, because I'm hearing different things about what it is that there's disagreement on, and as a result, I can't give you any defined date. I hope that we could agree the schedule within a few days, but I'm not in a position to set out how fundamental the disagreement is in relation to the management functions, the membership of the management committee, and the triggers. Unfortunately, they have been going around for a few days now, or at least a week now, in relation to the wording, and I haven't seen a lot of movement in regard to this particular schedule. So it's down to the solicitors and the two parties to agree those terms. But at this point, there's very little agreement on that schedule, as far as I am aware.
I just add in terms of the position on the open space schedule.
Sorry?
Can I just add in terms of the position on the open space schedule? So it was previously drafted and it was agreed wording with the council, as it was agreed with the previous council solicitor. The new council solicitor took that on, completely redrafted the open space schedule, and some of the triggers that are within that schedule are now more onerous to the appellant. And also, I just wanted to pick up on a point that you raised earlier about there being an objection by the council about residents not being involved in the management company. That wording was in the previous open space schedule and is also in the new one. So again, I think it's just some finalisation discussion more than anything. I personally, they're not major points to resolve. It's just finalising, and we need to know what the council solicitor wants. Because it's just been unclear. We've been pushing back on the basis that we've been provided with no reasoning as to why the wording was changed, and that was ultimately our pushback. But otherwise, it won't take us long to discuss and finalise that with the council. To me, it's not a major point because the provision of open space is secured. It's just some of the mechanisms and the finer detail that needs to be finalised.
Right, so it sounds as though if I was to allow a few extra days, then there's a reasonable chance that I could have a completed and signed, dated section 106 before me.
The point that I was just going to raise as well, sir, in terms of that was in terms of, I would suggest a minimum of 2 weeks, only on the basis of the council solicitor not being here to input, but normally the council will have standard sealing days for the section 106 agreement. We've got 3 parties to sign this document, and we've also got the county council, who are only involved as an approving party because their obligations are provided unilaterally, so they don't need to seal, but they will just need to approve the final version of the document. So I would personally suggest a 2-week minimum just to agree the final amendments and then get the wheels into motion in terms of getting the document signed between the parties. If anybody has got any other input on that timescale at all.
The difficulty I have with that is I'm then on leave for 2 weeks. It's not to say I couldn't start drafting the decision, but clearly wouldn't be able to finalise it. Yes, okay. It is disappointing that this appeal has been around so long, and yet here we are still trying to sort out these details, but so be it. Yes, okay. I'm happy to allow 2 weeks. So that would take us technically until the 22nd of March. When you say 2 weeks, are you that precise, Miss Windles, or
is that 2 weeks? I think 2 weeks from today is fine. The 2 weeks to run from today is fine.
Sorry, I have to say I'm not privy to the workings of our legal team, so it's difficult for me to commit on their behalf. So I noted that Ms. Swindles indicated a minimum of 2 weeks. I'm not familiar with the process, and therefore I'm unable to commit to any timescale on behalf of my colleagues.
No, I fully understand that. I think perhaps the safest option is for me to not close the hearing, but to adjourn it when we finish our discussions today. Allow Ms. Song time to consult with yourselves and the solicitor at Kent County Council, and then come back to me with a timescale between you. So what I'd like to do then is to say, would it be possible to get a response to me by the end of this week on a timescale for finalising the Section 106 agreement? Not the actual, So would that give you sufficient time, Ms. Song, to consult with your solicitor colleague?
Yes,
okay.
It should be, yes.
Right, so can I be absolutely clear then that I would like by 5 p.m. on Friday confirmation from both parties of a timescale for agreeing finalised Section 106 in respect of all matters other than Stodmarsh. Is that absolutely clear?
Or did I just hear that all matters other than Stodmarsh, did you say?
Yes. Yes. I think we've taken Stodmarsh out of this particular equation for the moment. Right, so it's 5 p.m. Friday, 9th, 10th, 11th. Right, for I must warn that I'm not keen to keep this dragging on. I'm sure nobody is, but obviously I'm under my own targets and pressures to determine the appeal as quickly as possible. Equally, I want to get it right, for the sake of a couple of weeks. Then it's important to give that flexibility, but it's not an open-ended offer, so I put it that way, and that if it's clear that progress is not going to be made, then I will proceed to determine the appeal on the basis of the evidence I have. So I just need to make that clear. It's just that, that's the way it works. Okay. Is there any need for us to go through the section 106 then, if it's going to be changed anyway? I think I don't think so from my point of view. I'm happy to move on to conditions unless anybody want to say anything more about the 106.
The only thing we want to say about the 106 is that we are very keen to get this resolved as soon as possible. So we will ensure that when all parties come back to you by 5 PM on Friday, that there is a clear timescale set out, and that we will be looking to resolve it as soon as we possibly can, because it has been dragging on for a considerable amount of time. So we will be looking to engage and get the matters resolved and get the information back to you as soon as we possibly can. But in terms of going through the section 106 agreement at this stage, I don't think that is necessary. So.
Yeah. Okay, that's fine. Can I turn then to conditions? I don't think 5 o'clock is going to be our finish time, but hopefully we'll get through as quickly as we can. We do still seem to have, well, Councillor Harman is sticking with us. Again, for Councillor Harman's benefit, just to reassure you that this doesn't mean, this discussion we're about to have doesn't mean that I've made up my mind. It's completely without prejudice to the council's case, but it is part of the formal process. So, right, I have the revised condition list in front of me. Do you have that to hand? Okay, I shall go through them one by one. I have some comments. Conditions 1 and 2. 2 will need to reflect the amended plans when those are submitted. Something else we need to discuss the timescale for. And then condition 3, external materials submitted to carried out. Stop me if you have any comments as we go through. Condition 4, no external lighting shall be installed until deeds will be submitted to improved and right on local planning authority. Approved lighting shall be installed prior to occupiers' respective dwellings. Does there need to be a retention clause there? I mean, the issue is really to prevent additional lighting, isn't it, rather than necessarily retain what's been approved. But I think it's good practice maybe to put a retention clause on that. Is there any objection to that? No. Right, okay, so let's take that. Right, then boundary details, condition 6. Will I put my writing? Oh yes, okay. I did query if this needed to be a pre-commencement condition. I don't see why it couldn't be at least prior to any works above slab level, or possibly preoccupation, but happy to take views on that. Nobody's got any views on it, so I could make that.
No views on that, so happy for it to be above slab level.
Would the council be satisfied with that?
Sorry, I was just reflecting as to whether there would be any implications on the ecology aspect, but I think we would be fine with that. Yes.
Okay. Well,
so yeah. That's condition 5. Yes.
5. Yeah. Yeah. Okay. Well, I'll check ecology. Yeah. Okay. Right. Then we have a condition removing permitted development rights for other gates, walls, fences, or other means of enclosure. Clearly, the government is not keen on removal of nationally granted permitted development rights, but I can see the reason and rationale behind this. So again, any comments on 6? No, thank you. Right, condition 7, the construction management plan. Again, I think that needs an implementation clause on it, so that the provisions of the construction management plan should be adhered to during the construction period, something like that, just to make sure it's actually undertaken in accordance with the plan.
Yes, I apologise. I think that might have come off when I amended it to include the ecology buffer elements.
Okay, right.
Yeah.
So, okay, thank you. Condition 8, I haven't, well, I did have to go rewording it, but it does seem to me to be sort of repetitious from my reading. Prior to the first occupation, the development details of where designated parking spaces and car parks can be provided electric vehicle charging points shall be submitted to an agreed in writing local planning authority. The charging point, yes, okay. Schemes shall be carried in accordance with approved details, and the charging point shall thereafter be retained. And then it's got no dwelling shall be occupied until facilities for electric vehicle charging for that dwelling have been provided in accordance with details have been submitted to improved and writing local planning authority. So, as drafted, the council's asking for those details that can be submitted twice, I think, or at least the way it's phrased. I think I can make that more concise along the lines of, and I'm not suggesting this is exact wording, but along the lines of, prior to the first occupation of any dwelling in the development hereby permitted, dedicated electrical vehicle charging facilities so they're being provided in accordance with details, so they're being submitted to and approved in writing by the local planning authority. The charging points may be, and then dedicated electrical vehicle charging socket, etc. The charging points will have to be retained in working order in accordance with approved details. I think that sort of pretty much covers it. Okay, happy with that, thank you.
Yes, with also the last sentence there in terms of the maintaining the preservation of the charging points.
Yes, we have a difficulty in that I can't use a condition to secure maintenance, only retention. I can't.
Retention.
Yes, I'm afraid I can't oblige anybody to maintain something through a condition, but I can, because it goes with the land, I can ask for it to be retained.
Okay.
Condition 9, I would say prior to the first occupation of the dwellings hereby permitted rather than the site, parking spaces. Okay. Condition 10, visibility displays shall be provided before first occupation. I'll just reword that for consistency to be prior to the first occupation, dwellings hereby approved. But that's fairly standard, I think. Condition 11, again, just a slight rewording of consistency rather than the scheme, so the dwellings hereby approved. Contaminations, a pre-commencement condition, which I understand the rationale for that. Yeah, just under point C of condition 12, a full copy of the completion report confirming the objectives, methods, results, and conclusions of all remediation work shall be submitted to and approved in writing by the local planning authority. There's no sort of time scale for that or trigger point. So this is all pre-commencement, so presumably this would be pre-commencement as well. But, I wonder if it's, I'll reflect on that, because it's, you know, the condition starts prior to commencement of development to scheme, and then it's got A, B and C. Is it clear that A, B and C are pre-commencement as well? That's my issue. I'll I'll reflect. Yeah. A, B, and C. I do actually wonder if C of condition 12 and condition 13, one's a verification report demonstrating the completion of work set out in the approved strategy. The other is a copy of the completion report, good objective methods, result conclusion. Are those, is that repetitious, or do they need to be separate conditions?
I think they could be combined.
Okay. Yeah. Okay.
I think it's just that there's a verification report and a completion report, and I must admit, I'm not being part of environmental protection. I don't know whether from their perspective they would constitute two separate documents, or whether they are in fact one and the same in terms of their content. So I couldn't say for sure. No, okay. But certainly on reading the as a layperson in relation to these particular matters, and reliant upon my my colleagues, I couldn't say exactly. I can refer back to them and ask them as to whether or not the two are indeed the same report, or whether they are in fact different from a technical standpoint.
Okay, I'll ask for Ms. Hawke's view in just a moment. The other issue is that condition 12 requires prior to commencement of development, condition 13 prior to occupation. So it could be that there are the two stages. Ms. Hawkes, do you have any view on this?
Apologies, sir. I missed the question. Apologies.
Yeah, I can repeat that. It's no problem. We're looking at conditions 12 and 13.
Yeah.
And I was querying whether part C or clause C of condition 12 and condition 13 repeat each other. But I did recognise that condition 12 is pre-commencement and condition 13 is pre-occupation. So I wondered if they were two separate stages.
Yes, I believe they are, and as you have the two separate stages there, then it looks like there are two separate reports as part of the pre-commencement which need to be produced. Okay, well let's think we'll leave it as it is, not least because if the appellant's happy with the pre-commencement condition as worded, then I'm loath to tinker with it too much. Okay, condition 14, piling or other foundation designs shall be not permitted other than, I have no issues with that. Assume nobody else does, so nobody speaking. Condition 15, yes, condition 15 is principles of installation of sustainable drainage schemes are encouraged. No drainage schemes for the infiltration of surface water drainage into the ground permitted other than the express written consent of the local planning authority. And then there's condition 17. Drainage not begin in any phase until a detailed sustainable surface water drainage scheme for the site has been submitted to and approved in writing by local planning authority. On first reading, the two seem to conflict, but I think on second reading, one's quite clear that you do need, condition 17 is that you do need a sustainable surface water drainage scheme to be submitted to and approved in writing by local planning authority and implemented. And condition 15 merely states that there shouldn't be any other scheme without express written consent of the local planning authority. Okay. I'm happy with those two. Any other thoughts? Sorry, I've just had a message pop up. So, are you still going? Okay. If during condition 16, contamination remediation strategy,
Okay. Okay. 17 I've dealt with. 18. Yep. There's. I didn't know. That's fine. I think. I just wonder if it needed to be a pre-commencement condition, but I think preoccupation is fine.
Yes.
Sorry.
Sorry. Yes. Sorry.
Okay. Thank you. Condition 19, refuse. Yep. Right. Condition 20. It's a little bit vague. I found condition 20A. Says all trees to be preserved. Do we know which trees are to be preserved? Sorry, Councillor Harman.
I'd like to ask, so can that be extended to say trees and hedgerows?
We do have a landscape. There is a condition about landscaping particularly. So I think this is specifically about trees. So I think between the two of them, hedgerows are protected, or
yes,
you know, the conditions will allow for that in part of the details of the landscaping scheme.
Okay.
It was, my query really was all trees to be preserved. Is there a plan? It says retain tree or shrub, existing tree or shrub, which is retained according to the approved plans and particulars. So that's on one of the plans, trees to be retained, is it? So
I'm just double checking. Sorry, my system timed out, so it wasn't allowing me to open the relevant file. So I'm just looking at. I think the trees to be retained are identified within the pre-development. What is it called? Sorry, pre-development tree survey and report.
I wonder if that needs to be specified in the condition. Ms. Hawkes, any thoughts?
Yes, the trees to be preserved are shown on a plan within the arboricultural report that was submitted as part of the planning application. So yes, a way of dealing with it would be to include a reference within that part of condition 20A, referring specifically to the arboricultural report.
Because there is a tree protection plan, but I think that although it's listed separately on our system, it was probably an appendix to the original development tree survey report. So
yeah, that's what I thought. But, I haven't had a look. And the other part I took a little exception to is I think the 5th line down, and any approved arboricultural method statement. I know the redevelopment tree survey report includes an arboricultural method statement. Was the council looking for something more than that, or
no?
Shall I say the approved?
Yes.
Okay. Right. Okay. Thank you. Yep. Okay. That's covered that. And dealt with that. Port. Condition 21 refers to paragraphs A and B below. On my copy, those two paragraphs aren't marked, but I assume A is no retained tree or shrub. Shall we cut down uprooted, and B is if any retained tree or shrub is cut down, uprooted or destroyed.
Yes, that's correct. Sorry.
Yeah. No, that's okay. That's fine. Just it seems obvious, but you know, I just want to be sure. And condition 22 is the landscaping scheme, hard and soft landscape works. Details including planting. And then 20, that would include hedgerows. 23 is ecology. Again, this is what rang alarm bells. That says 24 actually. So 23, I'm happy with. Condition 24, the approved schemes to take into account any protected species that be identified on the site. Shouldn't really be leaving, certainly not any survey to a condition. This is why I asked for the protected species survey report. I put I don't know. I'm not sure how I can deal with that precisely. I need to see the protected survey, protected species survey report. But perhaps leave that with me. These are pre-commencement conditions, so I would need the appellant's agreement to anything I came up with. Anybody got any comments on my concern or generally about condition 24?
I would say just I realised you haven't seen the survey report, but it has been submitted and consulted upon. We have considered that that the impact on protected species is not an issue which would raise an objection from the perspective of the council. With regard to this particular condition, it's in relation to enhancement rather than mitigation of harm, and I think it was on that basis that we've stressed the point that any enhancements should definitely take into account the potential impact and benefit, one would hope, given that it's an enhancement strategy on the protected species. So it's not there to prevent harm to the protected species, but to ensure that when a strategy comes forward, that it's there to take their long-term survival into account, and anything we can do to assist in that matter.
Thank you, Ms. Song, for that clarification. I wondered if there should be a reference in here to the biodiversity metric to ensure that the results, if you like, from the metric are achieved. Ms. Hawkes, do you have any thought on that?
Don't have any objection to that, sir. Obviously, it was something that we discussed earlier today in terms of securing the biodiversity measures, so that would be a way of dealing with it. Also, to confirm, in terms of the protected species report, I emailed that to you at lunchtime today, so it should come up on your system shortly. I also copied in Ms. Song into the email.
Right, thank you very much. Right, condition 25. Now, this is the scheme for the provision of the ecological buffer and the details thereof. I just wanted to double check that the details certainly set out here don't actually. I understand that other plans need to be amended to conform with the amended plan showing the buffer, but I'm right in thinking that there's no need to amend the amended plan any further in the light of the comments from Kent County Council Ecology, in that their comments related, I think, to the details of the buffer zone rather than its extent shown on the plan. Is that correct, Ms. Song or Ms. Hawkes?
Well, they did express some reservation about the size of the buffer zone and the fact that there was a widening and a thinning at various points. But having discussed it with them, I don't think that's I don't anticipate a change to the boundary of,
Okay.
of the buffer. It would, but it's more about the detail of what happens in the buffer and how we manage that particular space in future.
Right.
Well, both as pre-construction, during construction, and post-construction.
Okay, thank you.
So I don't anticipate any considerable change in relation to the boundary of the residential plots.
Right. Okay. If I'm, yeah, so we don't need to put anything like notwithstanding condition 2 as a preface to this, because it's standalone in its own right, and it just relates to what is shown on the approved plans if they're approved. Okay, that's handy. Thank you. I dealt with that. Those were, unless there are any comments on, sorry, for Councillor Harman, I don't know if you have a copy of the conditions in front of you. No, just to let you know that, sorry, I do forget that. So I was saying condition 25 deals with the details of the ecological buffer. Condition 26 is about providing broadband fibre optic to premises. 27 is the archaeological watching brief. So yes, sorry if you have your hand up.
No, I'm sorry, it's a legacy hand again. It always happens if I use that button.
No, okay, that's fine. That's all I had to say on conditions. Was there anything else that anybody wanted to say on the condition side of things? No. Okay, that's thank you.
I think Councillor Harman, sorry.
Oh, sorry.
I just have one small thing, and that is on the condition 4, I think it was, which related to the dark skies.
Oh yeah.
And just to ask that that does say that there has to be a management plan, and every plan has to be approved. It is very important, this aspect, if this application is approved, but again, because of its position, there is a constant erosion of the dark skies, and obviously no matter how careful you are, more houses means more light, and specifically that people coming in to the village are very apt to install a lot of external lighting, so this needs to be very carefully managed.
Right. Okay, thank you. Understood for the comments. Right, that deals with the conditions. So the next item on the agenda is application for costs. Is anybody making an application for costs? Hawks?
No, sir.
Okay, Ms. Song?
No, sir.
Thank you very much. Right. So the next matter then are the arrangements for the site visit. And as I say, I intend to visit the site tomorrow. I haven't seen the weather forecast, but unless it's snowing heavily, I'm sure I'll be able to attend. I do have some distance to travel, so I was looking for probably site visit starting around 12 o'clock. Now, we discussed at the outset whether or not it should be an accompanied or unaccompanied visit. I really don't mind which. I certainly think I have enough evidence from here, and during the course of discussions, various viewpoints and matters to look at when I'm on site have been pointed out to me. So I'm quite satisfied that I can see what I need to see, and I know what I need to see when I'm out on site. On the other hand, and obviously it can be sometimes a little awkward, sort of walking around a little gaggle of people. But on the other hand, I'm perfectly happy if it wants to be an accompanied site visit, obviously I would need representatives of both the appellant and the council, if that was to be the case. And just a reminder, of course, I'm sure the main parties know, there'll be no discussion of the merits of the case if I actually close the hearing here and now. So any further thoughts on whether we should have an accompanied or unaccompanied site visit, or I should have an unaccompanied site visit?
So we're happy for it to be an unaccompanied site visit. We have a couple of suggested site visit points that we would like you to visit and look at, which we can forward on to you by email, which are clear in terms of the viewpoints which we would like you to pick up, but we are happy for it to be an unaccompanied site visit.
Okay, and Ms Song, you were happy early on, I think, for it to be unaccompanied?
Yes, I don't know if any of my colleagues here have any suggestions for any site visit points, but I think there have been quite a few mentioned over the course of the hearing today. Yeah. And if you need any of those positions clarified, we're more than happy to oblige. But I think you've probably had enough of the detail raised as part of the discussion. Okay,
thank you. Yes, I've identified some places I want to look at myself. I think they've all come up during the course of discussion. Obviously, I don't know what Ms Hawkes will come forward with. Councillor Harman, you said before that you were happy to attend an accompanied site visit, but I think also happy if it was unaccompanied. Is that still your position?
Yes, I think you have had all of the concerns and had the points pointed out to you, places suggested where you should stand. And just to say, if you're travelling a long distance, the Walnut Tree pub is on Roman Road, and at that time of day, we'll certainly be able to look after you for lunch.
I'm more interested in the availability of public toilets, to be honest. This is always
well, they're in the pub. They're in the pub too.
So, yes. Okay. Thank you for that. I'm not sure I can go there now because might seem as favouritism anyway. I believe there's also the like cafes and they're looking at Google Maps. So maybe I'll try that instead. Just to be clear, Councillor Harman, because it's an unaccompanied site visit, that's actually what it means.
Yes, so, I understand.
I don't anticipate being waylaid by the local residents, however strong the depth of their feeling. But I do have to say that if people do approach me, I'll explain who I am, what I'm doing, but I obviously won't discuss the merits of the case, or I will walk away. And if it gets to the point that extremely unlikely being harassed, and I will call the site visit off, simple as that. But I'm sure you've all got other things to be doing, so that's fine then. Can anybody suggest a suitable place for me to actually park, please?
You can park in the road opposite the site. There is a lay-by which during the day tends to be available.
Okay, thank you. That's handy, thank you. I have to ask this as well. Are there any health and safety issues on the site?
No, not that we know of.
No,
probably some sturdy walking boots would be a good idea, or at least waterproof footwear.
Yeah, my boots and walking boots are in the car, so that's fine. That's okay. In that case, then, I'll move to closing. I think what I will do is I will close the hearing here in a moment. We've still got we've got a time scale for confirmation of how long it would take to revise the section 106. So confirmation of that time scale by the end of this week, and then obviously following that will be section 106 coming in, hopefully. The document I've requested you kindly provided. The only other thing was the issue of amended plans. Do you have a timescale for that, Ms Hawkes?
Yes, so we can turn that around by the end of the week. It will probably be sooner than that.
Okay, well, that would be excellent. If you could do that, make sure, please, of course, it's copied to the council.
Of course.
I'm minded to not close at the moment, because I could, if I do, there's going to be issues arising, aren't there? I can see that happening. So I'm adjourning the hearing for now. We will write and let you know when it's formally closed. I would ask that you don't take this as an opportunity to submit any more information or further evidence than we've already agreed will be provided. It may be that I can close the hearing on Friday or first thing Monday morning. So that's formal, and then we'll just deal with the section 106 following. So this then is your final chance to say anything more that you want to. If there's anything you feel, I don't know how many other interested parties may be still with us. Councillor Harman, you've done extremely well to last the course. So is there anything anyone wants to say before we go? For the council?
No, sir. I think there's been quite extensive discussion on all the matters arising at the hearing. I don't think there's anything that I need to add.
Okay, thank you. I'm just going around the ones I can see. Ms Seaman?
No, sir, I don't have anything else to add.
Okay. Councillor Harman?
No, sir. I think I've taken enough of your time. Thank you.
That's absolutely fine. Thank you for your contributions. Mr Chaplin? No. Ms Hawkes and team, any final comments?
No, sir.
No, we're happy. Thank you.
No, sir.
Okay. In that case, can I formally thank you all for your contributions and announce that the hearing is now adjourned, and we will write and confirm when it's formally closed in due course. Thank you very much indeed. So now leave. Thank you.
Thank you.
Thank you, sir.
Thank you.